Fresh matter, my lord.
Fresh matters, please write on top. Fresh matters. and
Tomorrow,
give
my
it-
lord.
Melons.
Tomorrow, my lords.
Bharat, fresh matters will come.
Melon.
Threat of disposition, my lord.
Threat of demolition.
Just one. Write on top fresh matters
Yes, ma'am.
and give it. All fresh matters will definitely come.
Tomorrow, my lord.
Melon.
Lord, tomorrow fresh matter.
Melon, there is a
Disposition, the granted land, and now they are again to fix the date tomorrow to survey it and allot the grant to some other person. Hence,
Tomorrow.
Lords, I'm moving a matter, Lords.
Just wait. Fresh matters you give. Tomorrow it will come.
Melon.
Fresh.
Tomorrow, Lords, but
Fresh matter.
fresh matter.
Sir, fresh matter, sir.
Melon. Threat of demolition. Melon.
Fresh matter
Kindly have
tomorrow.
it tomorrow. Melon. It's not a.
136 3 minutes has to go back.
Demolition.
to 80 minutes.
Yes. Demolition is tomorrow.
My lord.
Old
Not
matter.
any notice that.
Old, just one. Old matters I'm not taking. It will be only after vacation. Only fresh matters you give it. Other matters, if there is any urgency of demolition, eviction, you make a request. Vacating, etc.
They are doing eviction, my lord. They are in the position for the
Put it.
agricultural land.
Athagoli, eviction.
Lords, this
Yeah,
is
without any notice, they are coming to survey for
Fresh matter.
Yes, fresh matter.
Togoli, Nale,
Tomorrow, my lord.
tomorrow.
Lords, fresh matter, my lord. There is
Give
a
it. Give it.
Eviction, my lord. This is the second memo I'm moving, my lords. It's supposed to be listed today, my lord.
Aden nodu manche.
For tomorrow it will be.
Tomorrow.
My lords, one fresh matter, a CHT matter, my lords. Fresh
Pending
matter
matter,
for tomorrow, I'm
136
requesting
136 3 minutes has to go back to 80 minutes.
tomorrow.
After vacation, after vacation.
Malad, one matter for tomorrow, Malad. Staff disposition by, issued by the Tahsildar, Malad. Yesterday I moved the matter, Malad, that are not listed.
Ade manjura check ಮಾಡು. ಯಾಕೆ ಬಂದಿಲ್ಲ ಅಂತ.
My lords, another 79 A and B matter,
Tomorrow.
79 A and B matter, my lords, covered by judgment.
ಕೊಡಿ. Fresh.
Fresh ಅಲ್ಲ, sir.
Fresh ಅಂದ್ರೆ ಬರ್ಲಿ. ನೋಡೋಣ, we have really, it's tight, that's all. Yes.
Melon. One fresh matter for tomorrow.
Give it. Fresh matter tomorrow.
Grant land, my lords. Tomorrow matter.
Fresh.
Fresh matter.
ಕೊಡಿ. Fresh matter.
Fresh matter. Tomorrow.
ಕೊಡಿ.
PMLA matter.
ಹಾ?
PMLA matter.
ಹಾ.
22nd is the next date, my lords. The warrant has been issued. May I request for Thursday, my lords?
ಹಾ.
So in this case, I have filed an impleading application which is not put up with the petition, my lord. So I am already communicated petitioner counsel, I am moving for adjournment.
You have informed him,
Yes, my lord. I am informed, but my application has not been put up with the petition.
but you have informed him.
Yeah.
Relist. Impleading application stated to have been filed.
As proposed, respondent.
To be
number
put
five,
up.
190.
Yes. Appearing for?
Kindly have it on Friday.
No, not Friday. No, it's only in some process, etc. So we'll give you time when it reaches. Let us see.
Page number 13, 57 to 62. Page number 14, 63 to 65.
Serial number 63, my lord.
63.
63. Because I am for the petitioner. Senior is not well, my lord. Have it.
I request. No, but somebody has filed vacating stay.
I'll inform, my lord. Senior is hospital. Undergone
Okay, let us see. I'll adjourn it when it reaches. Otherwise, you circulate a memo, get their signature on the memo and give it to the court officer. I'll adjourn. Yes.
Page number 15, 66 to
And for
67.
66 respondent. Seek an urgent. Inform the petitioner counsel, corrected matter, counsel is present.
You have informed. 66. Relist. In the week commencing from.
27th of January.
71, my lord. Respond number 3.
Just wait.
67 lord is connect, wrongly connected 57.1 and 2. Are wrongly connected with 57 and 7.3. There are 482 petitions tagged into GMO. Wrongly connected and will be dealing.
Which one? 67.1 and 2.
1 and 2.
Criminal petitions.
67.1 and 67.2 to be delinked and listed before the appropriate roster bench.
The interim order may be.
Interim order in operation is extended till the next date.
71 by
Just
Page
My
number,
lord, serial number
page number
66.
16, 68 and 69. Page number 17, 70 to 73.
71, my
yes.
I have a third respondent after vacation.
Have you informed the other
I will
side?
inform the,
Inform and report to the court officer.
yes, ma'am.
List after winter vacation.
Page number 80, 74 to 79. Page number 19, 80 to 82, 80 and 81.
Serial number 15, my lord. Serial number 15, my lord. It's not getting the NSA short accommodation.
Vijaya AM.
Just wait, when it reaches, I'll accommodate.
My lord,
Matters?
my lord, one submission. One PTCL matter.
Give it fast time.
Last week,
Mentioning time is over.
I understand, my lord. I have moved the matter last week.
Huh.
Today date was given. It has not been listed.
Pressure.
As matter has been remanded by the division bench of this humble court. Proceedings has initiated by the deputy commissioner. By suppressing all these facts, they have challenged the proceedings, only proceedings, and have obtained an interim order.
Tomorrow. Good.
Please.
Fresh matters, serial number 1. And the Kumar BL.
I'm for the patient also. Let do this matter.
Take out notice.
But I'll start for interim stay also.
No, now they've given,
Tribal claimants also there.
they've stated why they have allowed it. Reason, on what ground you are saying you're challenging
Because
them?
their petitions have claimed Article rights in respect of the land in question, Lord.
Petitioners are,
Petitioners are the tenants. They are the tenants.
it is allowed now for
Yep.
claim of
Yes.
page 38.
Yes, Lord.
Partly
There are-
allowed.
Some people have approached tribunal also.
Ah.
Karnataka. And some people, because other rival claimants have come to High Court also.
No, correct. What is the interim order now?
Interim order saying of that improved order. That's all.
I can only say status quo regarding
No,
possession.
that's all.
AGM accepts notice for the respondents. 1 and 2, emergent notice to private respondents. There has been order of status quo regarding possession as on date. Office objection.
I'll comply with it.
No, Kiveter, have you served?
Yes, Kevin has been served.
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 Serial number 2. Baji.
Adil one sentence add ಮಾಡಿ. No representation on behalf of Kiveter.
Happening to the petitioner in the matter,
Yes.
my lords. My lords, this is pertaining to issuance of Sagovali check. Order
AGA,
is passed way back in 84, my lords.
AGA accepts notice for the respondent. List the matter in the preliminary hearing list in the week commencing from. Synopsis to be arranged chronologically. So you do it, I'll give you time. Week's time granted for compliance of office objections finally. Yes,
3.
Any date could
Serial
be
number
fixed
3.
in the first week or second week, my lords, any date.
19th of January.
yes.
3.
My lords, I appear for the petitioner. My lords, here we have challenging, my lords, the order of the second respondent who is from Bangalore, my lords. The Commissioner, Department of Survey and Settlement and Land Records. The office, my lords, has raised an objection that the petitioner belongs to Bellary and the matter does not pertain to this honorable court, my lords. It's not the place of residence of the petitioner. It's the order and the challenge, my lords. It's the second respondent's order. So the office objection may kindly be overruled and notice may kindly be issued, my lords.
There's one, no, now only one office objection remains that
Yes,
you
ma'am.
just find out.
The office note, my lords, that petitioner belongs to Bellary.
No, that has been,
That is the only office objection, my lords. Rest all we have complied.
no, no, that this one, that office objection you are raising, they have overruled, I think, or left it out. Now there's only one office objection regarding prayer that you just check out.
I'll check it out.
Yeah,
I'll check.
AG accepts notice for the respondents. Instructions to be completed within 2 weeks. Office objection to be complied.
Grateful, grateful.
4, number 4. Alvin?
Yes.
Petitioner, my lords, in all the 4 connected matters, my lords, the court had directed a joint inspection to be done in these lands, and we're awaiting the joint inspection report from the Tehsildar.
But the revenue inspector has conducted some sort of a spot inspection. We're trying to verify whether we're going to continue issuing it for the Ashraya scheme or whether we're going to hand it over to the petitioners. Lordship may have it the second week of January, my lord.
Release the matter in the same stage in the second week of January.
My lord, there was a stay granted in one of the matters. It may be extended to the connected matters as well. In 4.2.
No, what is the stay now? No, still they're not going to take any action. They're deciding.
Jump.
5.
Like in this case, Malad, the petitioners here in Malad challenged the.
You are the grantee.
Grant Malad within a period of 2 years, Malad, within the span of 3 months, Malad.
He accepts notice for the respondents. 1 and 2, 1, 2 and 3. Emergent notice to the private respondents.
But not for interim, not to alienate the.
No, let us see.
Status code.
Subject, it will be
Number
subject
6,
to.
Manjunath, yes?
Yes. Whatever happens will be subject to orders to be passed. Let us see. It is rejected, isn't it? No, no, let us see. Yes.
It create third party interest.
It would be subject to orders to be passed. Yes.
May please. Assigned is the order, my lords, the interim order passed by the assistant commissioner, my lords, whereby my lords status quo is being granted in respect of an MR of the year 2013, my lords.
No, it appears.
2003.
Correct. It appears that the land has been converted.
Yes, my lords. The converted land, the assistant commissioner would have no jurisdiction, my lords, on the converted land, my lords. Conversion has happened in the year 2003, my lords. I have purchased this property in the year 2012.
No, correct, but now the order is only status quo.
Status quo of getting back the entries of the year 2003, 2004. My erstwhile landlord's entries were there in the RTCs, my lords. That has been now disturbed, and they have restored the entries of the year 2003, 2004. If my lord should kindly see the annexure E for a moment, my lords.
No, which is the
page
order?
40. Page 40.
Which is the order that was challenged before the assistant commissioner?
Before the assistant commissioner. That's with respect to the MR entries of MR entry bearing 29 of 2003, 2004. That my lord should get it at page 40.
Now this is in whose name?
The respondent number 3 claims that it was in the name of their forefathers, my lords.
Correct. Now this you challenge this.
I did not challenge. Respondent number 3 challenged the entries which were made in the name of my erstwhile owners. And the assistant commissioner proceeds to pass an order of status quo, my lords, and my lords restores the entries made of the year 2003.
Where is that?
Page 40.
Correct.
Last, my lords, Adesha Putta. Karnataka book Bukandaya so and so. Ready mail manivi dakaligondiದೆ. MR number 29 of 2003-2004 ಮುಂದಿನ ವಿಚಾರಣಾ ದಿನಾಂಕದವರೆಗೆ ಯಥಾಸ್ಥಿತಿ ಕಾಯ್ದುಕೊಳ್ಳಲು ಆದೇಶಿಸಿದೆ. ಪ್ರಕರಣ ವಿಚಾರಣೆಯನ್ನು ದಿನಾಂಕ so and so ಮುಂದೂಡಲಾಗಿದೆ. Thereafter the assistant commissioner did not have a sitting at all.
No, correct. It says status quo regarding MR 29 of
2003-2004.
This was in whose name? This 29 of 34.
34 was in the name of their forefathers, the applicant's forefathers.
Subsequently, you got it entered in your name.
Not my name, in the name of my landlords.
That is there.
That was there.
That is MR number.
That MR is not available.
That is a later MR.
That was a later MR which was changed in the year 2003-2004.
No, 29 is of 2003-4.
Please.
So which is your MR now? your vendor's MR. Is it earlier to this or later?
Sorry, my lord.
Now, this 29 of 2003-4 is that page?
That MR is not available with us. That was in the name of the appellant's forefathers is what they claim in the petition.
Correct. So they're seeking.
Thereafter, my lords, my vendors are, my lords,
Where is that? Where is that?
the sale deed, my lords, find it at page 16, 13.
Page?
Page 13 is the sale deed, my lords.
Now, after this sale deed, there's another mutation.
No. By then, the property was already converted. Property got converted in the year 2003, 2004 itself. Sale deed is being executed in the year 2012 in my favor. By then, the property was already converted. That, my lords, would get it at annexure.
So
B, my lords.
as on the date of annexure E order,
Yes.
it was already converted.
Yes. Annexure B for a moment, page 34, my lords.
But you must not create third-party rights. You must not create third-party rights.
No.
The petitioner submits that the order at annexure E is one without jurisdiction insofar as land was converted for non-agriculture purpose in terms of the order dated 19/12/2003 at annexure B. In light of the same, there would be the stay of the order at
No,
annexure.
order is dated 24/6/2020. The assistant commissioner's order is dated 24/6/2020.
Not that council. The order of conversion is annexure B, isn't it?
Annexure.
So I'm saying that since it was converted
Under order dated 19. Sorry.
(19/12/2003). In light of the same, there would be stay of the order at annexure. Stay of the order dated
24/6.
24/6/25. 24/6/25 passed by the assistant commissioner at annexure E. Needless to state, petitioner not to create third-party rights. In the interim, AG accepts notice for respondents 1 and 2, emergent notice to the private respondents. Petitioner is at liberty to serve counsel who appears for the private respondents in the pending proceedings.
Great.
7, Pundika Ishwar Bhatt, serial number 7.
I appear for the petitioners. I have sought for writ of mandamus directing the respondents regularization committee to consider my application filed in 1991 itself. My lord, in the meantime, my submission is this, my lord. I have threat of disposition. Now they are going to, the government is going to grant the land in favor of third parties, my lord. Though I have vast improvements are situated therein. Without considering my application, they are going to distribute the land to third parties.
You find out. AG accepts notice for the respondents. Relist on Thursday. Relist on Thursday in the same stage.
18.
Office objection is complied with. It is stated office objection is complied with. Office to verify.
8. Raksita DJ.
In this case, I appeal for the petitioner counsel. I question the correctness of the order at page 104 by the JDLR. May I request, my lord? Your Lakshmi, this is the third round of the matter before the Honorable Court. Your Lakshmi, kindly appreciate page at 104, annexure T. Now here, my lord, the short point in the case is, there was originally grant was in 11/11/54 under the Mysore Revenue Code. Now later, my lord, in 2004, I purchased the property in 2005. 2004 land was converted. Now only the grievance of the petitioner is to correct the village map. That's how, that is the powers are vested. May I request, my lord, page 175 maybe kindly be seen. 7.5. So Lakshmi, kindly appreciate.
So you take out notice.
Annexure page at annexure P.
Yes, now you take out notice.
75.
AG accepts
This
notice.
is emergent notice may be harder. Date may be kindly fixed, no stay, no interim order is sought.
AG accepts notice for the respondents. Instructions to be completed within 2 weeks. Relist the matter in the week commencing from
19th of January. 9, Pradeep Yadav, Ganesh P.
Respondent number. Respondents filed a requisition 35626 for connect matter
WP
W35626 of 2020.
35626.
of 20.
25.
Now you will accept notice in this.
Is a caveat, madam.
Caveat.
Around caveat.
Adal our respondent number 5 is
Same order has been challenged in both these writ petitions. Now the DC filed annexure A. Now, my lord, he treated the land as a government. My lord, if your lordships could see the annexure A, it is a completely AI generated order. Now I take your lordships to the first page of the implement order, AI, annexure A. My lord.
How do you say that?
Sir, now it is called as government Bilu. Now the stand of the government is that it is a government Bilu.
There is some app to check if it's AI also.
Yes, my lord.
There is an app to check AI content. It will tell you how much. So in the presentation made in the Judicial Academy, there is one resource person called Anant Prabhu. He is a regular resource. So he said to get over that detection of AI, there's one more app which gives you. No, but now this is a case where it was declared as PADA at some point of time.
Yes.
Subsequently, because it was vested with the government has granted it to the petitioner.
Entire land irade swami 4 ಎಕರೆ 23 ಗುಂಟೆ.
And then subsequently, at their instance, it was restored later.
Yes. And that, my lord, they are not sought for restoration. They are sought for deletion of entry of FADA. They say in their appeal that the FADA has been entered illegally.
Anyhow,
and by mistake.
Correct. Now let us see. So status quo as on date, both parties to maintain status quo as on date.
Yes.
AGA to complete instructions within 2 weeks. List along with WP number 35626 of 2025. Both sides to maintain status quo as on date.
And revenue entries.
Status quo as on date as regards revenue entries and possession. Yes. How do you say it's AI content?
Lord, I take your lordships to annexure A.
Yes.
Lord, in Kannada, it is called government Bilu. Now the DC says it is a government fall. There is no term as government fall under the Land Revenue Act. If you translate, my lord, under the chat GPT, it says government fall.
Let us, yes.
10, number GS.
Office objection is
This had come up yesterday.
Yes, please.
Please. What is the matter?
Lord, this is 136(3) proceedings before the Deputy Commissioner. AC Mara directed to mutate my name in respect of 38.5 guntas of land in 29/1A, based on Mara sale deed and earlier Palupatti, and remaining 27.5 gunta in favor of respond 5 to 10. But it was challenged by the respond 5 to 10 before the DC. He remanded the matter. After remand also, Assistant Commissioner earlier order upheld his earlier order after considering various aspects. Thereafter again 136(3) proceedings. Deputy Commissioner has set aside the order of AC with a direction to restore the names in the entries as which was stood prior to suit invoice number 468 of 2000. Against which I filed a revision petition before the tribunal. Lakshmi kindly see tribunal's order. I filed revision petition along with application for stay. Tribunal summarily rejected my application and admitted the revision petition. Page number 96 में कहीं the interim order on IA number 1, 96. Para number 2, 3. In this case, the pendency of OS number 19 of 24 for the relief of declaration is admitted. Therefore, at this stage, revenue authorities have no jurisdiction to pass any orders in respect of those property. Therefore, stay cannot be granted against the orders of first respondent. Yes, no specific order in respect of kata of the property is made by the first respondent, but the first respondent has only directed the parties to approach civil court. This observation is not correct, Murad. Lakshmi, kindly see page number 79. Order of Deputy Commissioner, operative portion. A specific order was made by the Deputy Commissioner, Murad, page number 79. ಪೀಠಿಕೆಯಲ್ಲಿ ಚರ್ಚಿಸಿದ ಕಾರಣಗಳಿಗಾಗಿ ಮೇಲ್ಮನೆಯನ್ನು ಪುರಸ್ಕರಿಸಿದೆ. ಪ್ರಸ್ತುತ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ಹುನ್ನಾಳಿ ಅವರ ಆದೇಶವನ್ನು ರದ್ದುಗೊಳಿಸಿದೆ. ಚನ್ನಗಿರಿ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದ ಪ್ರಕರಣ ಸಂಖ್ಯೆ 19/2024 ರಲ್ಲಿ ಅಂತಿಮ ತೀರ್ಪು ಹೊರಡಿಸುವವರೆಗೂ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶ.
Anyhow, it's an interim order. In his presence, you take out notice. You serve the council.
Now, Murad, I am in possession of the property. And as per the order of AC.
So, but correct. Now there is some civil dispute. OS 19 of 2024.
Pardon?
OS 19 of 2024.
19 of Murad, that is pending consideration. I have produced.
So
for declaration, it was filed.
Correct.
Even prior to that, Assistant Commissioner has directed to change the kata. Even prior to OS number 19 of 24.
Anything regarding possession, after notice we can see. There are some.
My submission is, Murad, at least status quo regarding possession. Otherwise, standing crop of Murad Arekanath is there.
No, but that you have to seek before the civil court.
In the observation of appellate tribunal, that Murad, while rejecting my application straight away, summarily, there was no positive direction is not correct.
No, correct, but let us see. In their presence, we can see.
Annexure C is mutation.
You take out notice.
Then
no ex parte order. It's a interim order. Now let him be served. I'll fix a date. You serve him. Let us see.
Even appellate tribunal also, Murad, order notice.
No, the civil suit is pending.
Civil suit, Murad, filed by me for declaration.
You seek for relief there. Let us see. AG accepts notice for response 1 to 4. Emergent notice to 5 to 10. The consideration of interim prayers kept open. Petitioners at liberty to serve. Counsel appeared for the respondents before the Karnataka appellate tribunal.
ಅಲ್ಲಿಗೆ ಬಂದೇ ಇಲ್ಲ, ಅಲ್ಲೂ ನೋಟಿಸ್ ಅಷ್ಟೇ ಆಗಿದ್ದು, ಹಂಗಾಗಿ ಅಲ್ಲಿ ಯಾರು ಅಪಿಯರ್ ಆಗಿಲ್ಲ. That may not be, Murad.
It's very emergent notice. Relist in the week commencing from
27th of January.
Yes.
11.
ಅದಕ್ಕಿಂತ ಮೊದಲು second week of January.
Second week.
11. Shruti SP.
Appear for the petition. Of the purchase, the sale deeds also, Your Lordship.
List of dates.
List
Yes.
of,
Yes. Yes.
in the 1978 land
The
in favor of,
rectified synopsis filed is taken on record. Yes.
Your Lordship, 1978 land, 4 acres land has been granted in favor of the Timmaya. Then after, in the year 1987, he executed a release deed of 2 acres. Out of 4 acres, he executed a 2 acres release deed in favor of his wife V. Jayalakshmi. The Jayalakshmi farmed the layout in that layout. She sold the 64 sites out of the farm, 64 sites out of that. The petitioners herein are the purchasers of the such 4 sites. Your Lordship, we are purchased and constructed the house and residing there. Your Lordship, the Assistant Commissioner without properly is not at all served to the petitioners. Then he passed the order holdings that the Timmaya belongs to the scheduled caste and that is a granted land. Since permission has not been taken, then the same has been questioned by the petitioners and other site owners before the deputy commissioners. In the deputy commissioners, we taken a specific contention that the Timmaya is ex-serviceman and he belongs to the Okkaliga community, but he was married SC lady, Jayalakshmamma, who belongs to the
petitioners are purchasers of land and seek to call in question order of the Assistant Commissioner directing restoration of land under provisions of the PTCL Act and have also challenged the order of the Deputy Commissioner affirming the order of the Assistant Commissioner. Full stop. The petitioner specifically asserts that the original that Timmaya, stated to be the original grantee, did not belong to the scheduled caste and scheduled tribe community, and accordingly, it cannot be stated that the land granted would come within the purview of the PTCL Act. Full stop. In light of the same, there would be stay of the order at annexure
Annexure
D and E.
D and E. The CG accepts notice for the respondents. 1, 2, 3 emergent notice to the private respondent.
Respondent 4.
4.
Yes.
1, 2, 3.
12. Srikantyam, connected matters.
Paper. Petitioner in this case, my lord,
Responding numbers.
there was a RRT proceedings which was taken place in the absence of petitioners. And in the RRT proceedings, the sale deed which according to them it is of the year 1939. And in the year.
What are the facts you tell me?
My lord,
you say you are not a party in the.
not a party in the RRT proceedings.
So
and but there was a OD in the year 1943 as per annexure N.
Page
138, my lord. In 142, that's the continuation of annexure N. My previous vendor name Veerabhadrappa is mentioned as the Khatedar for 52/1. Since from that date 52/1, Veerabhadrappa, son of Veerappa.
This is your vendor.
This is my vendor, my lord. And the Puttaya is the father of respondent number 8 and 9. And it is shown in this 2 acre, 1 acre, 23 guntas. As this 40 has taken place as per the possession, my lord, because here it is mentioned in annexure N 138. Index nante pura Veerabhadrayana ಹೆಸರಿಗೆ ದಾಖಲೆ ಆಗಿದ್ದು. Page 140, that's the typed copy.
140, that type 142 I've seen.
Now 140, my lord.
140.
That is also annexure N typed version.
Yes.
Index nante pura Veerabhadrayana ಹೆಸರಿಗೆ ದಾಖಲೆ ಆಗಿದ್ದು ಈ ಪೈಕಿ MR ನಂಬರ್ 1/3940 ರಂತೆ ಪುಟ್ಟಯ್ಯನಿಗೆ ಖರೀದಿಯಾಗಿರುವ ಪ್ರದೇಶವನ್ನು ಅವರ ಅನುಭವದಂತೆ ಪೋಡಿ ಮಾಡಿ 1-2 ಹಿಸ್ಸೆಗಳಾಗಿ ವಿಂಗಡಿಸಿದೆ. So this later the RTC continued in the name of both parties. It was continued till the year 2018-19.
This MR 3940 relating to Puttaya relates to 52/2.
Correct, madam.
So according to you, it was only 1 acre 23 guntas.
Yes, madam.
And MR was also entered in that.
Correct.
Now
in the name
what?
of Puttaya.
Now what happened?
And later, my lord, I purchased the property from Veerabhadrappa in the year 1954.
Yes.
And my name entered in the RTC, my lord. And the RTC continued till the year 2018-19 without any disturbance. And in the year 2018-19, RRT proceedings was taken place on the instigation of respondent number 8 and 9, my lord, saying that the RTC, the entries, that is the extent, is not proper, and the extent ought to be 2 acre 21, not 1 acre 23.
2 acre
21, according to the respondent number 7, 8, and 9, my lord. And the RRT order, my lord, in page 152.
That is annexure T proceeding.
Annexure T, my lord. 143, in page 143, last para, it clearly mentions there was a Ketwaru Dakale, 1909 ನಲ್ಲಿ 153, my lord, page 153.
No, now.
Last para, my lord.
No, just a minute. Now, so you are saying that this modification to 2 acre 26 guntas is without notice to you.
Correct, my lord. That too, it is based on the Tahsildar has changed based on the seal deed, my lord. that sale deed which has taken place in the year 1939.
It is. Now this order is passed by the Tahsildar.
Tahsildar, my lord.
Now you have challenged which order now?
Now all the
Now that was challenged.
that was
before
challenged in RA, my lord,
the,
and which was dismissed.
and
And
then
while pending the said RA, because in first RA what happened, my lord, I only challenged the RRT proceedings. In the immediate of the RRT order, the respondent number 8 and 9 has sold the property to 9 and 10. And there was no knowledge, because immediately after coming to knowledge, the petitioners preferred one more RA, my lord, challenging RRT as well as the MR entries, subsequent MR entries in one more RA proceedings, my lord. So there was two RA proceedings, my lord. Since there was two RA which was dismissed, again I have to prefer to RP, my lord, which was also dismissed only on the ground that the basis on the sale deed is proper, my lord.
correct, but now since it's already changed into his name.
Correct, my lord.
So what is the interim relief now? Not to create that.
Not to create third party and let them maintain status quo regarding the possession, my lord. Because in 1943 also the PODI was taken place as per the possession of the parties, my lord, and it was continued till today, my lord. Till today, the possession is continued.
Lord, this Puttaya had purchased. Kindly turn to page 132.
No, correct. Now merits apart, the order at annexure T is without notice to him.
So that is true, my lord.
There ends the matter. The rest we'll see. The rest we'll see.
It is true, my lord. He was not the party, as could be seen from the order itself. But the point is,
no, correct. So
at the earliest point of time, the Puttaya had purchased the land measuring 2 acre 21 guntas. You will also find it at page 132.
No, now that is on merits.
Please.
What could be done if you say, then we could simply set it aside and remand it back for consideration in his presence. Let the proceedings take place.
That's all. That's all I see.
I will not enter into merits because it may prejudice what.
Because mine is the earliest.
So I leave it at that.
1939 I had purchased. They had purchased 1954.
I leave it at that. The petitioners have filed the present writ petition challenging the order passed on 4/11/25 by the Deputy Commissioner, as also the order dated 3/8/2021 in RA 242 of 2020 by the respondent number 3, that is the Assistant Commissioner. Petitioners also challenge the validity of the order of the Tahsildar in RRT CR 14 of 2018-19. Certain consequential proceedings have also been, certain consequential relief is also sought for. The petitioner submits that his vendor Veerabhadrappa is Veerabhadrappa, and there were proceedings regarding Hissa survey in the year
1954, my lord.
1954.
Annexure B.
And in terms
1954.
And in terms of the said Hissa survey proceedings, re-survey number 52/1 was shown as for an extent of 2 acre 19 guntas, while the private respondent's vendor, Puttaya is your vendor.
Puttaya is my vendor. Puttaya is my father.
Whereas the land
property belonged to Veerabhadrappa, he had sold this 2 acre 21 guntas to Puttaya in 1939.
Where is it? 19 full stop. Further, an extent of 1 acre 23 guntas was shown in the name of Puttaya, father of the private respondents.
7 and 8.
7 and 8.
Only 7 and 8.
7 and 8. It is
Sorry for interruption, my lord. They had purchased, this Puttaya had purchased as per the sale deed dated 19/9/39. Your lordship will find it at page 129.
I'll refer to
Annexure
that.
K.
I'll refer to that. Full stop. It is the case of the petitioner that certain proceedings were initiated by the private respondents claiming to Puttaya, and in terms of the order at Annexure T, the Tahsildar had directed that Khata ought to be effected in the name of Veeranna, son of Puttappa, and Mariappa, son of Puttappa, for an extent of 2 acre 26 guntas in survey number 52/2. It submitted that this order of the Tahsildar was an order passed without arraying the petitioner herein as a necessary party. It submitted that in effect the earlier ISSA survey proceedings in the year 1954 stood altered insofar as the extent of land in the name of Puttappa came to be enlarged from 1 acre 23 guntas to 2 acre 26 guntas, and proportionately the entries in the name of the petitioner with respect to the extent of land in survey number 52/1 would have a shortfall. Learned Counsel Sri M.J. Alva, appearing for the respondents, would however submit that the entry made by the Tahsildar is in accordance with the earlier sale deed of 1939.
1939.
1939.
1939.
And accordingly accordingly does not require to be interfered with. Full stop. Next. However, it must be noticed that any alteration in the entries having a prejudicial effect regarding the extent of land in a survey number, if sought to be made, ought to be made with notice to the petitioners herein. Full stop. Without entering into the rival contentions, noticing that the petitioner nor his vendor were parties in the proceedings at Annexure T. The order at Annexure T requires to be set aside. Full stop. Accordingly, the order at Annexure T AB, T passed by the Tahsildar, order at AB passed by Assistant Commissioner, and order at Annexure A passed by the DC are set aside, as also all other connected proceedings pursuant to such impugned order. All contentions are kept open. Both parties to mark their presence before the Tahsildar without further notice. Full stop. On the Tahsildar is to restore the proceedings in RRT CR number 14 of 2018-19. The petitioners herein may be permitted to be arrayed as additional respondents. All contentions are kept open.
Connected matter.
What is that?
Very same, my lord, because I mentioned there were, initially there was only RRT.
Shall we club and
yes, my lord, better, my lord. It can be clubbed because only one.
To respect my submission is it is a mischief because
Mischief,
they
mistake.
had filed one appeal under 136(2). Then again, after the dismissal, they file one more appeal. Now against those two
Not after
orders,
dismissal.
another two revisions happen.
Correct. Now, otherwise, you can withdraw this. In
Exactly,
light
they
of,
have to withdraw it, review of the order.
in light of, you can file a memo. In light of allowing of WP so and so.
Yes, madam.
You can withdraw this.
Because, my lord, in that RA, the other MR entries which was in the name of subsequent purchasers have also challenged, my lord. Only for that reason it can be clubbed and one order may be passed. Even I filed before the RP also for very same thing. But they mentioned that for clubbing.
Now,
So far as the order of the deputy commissioner is concerned, it is a common order, my lord, in respect of both the proceedings.
But
it is a common order.
It is a common order, but they have filed.
We'll just say WP is it common order.
37642.
One paragraph. WP 37642 of 25 has been filed by the petitioners, calling in question correctness of the order of the DC prior details by RP number 474 of 2023 at annexure A passed by the DC, comma, order in RA 156 of 2021 passed by the Assistant Commissioner, comma, and order at annexure T passed in RRT CR 14 of 2018-19. In light of the order passed in WP number so and so, the present writ petition is also liable to be disposed of, taking note of the observations passed in the said order. Full stop. Now all the numbers, order numbers are same.
Same, my lord. Very same.
It's a common order.
Common.
Accordingly, the said writ petition is also disposed of as not calling for adjudication, taking note that the very same orders are set aside in the order passed in WP number so and so. Now the numbers of the three cases are same.
Yes, my lord. Very same.
January 1st.
January.
Great. 12th of January. 12th of January. 12th of January attend ma. 12th of January. 13.
Last occasion, this honorable court directed DC or in any of the revenue officers to conduct an inquiry in respect of the grant certificates which they have produced along with the memo before this honorable court and also a Sagwadi. I have conducted. The report is here with.
Good. Now you give him a copy.
Copy received, my lordship. I will go through it kindly and after vacation, my lord.
No, my lord, this petition has to be dismissed with exemplary cause. And
my
also,
lord, first week of January maybe.
Tahsildar or any revenue officer to initiate criminal complaint against the petitioner for carrying out such an act of concocting and false documents are produced. And before this honorable court, action has to be taken. Yes. Grant register, grant certificate, application, 94cc application also is concocted. They have not produced. Only one application which they have produced, which is already been rejected. And all these are not fitting into any of the grants. Still they want to putting a hold on the land.
So let them take the stand in writing.
Yes.
AGA has filed a memo along with the report of the Tahsildar and other documents. It is stated that the proceedings were conducted by the Tahsildar pursuant to the directions of this court on 10/12/2025.
Might be on 10th itself.
Petitioner to take his stand in writing, specifically adverting to the documents filed along with the memo by AGA. affidavit of the petitioner to be filed along with the necessary pleading in light of the allegation, in light of assertion by the government that documents relied on by the petitioner are concocted. Relist the matter in the week commencing from
12th of January.
yes.
14th, KV Satish, Natraj.
Matter, my lords, the application of the land.
Why was it adjourned?
Lord, it was adjourned only for the sake that they want to prove their title with respect to the grant and also with respect to the purchase. But as of, they have only sought for entering of the name of the petitioner because in his name itself, his vendor name itself, it was converted and he is into question of the 13.5. As of last
the lordships observed.
Last occasion also, I agreed with respect to the putting of the entries in the name of the petitioner. If there is any dispute of any of the title, they have to approach any of the civil court or court as per.
The lordship directed me to implead the Surajakanahalli, that the Gram Panchayat, that is Anekal, as the respondent number 4, and then so that they can agitate their rights before the thing, because the property is converted and the khata has already been transferred in the name of the petitioner as well as his predecessor in title.
So, new records are in my favor, my lords. They have taken entries, panchayati entries in their favor, my lords. That is the reason why my lords direct them to implead the PDO as a party. Still, it is pending for.
Subsequent to the conversion order, the RTC, the mutation has been effected, my lords.
And till today, we have not sold any of our property to petitioners. We are the original grantees, my lords. And till today, the revenue is in our favor. We are not transferred any of our properties, particularly the subject 7 number. They have obtained a sale deed.
No, now have you made that PDO as a party?
My lords, I have to just carry out the amendment only, my lords. The file had been sent, I could not immediately carry out. I'll just make it, my lords. I have filed the amended cost title also.
So who is the council?
My lords directed Devraj to take notice, Mr. Devraj. But he said he is not handling Anekal matters. So he has directed me to serve it on Mr. Prakash. MS Prakash. So I have served it on, my lords. I have informed him also that that matter is listed.
Now, correct. Now we could dispose it off. No? Yes. There is no other way. I'll only record your submission. Now I'll record your submission though. Now you just tell me brief facts only for this purpose.
Yes, my lords. My lords, the property has been converted, my lords, as per Annexure F at page 62, may kindly be 57, may kindly be Annexure F, as early as on 21st of December 2004.
21st December
2004.
Extent of?
My lords, there were 5 different owners who have all sold the property.
No, correct.
Now, total extent is 1 acre 38 guntas.
1 acre?
And only the 1 acre 38 guntas.
Which is the subject matter of the present?
Not the subject. Only 13.5 guntas is what they are questioning.
13.5 guntas.
13.5 guntas.
This falls within this order of conversion.
Yes, my lord.
Yes.
So all the respective owners, 5 owners, had applied for conversion.
Yes, yes.
Including
now, correct. Now,
yes.
Now you go to his application before the AC. What was the order passed?
My lord, the Tahsildar mutates the names of these respondents 2 and 3 without giving notice to me.
Where is that?
Yes, my lord. Yes, that let's copy of annexure page 33, my lords, annexure C. I did not approach the revenue authorities for change of this RTC only because of the fact that the property was already converted. Even my vendor also has not approached the Tahsildar.
Now, this H12
yes,
of 2013-14,
yes,
it records the name of the respondent number
2 and 3, and the Muni Venkatappa has passed away subsequently. My lords, the legal heirs are brought up.
So we'll say in favor in favor of the private respondents.
Yes.
So this entry you're saying was without jurisdiction because it was converted.
Yes.
Now this order was challenged before the AC.
I have challenged.
Annexure?
Yes, AC is Annexure B in RA A 640 of 2014-15, page 27, my lords.
Annexure B is the order of the AC.
AC at page 27.
And then this was confirmed by the DC.
Yes, my lords. Annexure A at page 20.
Yes. Now you are saying that you have already got Kata in your name before the PDA.
Yes,
Panchayat.
at page 61, my kindly visit.
Page?
Page 61. This is under the Rural Development and Panchayat.
Now this in which year you got it done?
Gram Panchayat. My lords, my vendor has also got it converted. I mean, registered the Kata, and then it has been by virtue of the sale deed in my favor. It has been, and it is in respect of the entire 1 acre 38 guntas.
So now you claim.
We are claiming that we are the family members of Muniappa, who is the original grantee. Till today, revenue entries in our favor. They are claiming that they have one of Muniappa, that is my father, executed gift deed in favor of Chinnamma. From Chinnamma, they have purchased. No document and no revenue entries is affected in her favor. Suppose they have purchased from my father or gifted by my father. Where is the revenue entries? Straight away they went before the Panchayati authority, converted the land, and they obtained the Panchayati Kata.
Is at page 74, my lords.
No, just on. I'm not entering into the merits. So you are claiming that you are the legal representative of the original grantee, and that there was no sale in favor of the. No, you are saying there was no sale in favor of the petitioner or his vendor.
Please, we have not executed any sale deed.
That's your content. And then you got the mutation change on the basis of inheritance.
Yes.
Inheritance.
Please.
So now I will keep it open for you to challenge his the entry made in his favor in the Panchayat.
My lord, I have placed the mutation in
That
favor of that Chinnamma. In favor of Chinnamma. Chinnamma, the mutation.
Anyway, I am not entering into that.
Since your lordship here pointed out, he said that there is no mutation at all in the name of my vendor or the predecessor. It is. I have produced that document.
Let us see.
At page 74, my
Let us see.
Page 74.
No, I leave it at that. I don't
Yes,
want the present petition has been filed, calling in question validity of the mutation effected in favor of the private respondents in terms of the mutation at annexure C MR H12 2013-14. Said order of the Tahsildar was assailed on various grounds, including on the ground that the land itself having been converted as per the order of the Deputy Commissioner dated 21/12/2004. The revenue authorities did not have jurisdiction to entertain any application for change of mutation after such order of conversion. Full stop. The Deputy Commissioner, as per the order, the Assistant Commissioner, as per the order at annexure B, rejected the appeal, and same has been, and the said order has been confirmed by the Deputy Commissioner in revision petition 450 of 2017. Full stop. Next. Petitioner claims that on the basis of the sale deeds and in light of land having been converted to non-agriculture purpose in the year 2003, have got Kata transferred in their name before the Panchayat authorities and rely on the documents produced at Annexure G series issued by the Panchayat Development Officer. Full stop. The respondents, on the other hand, would contend that the petitioners have no lawful title and that the land was originally granted land in favor of Muniappa, and there was no sale by Muniappa or his legal representatives either to the vendors of the petitioner or to the petitioner, and accordingly had sought for inheritance kata, which was rightly entered, rightly affected in favor of the private respondents by the Tahsildar. Next, AGA submits that once land is converted for non-agriculture purposes, revenue authorities cannot enter into any disputes relating to such mutation entry, and the grievance regarding any entry existing as on the date of the order of conversion can be made only before the municipal authority. Municipal authority. Full stop. Next. The fact that the subject matter of dispute of 13.5 gunta comes within the purview of the order of conversion dated 21/12/2004 is not in dispute. Full stop. Once land is converted on 21/12/2004, the revenue authorities lose jurisdiction to enter into any disputes. Full stop. Accordingly, the mutation entry at Annexure C is one without jurisdiction and is set aside, as also the orders at Annexure B of the Assistant Commissioner and order of the Deputy Commissioner at Annexure A. Full stop. The Khata as on date stands in the name of the petitioner, as is evidenced by the documents at Annexure G series. Full stop. However, noticing the contention of the private respondents, it's clarified that the contentions of the private respondents regarding effecting of Khata standing in the name of the petitioner would be challenged, is required to be challenged. All contentions insofar as the private respondents are kept open to be taken up before the authority, before the
respondent number 4.
Before the Panchayat authority. It is clarified that court has not entered into the merits of the claims of both parties, and observations made are only on the jurisdictional aspect. All contentions of both sides are kept open. Liberty is reserved to the private respondents to challenge the Khata effected in the name of the petitioner by the Panchayat authorities if circumstances are so made out and if so advised as per law. The delay in filing the appeal must be construed liberally in light of the proceedings pending before this court, as well as revenue officers, that is before the Deputy Commissioner and Assistant Commissioner.
Should not
in the interregnum, the petitioner not to create third party rights for a period of 4 weeks. Full stop. The such protection is granted only as a transitionary relief, leaving it open for the private respondents to approach the requisite authorities and obtain necessary orders. Learned Counsel B.A. Prakash from M.S. Prakash is directed to accept,
I'll carry out the amendment.
accept notice for the newly added PDO, file could duly added Panchayat Development Officer of Surajakanahalli Gram Panchayat. Necessary amendment to be carried out.
I shall.
Yes.
15.
Right.
Vijay, 15.
I may be permitted to retire from this case. Another counsel is hearing.
I have received NOC Wakalat today, my lord.
Learned counsel so and so undertakes to file wakalat for the petitioner with NOC from the previous counsel. Office to delete the name of learned counsel PM Vijay from the as representing the petitioner in light of appearance by another counsel.
It may be taken up after vacation. Any date may be fixed.
Fraud, my lord. My lord,
I have received today, my lord. I have no instructions.
Lord's permission has been taken to alienate this property. Based on that permission, my lords, I have purchased this property. Lords, later on, on the very same permission, my lords, he alienates the property in favor of other person, other respondent hearing. My lords, he gets the revenue entries mutated in his name. I challenge that. Meanwhile, my lords, very petitioner and the family persons files a suit for partition, divides this property. My lords, that was also being challenged without arraying me as a party. Now, my lords, writ petition has been filed to seeking for an alternative land, to allot the alternative land in view of this alienation. But this is a fraud, nothing but a fraud, my lord.
Let us see. Now you take your EGA to take stand in writing by the next date. Relist the matter the same stage in the week commencing from. Yes.
16. K. Ravishankar. 15. K. Ravishankar.
In this matter, Ravishankar is on his legs. So I seek.
Your Lordship is asked to produce suits regard to the question.
He had already produced, I think, along with memo, he has already produced the plain copy of the plain.
The suits that your Lordship asked us to produce are not produced. I have a copy of it.
File it. Let it be on record. The counsel for the respondent files along with the memo copy of the pleadings in OS number
1199.
In OS number 512, a copy of the judgment in OS 512 of 2017 and OS number 1199 of 2019. Same is taken on record.
In this matter, my instructions are this. Without the lordship, behind by back of the lordship, the contesting petitioner. 11 sketch is prepared. Now, lordship, they are trying to take coercive steps. Lordship, that is the reason. Lordship.
Hear this matter for 2 minutes. Lordship, we dispose this up because your Lordship are of the opinion, Lords, this is a case for dismissal on the last day. 2 minutes, Lords. I only take your Lordship. Lordship, we dispose this up. Lords, the orders of the JDLR and DDLR are challenged. Lords, wherein they had to file an appeal before the Director of the Land Reforms. Now, Lords, the challenge before your Lordship is against orders passed by the DDLR and JDLR. They had to file an appeal before the Director under 49G. 1. Lords, there are 2 suits that I have filed.
They have challenged the
order of the DDLR and JDLR. No?
Lecture L and M.
Wherein they have sought for initiation of PODI proceedings. Lords, all that the JDLR and the DDLR have done, Lords, they have said, you get the suits decreed or you get the suits decided. Only then will I take a decision is what they have said. Now the suits are decided. They're decided in my favor. Their suit for possession, declaration and permanent injunction is dismissed. And my suit for possession and permanent injunction is decreed. Thereafter, Lords, they filed this writ. Now the JDLR's order, Lords, that is under challenge. Because all that they have said is let the suit be decided. Now the suit is decided. Now, Lords, nothing survives for Lordships to consider in a writ. When Lords, they had to file an appeal before the Director of the Land Records.
They have lost the suit for declaration of.
Declaration and permanent injunction.
Lost.
Against which they file a regular appeal, Lords, no interim order is granted. Against which they file a writ. There is no interim order granted, even the writ.
Appeal is pending. In this matter.
Let us see. Relist the matter in the same stage in the week commencing from
12th of January.
Yes.
17. Anandram.
Before the petitioners. The last occasion it was listed, my lord, for hearing on IA. Your Lordship, after hearing for some time, my Lord, has directed to be listed today, my Lord, in preliminary hearing, my Lord. This is with regard to, my Lord, the regularization of.
Directed me to conduct an joint measurement from the taluk boundary, means the CMC boundary till the land. Before also we have submitted one report, and thereafter in their presence, in their vehicle itself, we measured and a report is presented. That report also last time I heard.
Motorbike case.
Motorcycle. Their own motorcycle, my lord, 3.6 kilometers, my lord. Our vehicles shows 4 kilometers.
So what is the instruction? Last time you took time to find out
Yes,
from
my Lord.
the
I have received a copy of the memo along with documents that they have filed. My Lord, my submission is, my Lord, if Your Lordship sees the writ petition papers, my Lord, Annexure E, there is a report by the.
No, correct. But now, is it a fact that on the date of that your client was present, and he also was a part of the.
My Lord, Your Lordship, my Lord, had directed, my Lord, the representative of the petitioners to be present.
Correct. Was he
So
present?
accordingly, my Lord, they were present there. And my Lord, I think they were explained with regard to the Dishank app, and my Lord, they have also gone on a scooter ride, my Lord, to the property. My Lord.
ನಮ್ಮ ವೆಹಿಕಲ್ ನಲ್ಲಿ 4 ಕಿಲೋಮೀಟರ್ ಬಂತು, ಆದ್ರೂ ಅವ್ರ ವೆಹಿಕಲ್ ನಲ್ಲಿ
ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ದಾರೆ. I'll just, my Lord, point out from the report that they have filed. My Lord, last occasion, my Lord, Your Lordship may kindly take, my Lord, the writ petition, my Lord.
Now the writ petition is filed, calling in question
My Lord, the endorsement by the Tashildar, who is, my Lord, the secretary of the Regularization Committee.
So annexure?
Annexure B, my Lord.
So this is the first endorsement.
That is the first endorsement, Annexure B series. It starts from page 42.
All of them were issued that the land is within 5 kilometers.
The endorsement, my Lord, is issued stating that, my Lord, the land is within 5 kilometers from the city municipal limits. The application is filed under section 94A, my Lord, form number 53.
Now this distance
Yes, my Lord.
is in terms of section
94A, my Lord.
That there's a bar.
There is a bar, my Lord, if it is within 5 kilometers from city municipal council limits.
Yes.
Now, my Lord, before the authorities, my Lord, thereafter, my Lord, I filed an appeal before the Assistant Commissioner that was dismissed, my Lord, by order dated Annexure C, my Lord. Not Annexure D, my Lord, is the order of the Assistant Commissioner in RA number 9 of 2003-2004.
So this endorsement of the Tahsildar.
Yes, my Lord.
Was challenged.
Was challenged before the Assistant Commissioner.
Yes.
My Lord, Annexure D is the order passed by the Assistant Commissioner.
Who
affirmed the endorsements by order dated 15/9/2010. But the Assistant Commissioner goes on to say, my Lord, that I was also not cultivating the land, but that, my Lord, is contrary to the findings of the committee minutes. Committee says I was doing Sagoli, but the land is within. So ultimately, my Lord, the question is whether the land is within 5 kilometers or not. Then, my Lord, I filed an appeal before the Deputy Commissioner. The Deputy Commissioner, my Lord, also dismissed my appeal, my Lord, by order dated 4/11/22, Annexure F.
On the same ground.
On the same ground. Now, my Lord, I had produced Annexure E, my Lord, your Lordship may kindly see at page number 83. Annexure E is a report by the PWD Assistant Executive Engineer of the PWD Department, wherein he says that, my Lord, the village is Amalapura village, survey number 39 of Amalapura village, Tumkur Taluk, Tumkur district.
This is by the PWD.
This is, yes, my Lord, by the Assistant Executive Engineer, PWD Department. He says the Amalapura is 9 kilometers.
Now this land is in Amalapura.
Amalapura, survey number 39. My Lord, total extent of the land is 26 acres, 27 acres, 36 guntas. Now, my Lord, this report says it is 9 kilometers from insofar as Amalapura is concerned. Now, this report was not considered, but, my Lord, Deputy Commissioner, while dismissing the appeal, my Lord, refers to another report according to which, my Lord, it is within 5 kilometers. That is at page number 87, my Lord. Page number 87, last paragraph, my lord.
Yes.
We were not given a copy of this report. Sahayaka Karyapalaka engineer, so and so ilake Tumakuru Ivaru, number so and so ದಿನಾಂಕ 21/9/2019 ವರದಿ ಸಲ್ಲಿಸಿದ್ದು, ವರದಿಯಲ್ಲಿ ತುಮಕೂರು ತಹಶೀಲ್ದಾರ್ ಅವರಿಗೆ ಈಗಾಗಲೇ ಈ ಬಗ್ಗೆ ಮಾಹಿತಿ ನೀಡಲಾಗಿದೆ ಎಂದು ತಿಳಿಸಿದ್ದು, ತಹಶೀಲ್ದಾರ್ ತುಮಕೂರು ತಾಲೂಕು ಇವರಿಗೆ ಬರೆದಿರುವ ಪತ್ರದಲ್ಲಿ ತುಮಕೂರು ಮಹಾನಗರ ಪಾಲಿಕೆಯ ಗಡಿಯಿಂದ ತುಮಕೂರು ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಅಮಲಾಪುರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 39ರಲ್ಲಿ 1.20 ಎಕರೆ ಸರ್ಕಾರಿ ಗೋಮಾಳ ಮತ್ತು ತಿಪ್ಪನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 25ರ ಪೈಕಿ 5 ಎಕರೆ ಖರಾಬು ಕಲ್ಲುಗುಡ್ಡ ಜಮೀನು ಒಟ್ಟು 6 ಎಕರೆ 20 ಎಕರೆ 6.20 ಏಕರ್ಸ್ ಜಮೀನಿಗೆ ಸುಮಾರು 4.5 ಕಿಲೋಮೀಟರ್ ದೂರವಿರುತ್ತದೆ ಎಂದು ಮಾಹಿತಿಯನ್ನು ನೀಡಿರುತ್ತಾರೆ. My lord, this report is not made available to us. We were not given an opportunity to, my lord, rebut the aforesaid report. So therefore, my lord, challenging these orders, my lord, I have filed the present writ petition. I am before your lordships.
Now here in this proceeding, 2 times some.
Yes, my lord. Your lordship may kindly see, my lord, initially an order was passed by this honorable court, my lord, on 7th of February 2024, my lord. At the time of preliminary hearing, 7th February 2024. My lord, in the order, my lord, page 4 of the order, 3 weeks time is granted to the learned High Court government pleader to file statement of objections, more particularly with regard to the distance between the land in question and the boundary of the city municipal council, Tumkur. Specific information shall be provided regarding the geographical area of the municipality during the year 2002 and whether there were any subsequent changes in the geographical area of the municipalities. The land are directed not to do anything further in respect of the land in question till the disposal of the writ petition. So, my lord, they were directed to measure from the land in question till, my lord, the city municipal limits. This is the, my lord, direction issued by this honorable court.
Now,
Then,
now,
yes.
If we were to ignore that, now presently what has happened?
Now, presently, my lord, they file a statement of objections, my lord. Virtually, my lord, they say it is a denial, but there is no denial. They have virtually admitted my case.
Now, what is the latest report?
Now, my lord, initially, my lord, an affidavit was filed by the government, my lord. Afterwards, when the matter was listed, they were directed to conduct a spot inspection and comply the order of this honorable court. Then, my lord, they have filed an affidavit dated 22/7/25. I have also filed my objections to this affidavit.
The objections we have mentioned 3 kilometers and.
My lord, 22/7/25.
4.68 kilometers.
One minute, sir, 1 minute. Kindly come to page number 6, my lord. After referring to all the mahazars they have done, paragraph number 8. In the meantime, what happens is, impleading application is filed by the RTO, my lords. That impleading application is before your lordship, saying RTO is also, my lord, allotted about 13 acres of land in survey number 39. They do not say whether it is the same land in which we are in possession. There is no identification of the land that has been allotted. Now, my lord, kindly come to the affidavit that is filed by the learned government advocate on 22/7/2025, paragraph number 8. What they say is
4.69.
yes, 4.69 kilometers, my lord, by reference to document number 2 to that affidavit. That, my lord, is the document they are referring to. My lord, in spot inspection, when this spot inspection was done, my lord, there was no notice to us. Our lands were not identified. Kindly come to document number 2, my lord, in the very same affidavit at page number 9.
Correct, but now you come to the page.
Page number 9, my lord. All that I want to point out is they have not identified our lands at all. Page 9. Tumakuru so and so Kasaba Hobali Amalapura Gramada survey number 39ರಲ್ಲಿ ನಕಾಶೆಯಂತೆ kindly mark this, my lord. RTO ರವರಿಗೆ ಜಮೀನು ಮಂಜೂರಾಗಿದ್ದು ಸದರಿ ಗಡಿಯನ್ನು ಸಹ ಗುರುತಿಸಿದೆ. They, my lord, point out the land granted to RTO. Then my lord, they say ಸದರಿ ಜಮೀನು 1990ರಲ್ಲಿ ತುಮಕೂರು ಮಹಾನಗರ ಪಾಲಿಕೆ ಸರಹದ್ದಿನಿಂದ ಅಮಲಾಪುರದ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 39ಕ್ಕಿರುವ ಅಂತರವು ನಮ್ಮಲ್ಲಿ ಲಭ್ಯವಿರುವ ದಿಶಾಂಕ್ ಆಪ್ ಸಾಧನದ ಮೂಲಕ ಪರಿಶೀಲಿಸಿ ಅದರಲ್ಲಿ ಲಭ್ಯವಾದ ಮಾಹಿತಿಯಂತೆ ಹಾಗೂ ಮಹಾನಗರ ಪಾಲಿಕೆಯವರು ತೋರಿಸಿರುವ ಸರಹದ್ದಿನ ಆಧಾರದ ಮೇಲೆ ಮಹಾನಗರ ಪಾಲಿಕೆಯಿಂದ ಸರಹದ್ದಿನಿಂದ ಅಮಲಾಪುರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 39ಕ್ಕೆ 4.6 I think it is 4.68 kilometers, not 46.8. ಅಂತರವಿರುವುದಾಗಿ ದಿಶಾಂಕ್ ಸಾಧನದಲ್ಲಿ ನಮೂದಾದಂತೆ ಸದರಿ ಮಾಹಿತಿಯನ್ನು ಮುಂದಿನ ಕ್ರಮಕ್ಕಾಗಿ ಕಚೇರಿಗೆ ಸಲ್ಲಿಸಿದೆ. One is there is no notice. Second, our lands are not identified. Total extent is 27 acres, 36 guntas. They identify the land allotted to RTO. With that boundary in mind, they conduct this mahazar. So therefore, my lord, here, my lord, this is not conclusive at all. Then, my lord, document number 3 is the land, my lord, reservation done on behalf of the RTO. Then, my lord, your matter came up before your lordships. Your lordship directed, my lord, representative of the petitioner to go before the ADLR. Then, my lord, they have filed one more memo. This is filed on 10/12/25. 10/11/25. Another memo is filed. This is what they are referring to as we went on a scooter to the lands of the adella heltare idralli.
So correct, but now what do you say regarding this?
My lord, my submission is this, my lord. Let a proper inquiry be conducted by a senior officer, my lord, of the survey department.
This report is in your presence now.
My lord, this report, your lordship may kindly see, even this report, what they have said, kindly come to document number 1, my lords. Unfortunately, they don't identify my land. My lord, document number 1, page 3 of this memo. My lord, paragraph number 2.
Yes, read.
ಅದರಂತೆ ಪರಿಶೀಲಿಸಲಾಗಿ ದಿನಾಂಕ 5/11/2025 ಪ್ರಕರಣದಲ್ಲಿರುವ ವಾದಿಗಳು ಹಿತಾಸಕ್ತಿದಾರರು ಹಾಗೂ ಅವರ ಪರವಾಗಿ ವಕೀಲರು ಕಚೇರಿಗೆ ಹಾಜರಾಗಿದ್ದು ಇವರೊಂದಿಗೆ ಕಂದಾಯ ಇಲಾಖೆ ಸಿಬ್ಬಂದಿಗಳು ಹಾಗೂ ಮಹಾನಗರ ಪಾಲಿಕೆ ತಾಂತ್ರಿಕ ಸಿಬ್ಬಂದಿಗಳು ಹಾಗೂ ಪ್ರಾದೇಶಿಕ ಸಾರಿಗೆ ಸಿಬ್ಬಂದಿಗಳೊಂದಿಗೆ ಈ ಕಚೇರಿಯ ಸರ್ವೇಯರ್ ಹಾಗೂ ತಪಾಸಕರೊಂದಿಗೆ ಜಂಟಿ ಸ್ಥಳ ತನಿಖೆ ನಡೆಸಲು ಚರ್ಚಿಸಿ ಸ್ಥಳ ತನಿಖೆ ನಡೆಸಲಾಯಿತು. ಸ್ಥಳ ತನಿಖೆ ನಡೆಸಿರುವ ಮೇರೆಗೆ ತುಮಕೂರು ಮಹಾನಗರ ಪಾಲಿಕೆಯವರಿಂದ 1995ರ ಅಧಿಸೂಚನೆಯಂತೆ ಮಹಾನಗರ ಪಾಲಿಕೆಯ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಅಂತರಸನಹಳ್ಳಿ ಗ್ರಾಮ ಒಳಪಡುವುದರಿಂದ ಸದರಿ ಅಂತರಸನಹಳ್ಳಿ ಗ್ರಾಮದ ಗಡಿಯಿಂದ ಅಮಲಾಪುರದ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 39ಕ್ಕೆ ಇರುವ ಅಂತರವನ್ನು they refer to the border of the boundary of survey number 39. ಅಮಲಾಪುರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 39ಕ್ಕೆ ಇರುವ ಅಂತರವನ್ನು ಸರಕಾರಿ ವಾಹನದ ಮುಖಾಂತರ ರಸ್ತೆ ಮೂಲಕ 4 ಕಿಲೋಮೀಟರ್ ಹಾಗೂ ಅರ್ಜಿದಾರರಾದ ಸಿದ್ದಪ್ಪರವರ ಮಗ ಮಂಜುನಾಥ್ ರವರ ದ್ವಿಚಕ್ರ ವಾಹನದ ಸಂಖ್ಯೆ ಸೋ ವಾಹನದಲ್ಲಿ ಕೆರೆ ಏರಿಯಾ ಮಣ್ಣುದಾರಿ ಮತ್ತು ರಸ್ತೆ ಮುಖಾಂತರ ಮೀಟರ್ ರೀಡಿಂಗ್ ಸಂಖ್ಯೆ ಸೋ ಅದರಂತೆ 3.6 ಕಿಲೋಮೀಟರ್ ಇರುತ್ತದೆ. ಅಂತರವನ್ನು
your client's motorbike shows lesser.
My lord, I do not know which way they have taken. My lord, what they have done, my lord, is to the boundary, my lord, of survey number 39.
Correct. Even if you were to take that, your property cannot be more than 1 kilometer.
My lord, there are several properties, my lord, because there are 13 petitioners.
Even if it says 29 acres, it cannot be more than.
No, because earlier report says 4.7 kilometers, 4.68, roughly 4.7 kilometers, which is hardly 300 meters, my lord, to come to 5 kilometers.
Let us see.
Because in fact, my lord, they have filed land grabbing before the land grabbing court, my lord, they have filed a petition. Adralli sketch madidare. This is a sketch that they have done. They have identified, my lord, where we are.
Let us see, but you are a part of this. Your motorbike was a living witness to it. Let us.
My lord,
no, but then there is no end to it. There is no end to it.
Let there be, my lord.
No.
All that I'm asking, my lord.
Not more than 2 times. Not more than 2 times.
Let there be, my lord, senior officer, my lord, of the survey department. Let him, my lord, do the survey, my lord.
No, let us see. The petitioners have is motorbike or scooter? Scooter. The petitioners have called in question the correctness of the order passed in RA 12 of 2011 on the file of the Deputy Commissioner Tumkur, comma, RA 9 of 2003-4 is order passed by the Assistant Commissioner Tumkur Subdivision, as well as proceedings before the Tahsildar in LND RUC within bracket KAAS 38:1999-2000. Full stop. Petitioner has also sought for a writ in the nature of certiorari to set aside the order at Annexure F passed by the Deputy Commissioner, comma, order at Annexure D passed by the Assistant Commissioner, and endorsements communicating the decision dated 30th May 2004 passed by the Tahsildar and Secretary Committee for Regularization of Unauthorized Occupation. Full stop. It must be noticed that the petitioners herein claim to be an unauthorized occupation of portions of land in survey number 39 of Amlapura village and are stated to be cultivating for the past more than 30 years. Full stop. Next, they had submitted application for regularization of their unauthorized occupation in Form 53. The respondent number 4 herein, who is the Tahsildar, had issued endorsements to all of the petitioners on the ground that the land sought to be regularized is within 5 kilometers of the city municipal limits. Full stop. The petitioner submits that such finding is contrary to facts insofar as the Assistant Executive Engineer, Public Works Department, in his report dated 24/3/2005 has stated that the lands in survey number 39 of Amlapura is at a distance of 9 kilometers from the municipal limits. In light of such facts, the endorsements of the Tahsildar came to be challenged before the Assistant Commissioner, who by order dated 15/9/2010 has dismissed the appeal, and against such order, second appeal was filed under section 50 before the Deputy Commissioner, who has affirmed the order of the Assistant Commissioner. Full stop. Such order has been challenged in the present proceedings. Full stop. It is to be noticed that during the pendency of the present proceedings, this court, by order dated 7/2/2024, had directed a factual assertion of distance between the land in question and the boundary of the city municipal council Tumkur. Full stop. The AGA had placed before this court records relating to ascertainment of the distance, while pointing out that the distance was within 5 kilometers, and accordingly application of the petitioner, it was stated, was ineligible and rightly rejected. Full stop. However, the counsel for the petitioner had challenged the first report relied on by AGA, prepared pursuant to the order of 7/2/2024. Full stop. This court subsequently, by order dated.
No, I think
30/10/25.
yes.
Huh?
No, I think it is 5/11/25.
6/11/25.
By order dated
6/11, before that, before 5. No, 30/10/2025.
By order dated 30/10/2025 had directed the ascertainment of situation of the property from the municipal limits, and the petitioner was asked to be present. The AGA has filed a fresh report by way of memo dated 10/11/2025, and once again it is the report would reveal that the property of the petitioner is within 4 kilometers. Accordingly, AGA submits that the orders impugned require to be affirmed. Next, it must be noticed that in terms of section 94A,
Yes.
in terms of section 94A,
Second proviso. 94A clause 4, second proviso.
it must be noticed that section 94 capital A of the Karnataka Land Revenue Act provides for regularization of certain cases of unauthorized occupation by constituting committee, full stop. However, the power to regularize unauthorized occupation is circumscribed by a restriction under the second proviso to section 94A. Full stop. The second proviso to 94A reads as follows. Extract second proviso along with table. Full stop. In the present case, it is not in dispute that the point of reference would be the boundary of the city municipal council. City municipal council.
As on that day, city municipal.
Full stop. In terms of the second proviso extracted above, no land shall be granted in areas lying within the limits prescribed in the table. The table at item 3, at serial number 3, provides lands which are within a distance of 5 kilometers from the city municipal council. And that would be the understanding of the reference made to the serial number 3 in the table. Full stop. In the present case, it must be noticed that the endorsement of the Tahsildar at Annexure B series issued at the first instance was that the lands of the petitioner were within 5 kilometers from the radius of the Tumkur City Municipal Council.
Yes.
Full stop. These endorsements at Annexure B series were called in question before the Assistant Commissioner in RA 9 of 2003-4. The Assistant Commissioner has rejected the appeal of the petitioners, reiterating that the properties are situated within 5 kilometers. Full stop. Such order was taken up before the Deputy Commissioner in terms of RA 12 of 2011-12 by way of a second appeal. Deputy Commissioner has affirmed the orders of the Assistant Commissioner. The Deputy Commissioner refers to a report of the Public Works Department dated 21/9/2019, which would indicate that the land of the petitioners was 4.50 kilometers within the limit of the city municipal limits. Full stop. And such order has been challenged in the present case. It must be noticed that there are concurrent findings by the Assistant Commissioner and Deputy Commissioner. Full stop. No doubt petitioner had contended that the order that the proceedings of the Public Works Department dated 21/9/2019, whereby the Deputy Commissioner had recorded a finding that the properties of the petitioner is within 4.50 kilometer of the municipal limit was not made available to the petitioner, and the report at Annexure E produced along with the writ petition would indicate that the village in which the land is situated, that is the village of Amlapura, is 9 kilometers, as is made out from the proceedings of Public Works Department itself, dated 24th March 2005. The ambiguity by the report at Annexure E was sought to be cleared by this court in its order dated 7/2/2024, which directed the ascertainment of distance between the land of the petitioner and boundary of the City Municipal Council, Tumkur. Full stop. Pursuant to such order, it is noticed that the state has filed an affidavit on 22/7/2025 and had relied on certain proceedings at document number 1 and 2, which would indicate that the property was situated at a distance of 4.68 kilometers. Full stop. However, petitioner had objected to such report, stating that the same was conducted behind the back of the petitioner.
Yes.
Full stop. However, it must be noticed that once again, the court, by order dated 30/10/2025, had directed ascertainment of the distance in the presence of the petitioner. Full stop. AG has filed a memo with production of documents on 10/11/25. The report of the Assistant Director of Land Records at document number 1 dated 6/11/2025 would indicate that the properties are at a distance of 4 kilometers. Full stop. There is a reference also to the petitioner Manjunath, son of Siddhappa, also being present during such process, including traveling in his vehicle KA06HQ5372, which would also record that the distance is less than 5 kilometers. Full stop. Para 2 of the report, document number 1 filed along with the affidavit, reads as follows. Next. It must be noticed that in light of the concurrent findings by the Assistant Commissioner as well as the Deputy Commissioner, as well as reports on 2 occasions made by the officers of the Revenue Department pursuant to orders of this court, there is a consistent finding that the property of the petitioner is within 5 kilometers. The order of the Assistant Commissioner as well as Deputy Commissioner having findings of fact regarding distance being concurrent, no grounds are made out for interference with the said orders. The submission of counsel for the petitioner that a senior officer may once again conduct measurement deserves to be rejected, as the measurement on 2 occasions pursuant to orders of this court by officials and reports of whom are part of record clearly indicate that the distance of the properties of the petitioner, which is a subject matter of application for regularization, is within 5 kilometers. Accordingly, the impugned orders are affirmed and the petition is rejected. Yes.
Okay.
Say number 18, Jairaj DS. Manoj.
My lord, should we see your last order, my lord? Says in order to ensure quietus to the issue, Tahsildar to conduct survey in the presence of the petitioners as well as respondent number 7. So the report is awaited.
The report is?
They have to submit the report.
The report is ready, my lord. I'll give a copy to the other side. Show it to your lordship that there is a.
Without giving us copy, my lord, what this is?
I'll give a copy, my lord.
You furnish it to him.
The Tahsildar had not signed, he has just come. I'll serve a copy now.
Sir, serve a copy, we'll take it on record and we'll have it immediately after. But prima facie, what is your finding?
There is a land, if your lordship may kindly see the sketch, my lord.
Let us see. You furnish a copy, you take your stand in writing.
No, I'm not. There are two issues, my lord. One is, my lord, they have said that we have encouraged about two and odd guntas of land, my lord. But, my lord, we had approached this court, my lord, when the notice was given to us. There is an order of this honorable court, my lord, which says that you consider their documents and pass order. Now, no such order is passed nor communicated. The order of this honorable court said the order will be kept in abeyance for 2 weeks until it is communicated, after it is communicated to me. No such order is communicated. They have come and demolished the property. This is highest, my lord, arrogance of authority, my lord. Now, they have to file on affidavit, my lord, who has taken this decision to demolish my property.
Lord, with regard to their land, whatever survey number 91, what the extent of layout they have done, we have not touched upon anything. Your lordship may kindly see the sketch for just a moment, my lord. There are two colors. One is yellow.
Okay. Now you furnish it to him.
I will furnish just for a
AGA.
sec.
No, let us see. AGA files a
This
report.
was done in presence of the petitioners, my lord. They
AGA
have
files,
signed also.
AGA files a report along with sketch. Same is taken on record. It's the assertion of the state that the property of the petitioner has not been touched.
Only with
No,
regard
my
to state property, whatever they have acquired, that property we have just demolished.
It is the assertion of the AGA.
Authorizedly, which was occupied by them, it's a state property.
That the encroachment by the petitioner of property belonging to the property acquired only has been demolished and has been demolished, full stop. Now, senior counsel appearing for the petitioner would submit that demolition is with respect to property of the private property of the petitioner.
Look, kindly see page 213.
Let us see.
Just give me 1 minute. Page 213.
No, but you'll have to have a look at the survey now.
No, I will have a look at it, my lord. There is the second issue, my lord, of how they can demolish without passing an order. Page 213. My lord. Now, please come to page 215. My lord. This is a notice which was issued to me, which said, my lord, that power under section 39 and 104, my lord, is being invoked. And they said, ಆದ್ದರಿಂದ ಈ ಹೊರದೂಡುವ ನೋಟಿಸ್ ಜಾರಿಗೆ 7 ದಿನಗಳಿಗಾಗಿ ಈ ಕೆಳಕಂಡ ಜಮೀನು ಖಲ್ಲಾಪಡಿಸಲು ಆದೇಶಿಸಿದೆ. Now please see overleaf, my lord. What they have noted there, my lord, ಅಕ್ರಮ ಒತ್ತುವರಿ ಹೆಸರು ವಿವರ, my lord. This is my property, 210. Now, my lord, now please see the operative portion, my lord, at page 218. Lord, this honorable court at para 4, my lord, I'm sorry, 217 said, treat this as a show cause notice and Lord, and consider the matter, my lord. After that, my lord, this honorable court said, ordered accordingly, writ petition is disposed of. It is made clear that the order to be passed shall not be given effect to for period of 2 weeks after it is communicated to the petitioner by registered post acknowledgement due, my lord. Now, my lord, this has not been done by them. And yet my property is demolished after this order. So they have to place on affidavit, my lord, the name of the person who has taken the decision to demolish the property.
Lord, senior counsel would assert that the directions in WP 18898 of 2022 regarding order to be passed after construing the notice for eviction, which was the subject matter of challenge in WP 18898 of 2012, to be a show cause notice, has not been complied with. AGA, on the other hand, would submit that the encroachment was ascertained in the presence of the petitioner and relies on the sketch filed along with the report.
No, my property is demolished much earlier, my lord. It is demolished in August 2/8/2023.
Let us the petitioner to take their stand in writing insofar as the report and the sketch. The court reserves liberty to direct the government authorities to furnish further details if it were to be found that the property demolished was in fact private property. Relist the matter in the week commencing from
27th of
Thereafter, tomorrow, reason is this, we are going to construction the property. We have already issued the work order. Kindly see this part of document.
Let us
Lord, I am ready to argue now itself, my lord.
No, let us see.
Only survey number 91 only 5 guntas allot. As per the boundary, what they have claimed that encroached to a demolition. Further, if 91 survey number of property there. Namda allot ಆಗಿರೋದು only 5 guntas ಅಷ್ಟೇ. My lord, ಬೌಂಡ್ರಿ ಪೂರ್ವಕ್ಕೆ ಸರ್ವೆ ನಂಬರ್ 91ರ ಉಳಿಕೆ ಜಮೀನು, ಪಶ್ಚಿಮಕ್ಕೆ ಸರ್ವೆ ನಂಬರ್ 91ರ ಉಳಿಕೆ ಜಮೀನು, ಉತ್ತರಕ್ಕೆ ರಸ್ತೆ, ದಕ್ಷಿಣಕ್ಕೆ ಸರ್ವೆ ನಂಬರ್ 91ರ ಉಳಿಕೆ ಜಮೀನು. There is no question of encroachment or none construction stall ಮಾಡೋದ್ರಲ್ಲಿ there is no meaning, my lordship. You have already issued the work order.
No, but he has to have a look. Have you had a look at the sketch?
That's what, my lordship.
Have you had a look at the sketch? Nobody has seen. Let him give copies.
Then when you have done there, therefore
No, I'm not here on behalf.
Otherwise, interim order cannot be extended, my lord.
But there is an interim order not to construct, because construction is going on in my property.
No, my lordship. None. That's what survey. ಅದಕ್ಕೋಸ್ಕರ ಅವ್ರ ಮುಂದೆನೆ ಪ್ರೆಸೆಂಟ್ ಆಗಿ ಇಟ್ಟು ಸರ್ವೆ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು.
Lord, who has decided that there is encroachment?
My lords, moreover, there is their properties belongs to Chandan Hosalli. This survey number belongs to survey number 91 of Sompura. That is Gundopu, my lordship.
Let us see. I'll fix a date on the reopening day.
Yes, my lord.
After tomorrow,
No,
we already issued the work order.
Maybe
Work is
nothing.
already going, my lord.
You will have to wait. There is some procedure. Now, no doubt the sketch supports your contention, but let him have his say. We'll have it. This is the matter in the same stage on
Reopening date, my lordship.
on 5th of January.
Yes.
6th of January.
Interim order.
AGA to furnish copy of the report and sketch to counsel for the other respondent as well as the petitioner.
Do it now itself.
Petitioner.
That is the only copy. I'll just take a Xerox and I'll
Yes.
paste.
Interim order in subsistence is extended till the next date. In light of urgency pleaded by private respondent, matter both sides to be ready on the next day.
Next day.
Yes.
19, Chetan, Chandrasekhar.
Appearing for the fifth respondent, my lord. Your lordship, I have heard the argument.
Your lordship may permit me 1 more week's time to file the adjournment, or file my rejoinder to their objections, your lordship.
My lordship.
Because petitioners are from Mysore and they've been unable to travel. They're in fact coming today. I'll secure their signatures on the affidavit and I'll
Heard this matter. Now, if you, after hearing what happens again, it has to start.
Your lordship, I'll only need 1 day's time, your lordship.
My lordship, if I make my submission, on 19th of the argument ಆಗಿದೆ, first 2 weeks granted, again first they have taken 2 weeks granted, my lord, and there is a serious allegation. The petitioner have played a clear fraud and the documents are available before this honorable court. They don't even have the locus standi, my lord, the documents are available with you. And also, there are 3 basic questions asked. 3 different PTCL, 3 different order passed by the same authority, whether it is sustainable. one, my lord. The second is ignoring the.
Now, what you want to file now?
Your Lordship, we are filing rejoinder to the statement of objections.
I will not, no, now it's on the material on record only we can decide what rejoinder you want to file.
No, Your Lordship, they are claiming.
Tomorrow, you can do whatever you want. I'm not going to give further adjournment. Relist tomorrow.
Great.
My lord, same stage.
Interim order. Interim order, Your Lordship.
Is extended till the next day.
Achho.
Two times we have heard, we have given you time.
Apologies.
Yes.
20, Suman Tel Balaji, connected matters. Serial number 20.
Yes,
My lord, the petitioners are all ex-servicemen.
if it has to be decided after vacation, not now. Relist the matters in the proceedings are complete.
One case we have filed the statement of objection, we will adopt to all the other cases.
AG submits the statement of objection filed in WP
7856,
7856 of
2019.
2019 would be adopted insofar as the other matters are concerned. Necessary memo to be filed. Now relist the matter in the same stage in the week commencing from. Yes.
21, Sukumar V.
Four in this case.
Yes, Sudhindra.
Filed a application for vacating of interim order. Whereas they are challenging Your Lordship, the annexure Q and T passed by the additional assistant commissioner and district deputy commissioner White. 21 White RA number 97 of 2023 and 24. And kindly peruse the, am I permitted to read the page number 19 and 100 of the annexure T, which is the.
No, what are the facts?
Let me place the facts, my lord. The petitioner, the originally land belonged to one Kadirappa. During his lifetime, he entered into a sale agreement. By receiving advance, advance consideration, he executed a sale agreement on 29/6/1990. Unfortunately, he demised subsequently. Thereafter, his wife, since they did not have issues, his wife being sole legal heir of Kadirappa, executed a sale deed on 17th of December 1993 in my favor. Based on the sale deed, mutation was made to my name during the year 1993-94, which continued till the passing of the order by the assistant commissioner during the year 2021-22. After lapse of more than a decade, the contesting respondent filed a suit in OS number 262 of 2014, seeking the comprehensive relief of declaration of ownership, contending that Kadirappa during his lifetime executed a will bequeathing the property in question in her favor, being foster daughter of him. Your Lordship, kindly see, the sale deed dates back to 93. Mutation also dates back to 93. Suit was filed during the year 2014, which ended in dismissal for non-prosecution on 12th of September 2017. When
now the will was executed according to them by
Kadirappa, my vendor, my vendor's husband.
When did Kadirappa die?
He died on
1991.
31st of August 1991.
Now the sale deed in your favor.
Yes, my lord.
Was by his wife.
Yes, my lord. He did not have issues. So she, being absolute owner, executed sale deed.
The suit was dismissed for non-prosecution.
Non-prosecution on 12th of September 2017. Subsequently, an appeal has been filed before the assistant commissioner challenging the mutation passed during the year 1993 in my favor.
Under 136(2).
Yes, my lord.
What happened to that?
Appeal has been allowed by the assistant commissioner, directing the Tahsildar to mutate the entries after giving opportunities to the parties. which order has been challenged by me before the Deputy Commissioner. The Deputy Commissioner, observed the jurisdiction of the civil court, reached to the conclusion as there is a will executed by the Kadirappa. So whatever the order passed by the Assistant Commissioner is correct. My respectful submission is when the suit filed by her was dismissed, that too for declaration, and will has not proved before the Honorable Court, and there is a lapse of more than a decade, 1.5 decade.
Will is registered or?
Yes, my lord, it's registered. It's registered.
And that is under question, and the seal of the petition is under question, and subsequent dismissal of my suit, I have prepared miscellaneous that is pending for evidence. 20th one 2020, it is for evidence.
Correct. So let them be heard now. What is the urgency on this part of the vacation?
Yes. Now, presently, I am the possession of the property, and all the title mutation also entered in my name. I could not able to fetch the fruits of my land, and that part there is a stay against me in miscellaneous petition, not to change, not to alienate the property in favor of third parties.
Your Lordship,
I am being the
So what is the interim order passed?
Interim order is stay of the order passed by the Deputy Commissioner and the Assistant Commissioner.
And subsequently, Your Lordship, Annexure B, am I permitted to read?
No, Annexure?
Annexure B.
No, I'm saying now what is the urgency? On this part of vacation, what is the urgency?
No, there is.
It has to be heard, isn't it?
Yes, this is, there is,
Now your suit is rejected.
I have filed miscellaneous.
Correct.
Miscellaneous after lapse of 3 years, my lord.
My evidence. My evidence.
Now the entry is in whose name?
My name. I have filed along with my objection. Annexure R4.
Entries on the basis of
RTC and present mutation is in my name, Venkatamma.
entries were made subsequent to passing of order by the Assistant Commissioner. 2023 ನಂತರ.
Just one. Now how are you aggrieved by this order?
No.
It has to be decided, isn't it? Then you wait. This not on this part of the vacation. We'll have a date immediately after vacation. You sort it out. Let us.
No, what I request this honorable court, there is a stay against me in miscellaneous. I accepted that. I undertake to. I am not to unite in favor of third party till disposal of the miscellaneous. I am in the possession of the property, and they have admitted.
No, we never admitted. We are in possession and enjoyment till date.
It is a grant land. 1978 in favor of my foster father.
We are not on the merits of it.
Yes,
I'm saying I'll fix a date immediately after vacation. You argue and let it be disposed of.
Please, ma'am.
Till then, interim.
It has to be decided how we can vacate the interim order without deciding the matter.
So subsequently, kindly peruse the annexure B. Annexure BL. That has been not challenged by this petitioner also. Annexure B. Permitted read at page number 103, footnote. ಖಂಡಿಕೆ 1ರಲ್ಲಿ ವಿವರಿಸಿರುವಂತೆ ಹಾಗೂ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯ ಆದೇಶ ಸಂಖ್ಯೆ RA 437 of 2022 ಕೈವಾರ ಹೋಬಳಿ ಹಿರೇಪಾಳ್ಯ ಗ್ರಾಮ ಸಭೆ 21ರಲ್ಲಿ 1 ಎಕರೆ ಜಮೀನಿನ MR 9593 ಅನ್ನು ರದ್ದುಪಡಿಸಿ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಬೇಕೆಂದು ಖಾತೆ ಬಡಾವಣೆ ಮಾಡುವ ಬಗ್ಗೆ ಇವರ ವಿರುದ್ಧ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳಿಗೆ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿ ಮೇಲ್ಮನವಿ ತಿರಸ್ಕರಿಸಿ ಆಗಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಮಾನ್ಯ ವಿಭಾಗಗಳ ನ್ಯಾಯಾಲಯದ ಆದೇಶ MR 95/94 ರದ್ದುಪಡಿಸಿ ಪತ್ರದಂತೆ ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡುವ ಬಗ್ಗೆ ಕಡತವನ್ನು ಮೂಲ ಶಾಖೆ ಕಳಿಸಲು ಆದೇಶಿಸಬಹುದು ಆದೇಶ ಮಂಡಿಸಿದೆ.
Now this order of 13/11/24 is it before or after the DC order?
Subsequent order of DC.
Correct. So let us see, let it be heard. Now how are you prejudiced? You are in possession? Then
Yes,
we have not stated anything about possession. The matter requires to be heard and disposed of. IA for vacating stay has been filed. However, the decision on the application for vacating stay would involve deciding on the merits of the matter itself. Full stop. Relist the matter in the same stage on
First week of January.
Interim order may kindly be extended.
On 12th of January. The modern operation is extended till the next date. Both sides to be ready.
Please.
Argue the matter on the next date.
Great.
Much.
Blood proceedings under section 136(3) have been initiated. Blood annexure H is the order. Under which blood proceedings have been drafted saying that blood grant is denied. When the petitioner is approached the Tahsildar and Revenue Inspector, blood they says that blood grant is suspicious.
Referring an
No, let us see.
appeal, referring an appeal to the regional commissioner on the order of the deputy commissioner.
AGA files.
Blood, let them make effect mutation. Blood thereafter, bloods subject to the appeal. Bloods let the mutation may be continued. Bloods.
Let us see.
Not yet filed appeal.
No, this is. Have you filed by now?
You've written a letter. Written a letter to the regional commissioner has taken note of it. He'll have to initiate proceedings.
AGA files along with memo communication dated 26/6/2025 addressed to the regional commissioner and submits that they intend to file appeal under
56, section 56.
Section 56. Same is taken on record. AGA to submit whether any action has been taken pursuant to such communication by the next date. Noticing the communication is of 26/6/2025. Needless to state, if no further action is taken, court may be constrained to consider the relief sought for in the petition. Relist the matter in the week commencing from
27th of January.
Let them effect the mutation subject to this.
Let us see by the next date. In case they don't, we'll consider.
Immediate first week.
Let us see. Let us.
23.
Yes.
Lord, the Tahsildar has forwarded, my lord, the papers before the assistant commissioner. My lord, the assistant commissioner, my lord, has to be effected entries, my lord. In this regard, my lord, direction has been issued to keep present.
Done, my lord, may I file a memo?
Put it. It's done. Yes. But why does it require so much of strain?
My lord, that thumb impression, there's an entire
Correct,
procedure for
correct.
demolition.
But then some system you must have, isn't it? Except for Nandish getting one more brief. The present petition has been filed seeking for issuance of writ in the nature of mandamus to direct respondent number 4 to consider representation of the petitioner and restore name of the petitioner and revenue records. Full stop. AGA files memo along with copies of RTC. Full stop. It is seen the name of Shiv Kumar, son of Chandrappa, is shown in column number 9 as well as column number 12. In light of such restoration of revenue entries, petitioner submits no further grievance subsists. Accordingly, taking note of the effecting of mutation, taking note of restoration of revenue entries.
Yes, madam.
In the name of petitioner, matter is disposed of as not calling for any further adjudication.
Please, 24, Kashyap.
Lord, sir, petition filed seeking restoration of revenue entries.
Yes.
My lord, sir, I was my previous vendor, that is Mr. C. Rangara, was the owner of about 10 acres of land in survey number 148. Now, my lords, in 1995, this was granted to Mr. Rangara by way of Growmore scheme. In 1995, the deputy commissioner allots.
My lord, I filed a memo on the last occasion, my lord.
Certain documents are placed, my lords, to say that there was a consideration, there was an order passed by the Tahsildar in the year 2000.
I submit this matter needs a bit of submission, my lord, if I make it wrong. Lordship has the memo that I have filed.
No, I'll also take your honors
Claims
through.
to have purchased the land. Petitioner claims to have purchased the land from the original grantee who claims has been granted land under the Gromor scheme. They refer to several petitions filed by them. Your Lordship put down to petitions at annexure.
If it requires some detailed hearing, I'll have it after
My
vacation.
lord, my only, the petitioner's grievance is that his request has not been considered. My lord, all that we are saying is that there was subsequent to all the petitions.
What was the
referred to-
request? Request was for?
Restoration of revenue entries, my lords.
We are saying that they were never in possession. Apart from the petitions that they have referred to, where there were directions issued to the respondents to consider representation, there was also another petition filed by the grantee and the legal heirs themselves, for which the matter was remanded to the tehsildar to consider genuineness of the records. Thereafter, the tehsildar has passed an order saying these grants seem suspicious, they are not genuine. They have not filed any appeal against that order. That order I filed along with my memo. Thereafter, an endorsement has also been issued to the legal heirs of the said grantee saying that this is not genuine, you were never granted lands, you were never in possession. They have not challenged. Now, the petitioners claim to have purchased from those grantees who were party to those proceedings, and they were issued with an endorsement. So we are saying now whatever you are claiming rights to, that itself has been negated unless there has been a
Correct,
challenge to
but
that.
right or wrong, there's a sale deed. No?
My lord, when they had no rights. In fact, if
Correct.
your
But
lordship.
then what would happen? Whether that has to be challenged or ignored? What is the legal position you look
But
in?
it is not up to the state to restore the revenue entries when they are saying they had no grant whatsoever. If the people claiming to have been granted lands have sold the property, then the state should not have to restore the
No,
land.
but-
We are saying there were no grants made under the Gromor scheme.
No, we'll consider, but you take it in writing. Take your stand in writing. Now, his only contention will be that under 128, once there's a sale deed, you're obliged to, you cannot challenge the validity of the sale deed in this proceeding. You take your stand writing.
My lords, may I make
That
We
too.
are not challenging, my lord. We are saying.
No, correct. So his contention would be under 128, once the registered sale deed is there, you will have to effect and restore it. You may not be in a position to not restore the revenue. That may be, so you take it in writing.
May one submission may I make, my lords. Already this honorable court has granted a mandamus to consider my representation. In the year 2017, this single judge of this honorable court has already issued a direction which they have not complied so far. If this document actually existed, what they're submitting in 2000, they could have produced this because this writ petition was pending for a period of 2 years, subsequent to which it was disposed of. If these orders were passed, they could have actually produced it before this honorable court. Now, after 20 years, they come up with this order which may not be.
AGA to take their stand in writing, list the matter in the week commencing from
7th of January.
Lords, it may have taken as part heard, my lords.
Vinay Swami, see? 25, Vinay Swami.
Lord, last occasion, with regard to my land, my lord, subsequent to I purchasing the property from the original grantee, my lord, that is a sale deed dated 14/12/2005. RTC and the mutation was transferred in my name. I am in possession of the property. Even today, I am cultivating mango crop in the said land.
Hodi and Durasti.
I filed for there's a mandamus by this court directing them to consider my representation.
The original grantee, my lord, sold the property twice. The petitioner seems to be the first, based on the first sale deed. So the second subsequent sale deed, my lord, that purchaser ends up seeking for a 4D, and a separate survey number is given in his favor. Now we've written to the assistant commissioner asking to cancel.
Who is the first purchaser?
Petitioners, sir.
And I have nothing to do. That land which new survey number has been given.
So we'll have to
They have-
cancel that. We'll have to cancel that 4D, my lord. Set aside that survey number and then, my lord, do the 4D because for the
Lord, that there is a layout being formed after conversion that is half a kilometer away from my land. It is not, the new survey number is not on my land. It is a separate land which they have encroached. I don't know what they have done. They could basically.
No, now they are going to do something. We'll take this on record and we'll call it. Meanwhile, we'll find out what steps they're taking. They're saying they're going to do it, but after some procedural formalities, which they're placing on record. So we'll call it, let us see what steps they take.
The only thing which I would like to bring it,
endorsement is
they're
in the next-
forming a layout, then they will sell it to third parties. They should act quickly, my lord, because otherwise third parties also in that land, which is nothing to do with me. I have nothing to bother about it.
AGA files along with a memo, a communication addressed by the Tahsildar to the Assistant Commissioner. Same is taken on record. AGA submits that they would take necessary steps insofar as request of the petitioner, but there are certain rectification of earlier PODI records. Relist the matter when you
Third week.
in the third week of January.
Date may be German.
27.
Yes.
26, Mohammed.
Petitioner.
Yes.
There's another writ petition that is pending.
Hmm.
Be called along with that writ.
List along with the
My lord,
WP number.
kindly see annexure 50, page 15, annexure A, my lord.
they're saying there's another writ petition pending.
Till then, my interim prayer may kindly be granted. They are trying to affect the, insert the name in my Pahani, RTC, ಬೇರೆಯವ್ರ ಹೆಸರಾಗು ಟ್ರೈ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ. ಇಂಟರ್ಮ್ ಪ್ರೇಯರ್ ಕೊಟ್ಟು ಅದು ಕನೆಕ್ಟ್ ಆಗಿ ಎರಡು ಜೊತೆಲ್ಲ ತಗೊಳ್ಸಿ ಮೇಲೆ.
But we don't know what that is filed for. No, we can't pass conflicting orders.
My lord, the petitioner, now recent petitioner is the
let us see.
Defendant
We'll have it day after
who
tomorrow.
suffered a judgment and decree.
Let us see, we'll have it, you take a chance day after tomorrow. List along with the WP 18677 of 2025 on.
The interim prayer may kindly.
When it comes up, we'll see what is.
6th of January.
Yes.
27. 27. Ritesh D. Nayak.
Weeks time granted to take necessary steps.
Lord, here they've arrayed Hassan Taluk. Lord, it's actually Chandraipatna Taluk.
The petitioner AGA submits that the petitioner is required to array the
Chandraipatna Taluk.
respondent number.
No, they've my lord arrayed it as Hassan Taluk. It has to be Chandraipatna Taluk.
Submits that the petitioner is required to array officers, revenue officers of Chandraipatna Taluk and not Hassan. Petitioner to take appropriate steps by the next date.
28, Malvesh.
Mandamus, my lord, to consider the my lord representation, to do survey, my lord, sketch and my lord haddubastu of the my lord the land of the petitioner.
Lord, it's I've just been informed it's already done. I'll just hand over the lordship may pass over, my lord, and just hand it over.
Pass over.
Twenty-nine.
I'm for the petitioners.
2 to 8. They may filed an
My lords,
application copy as.
I filed. It is duly served on the council appearing at this civil court. My lords,
May.
I have challenged.
What they are saying that they have served to the council who represent the case before
My lords, the petition is
Civil court.
duly served.
May I seek for
Petition
an-
is duly
I-
served.
You have to serve him, isn't it?
I have not been served.
You have to serve him, isn't it now?
Let them furnish the copy, I will file objection because there is a status quo order granted by this on the court at the first instance.
My lords,
It is related to a road.
No, now you serve a copy to him. Serve a copy to him.
lords, I have challenged the impugned order passed by the Tahsildar Mudgere, pertaining to which he had already issued an endorsement saying that he cannot entertain this complaint.
I will file the objection.
My lords,
No, now what has happened now?
Status quo order has been
Millards,
granted
there is-
to use the road. The dispute is between the parties to in an extent of road is concerned. My lord, they are owning more than 70 acres of land.
After that, I am owning only 4 acres of land. They are now obstructing that road to reach my property, to cultivate my land. It is a coffee plantation. They are owning 70 acres of land. My lord, there was a civil suit. Injunction has been denied. MA also dismissed. When we approached this honorable court, they entered caveat. And this honorable court directed both the parties.
My learned friend,
Just wait.
Maintain status quo with regard to the road is concerned. It is still in operation. I may be, in this case also, your lordship has directed the parties to maintain status quo. Let that order may continue. I may be permitted to file objection to this one. And I'll place certain documents also. What happened in this case, my lord? Earlier, there was a 3 guntas of Karab land shown as road. In the subsequent survey, that Karab has not been mentioned. Later on, again, the survey has been conducted. A recent survey has held that unfortunately, that 3 guntas has been left out as Karab. And now again, the Karab has been shown. Based on that, it has been directed to not to disturb the road, which is only 3 guntas. Otherwise, I could not reach my property at all.
Yes, government voted.
Not.
So then we have to hear the matter.
I'll file objection. I'll place the documents also before your lordship.
Millards, only one submission. I have secured an injunction against respondent number 2 and his agents and henchmen not to trespass into my property. There is a police protection order in my favor. And there is a categorical finding of the civil court that they need not pass through my property. When this order,
Where is that order?
Millards, OS number, in page number 162 onwards, Millards. In OS number 449. And this
Annexure
D3, my lord.
D3, that is the order.
Now this is a suit between
respondent number 2 and petitioner number 2 and 3 Millards, in which suit scheduled property includes 2 of the survey numbers which have been mentioned in the complaint before the Tahsildar. Now, this order gets passed on 8th of October 2021. Soon after, this respondent number 2 files a complaint. And he also files an appeal before the assistant commissioner. While these two proceedings, they get challenged before the coordinate bench of this honorable court. Coordinate bench has passed an order directing us to go before the appropriate authority to place all the material. When this is, and he has reserved the matter. Tahsildar has reserved the proceedings for passing an order. In such a situation, in another complaint, respondents have filed multiple complaints to negate this stay order of the honorable trial court. Now they.
Where is the order of the coordinate bench?
Let's say. In page number 417 Millards. And in pursuance of this, I have placed all the material.
Page
417 of my petition. There were 2 proceedings. One was before the Tahsildar, and there was one proceeding before the assistant commissioner. Assistant commissioner, along with the additional set of documents what I have produced, has disposed this matter, relegating the matter to the civil court, saying that under any action under section 133 in which respondent number 2 had filed an appeal before him, it cannot be entertained when civil suits are pending where public space is not involved and public nuisance is not created. No action is warranted under 133.
Where is that order?
Let's have produced with a set of documents on 20th of November 2025. The first of the document. When thus stood the situation.
Why are you jumping now? Where is that document? Filed along with?
Yeah.
Along with?
Along with one.
Additional documents.
Additional documents.
On 25th November.
Yes, my lords.
Page?
Page, first of the page, my lords.
Now this
That is Assistant Commissioner's order.
In this, who are parties?
Respondent number 2.
Girish or Satish?
Girish and Satish, they are the first of the respondents. The complainant is DH Vasantappa, the second of the respondent in this writ petition, against whom who have instigated this, who have misled this Tahsildar to pass this order. His senior officer has relegated the matter to the civil courts, and he seized of the matter in other complaints where all material has been placed before him. He chooses not to pass an order in that proceedings, and he passes this order on 22nd of April.
Now, what is the operative portion of this order?
Let's operative part of this order. He basically says
Page 4.
509 millets.
No, I'm saying order of
Assistant Commissioner.
Yes. Now, your survey numbers 306 and 308.
Yes, millets. Millets. He says Mudugire Taluk Gonibit Hobli Devrunda Gramada survey number 306 ಮತ್ತು 308 ಪ್ರದೇಶವು ಖಾಸಗಿ ಜಾಗವಾಗಿದ್ದು ಸದರಿ ಪ್ರದೇಶವು ರಸ್ತೆಗಳು ಖಾಸಗಿ ರಸ್ತೆಗಳಾಗಿರುವುದರಿಂದ
This order is passed on 13/10/25.
Yes, my lords.
Now, what is the impugned order that you have challenged now?
My lords, the impugned order what I have challenged is in a proceeding where these respondents have filed a complaint against me in particular, saying that I am obstructing them not to access their property. Now, this similar complaint is pending before Tahsildar. Where as per the direction of the coordinate bench, I have placed all material. He has reserved the proceeding to pass an order in this. He chooses to pass an order in a complaint wherein no show cause notice has been issued to me, and pertaining to which he has already issued an endorsement which is at ink page number 492, millets, wherein.
So now what is the order passed, impugned order?
The impugned order, he says,
Page?
Ink page number 508, millets. ವಿವಿಧ ನ್ಯಾಯಾಲಯಗಳಲ್ಲಿ ಪ್ರಕರಣ ದಾಖಲೆ ವಿಚಾರಣೆ ನಡೆಯುತ್ತಿರುವುದರಿಂದ ಅಂತಿಮ ಆದೇಶ ಆಗುವವರೆಗೂ ಯಥಾಸ್ಥಿತಿ ಕಾಪಾಡಬೇಕು. ಮೇಲ್ಕಂಡ ಎಲ್ಲಾ ಸರ್ವೆ ನಂಬರ್ಗಳಿಗೆ ಓಡಾಡಲು ಪ್ರತಿವಾದಿಗಳಿಗೆ ಯಾವುದೇ ತೊಂದರೆ ಮಾಡದಂತೆ ಸೂಕ್ತ ಕ್ರಮ ವಹಿಸಬೇಕು. He is basically instructing me not to obstruct them to.
Now, just on it. This order at annexure Z5.
Z5
is superseded by this order of 13/10/25.
Yes, my lords. He is very well aware. He himself has provided a report to the Assistant Commissioner.
Yes. Now,
specifically saying that there is no public space in 308.
No, one is you have suffered an order before the civil court.
Please.
You are bound by it.
Now that order has been, that order has been challenged in a MEA proceeding. That also dismissed. GMCPC petition is pending before this honorable court. They entered caveat after hearing both the sides. This honorable court directed us to maintain status quo regarding road is concerned. We have made out a case saying that if the road is blocked, we cannot reach our property which is situated next to their property.
No, correct. Now, once the AC has passed an order on 13/10/25,
please.
How Tahsildar's order will go?
What happened, my lord? A fresh surveyor has been appointed. That report is there. I may be permitted to place before your lordship, and I will leave to your lordship to take any decision on that one.
Where is the order in the writ petition, CPC?
CPC writ petition, yesterday it was posted, again it is posting on 18th. On their instance, it has been, they requested for a short date, and it is listed on 18th of this month. So their status quo order is there to be maintained by both the parties. Now, there is no dispute regarding the land is concerned. They are owning their own land. Now only the problem is that I have to reach my property, which is measuring only 4 guntas. They are a big landlord having more than 70 acres of land. Now they are obstructing to reach my property. Even after obtaining injunction order, I have not allowed to go to my property. I have left the property as it is for more than 6 months. It is a coffee growing area in Mudigere. So my submission is, my lord.
In page number 180,
Any
there
of
is a
it.
categorical
We'll see.
finding that they need not pass through my property.
We'll see now, in civil court, some CPC, some writ order is passed. So let us see.
Here also your lordship directed to maintain status.
What is the
Let that-
modification you're seeking?
Milords, Tahsildar has got no jurisdiction to interfere in a matter when civil court is already seized of the
So
matter.
we'll
He cannot say, don't
So
obstruct
we'll hear the
the
matter.
other side.
I'll fix a date, we'll hear the matter.
My lord,
Milords, in the meantime, stay order may be issued against the operation of the order.
Now you're.
Milords,
Block the road,
I will convey the difficulty, Milords.
No, in the CPC, there's already some order of status quo.
Yes, Milords.
I said, how do you get over that now?
Milords, the issue is that soon after securing this order on 22nd of April, they have barged inside my property. They have broken the check dam, and 6 acres of my land is rendered useless all through this
Okay, we'll hear it.
year.
So we'll
So
hear it.
kindly,
We'll hear it.
kindly,
We can't, no, I can't pass an order without hearing fully. It appears to be contested. Let's hear it rather than commit any order without hearing both. We'll fix a date and we'll hear the matter.
please may I make one.
Milords.
November lane one set of document which they have now rely upon. That also not made available for me.
Milords,
After filing the.
Just one-
repetition, they- only
one plea on this,
repetition
Milord.
papers are received by me, not other remaining papers.
Now,
Milords,
what do you say? He says you have broken into their property.
No,
and
sir, no, my lord,
caused
sorry.
damage to the-
I have secured a stay order based on the OS number 73 of 2025.
Even in the writ petition GMCPC, they moved the matter for modification of the order. There is a clarification saying that this status quo order should not allow the petitioner to disturb their position also. That we are maintaining, that modification also once they got from the very same GMCPC court. It is operating against me.
What is the order passed to the coordinate bench now?
The coordinate bench is that they have qualified the status quo order subject to the police protection order and the injunction order what I have secured. Nevertheless, I am before this on.
So then we'll hear, then you just wait. We'll hear.
Milords,
We can't do it on
may I
this part
convey
of the-
one
No, I'm
difficult-
saying I don't understand your urgency. We are on the threshold of a vacation. It's not that I don't have other matters. I'm not sitting in the afternoon. I have a bench at 2:30. I have to finish whatever I have to. This matter, we can't do it today. How can you do it today? You may have your urgency. I'm not taking offense to the urgency that you are pleading. But what I'm saying, it requires some detailed hearing on both sides and pass a final order. Again, if we pass another interim order, it's only going to cause complications. So we'll hear the matter and pass an order finally. We passed an order of status quo, you're saying that requires to be modified. Now the other side has come. Let them take the stand and we'll hear the matter. We'll fix a date and we'll hear the matter. The matter, counsel for the petitioner has filed an IA seeking for modification of the interim order.
Milord, they can be directed not to precipitate the matter. Because 6 instances have happened where it is leading to multiplicity of proceedings. And the circumstances in which this.
I am sorry, this is all created by them only. In order to see that, we have to be booked in a criminal case. Already criminal case is booked on their complaint only. They obtained the bail also.
This court had passed an order directing parties to maintain status quo as on date. Full stop. The counsel for the respondent to take his stand in writing by the next date. Relist the matter, date could after vacation. 13th. The interim order in operation as on date is extended to the next date.
Writ of mandamus, Your Lordship, to consider representation to mutate the name of petitioner revenue records, Your Lordship.
So I'll require some time. I've received
Last time also they took time, Your Lordship.
received an endorsement today, but it seems to be in the name of some other person, named Shankar Reddy, but the same survey number, my lord, they say that they're not in possession.
Let us see. relist the matter in the same stage.
Date may be fixed, Your Lordship.
Yes.
31. Ganapati Bhatt. The last date of hearing, my lord. That is writ of mandamus that I have
Let
sought.
us see, let us see. Relist the matter in the same stage in the week commencing from.
27th of January, 32.
Yeah,
Alaswamy, 27th of January. 32. Alaswamy.
32, I require some time.
At request of AGA, relist the matter in the same stage, week commencing from.
27th of January. 33. 33 Bharat Code of India.
In this case, man.
Yes, government. Then you take it in writing. AGA to take the stand in writing. Relist the matter in B group in the week commencing from.
27th of January. 34.
34, my lord, was to remove the entry in column number 11. We had said, my lord, the land is converted, therefore we are not able to remove that. The lordship had passed an orders to inquire from the deputy commissioner whether we can remove that. We are unable to remove it, my lord, because the system doesn't allow it unless the conversion is cancelled. And my lord, it's restored in Bhumi.
Okay, but then you take a stand in writing. Let's see what solution can we can. Now the problem would arise maybe in cases of compensation, etc., where suppose you assume the land has been converted and then acquired, and then earlier somebody else's name is in the mutation. So some solution must work.
In terms of valuation also, I understand it would affect them.
So you take your stand in writing. Let them
Entire
take
chunk
it.
of land, my lord.
Correct. So let them take the stand writing. What solution?
Yes,
is-
let them come out with the white and black, my lord. So let the lordship kindly.
The respondent state to take their stand in writing by the next date. Relist the matter in the same
A
state.
date may be given. my lord.
27th January.
Yes.
35. Suresh.
Obliged. 17.
Suresh.
Well, on chicken, the writ of mandamus, 5. Raj, I'm only seeking a writ of mandamus, my lord.
Just one. That's something. Huh? So it should get over. AGA submits that the process of effecting mutation is on, and they would they would report by the next date what furthest what action has been taken.
No, only the difficulty is, my
No,
lord.
just they are saying something, so they are going to report. They are saying they're doing it. Relist the matter in the same stage on.
13th of January.
Yes.
Please, my lord.
36. Varsha.
Lordships will see, my lord, the order passed by the Assistant Commissioner at page 26. Nothing, Lord. It says he has no jurisdiction. On the strength of a, my lord, a gift deed, I am claiming khata. I'm practicing advocate.
Yes.
I don't know, my lord, how he assumes no jurisdiction. Page 26, your lordships will see. Last time, Lord, lordship specifically directed them to take a stand, but the stand is already taken. Page 26, my lord, they have to defend this order basically. And my brother got it changed, my lord. For obvious reasons, they are not doing my khata change. My father gifted the property in my favor. Practicing advocate, and I reasoned out with him why he is not.
Yes.
No.
Relist tomorrow in same stage. Yes.
37.
Seeking writ of mandamus, my lord. My application for to mutate the names on a AHC ground, my lord, is pending before the Tahsildar, my lord.
Yes.
filed in the RTC reflecting the name of the petitioner?
Yes.
Yes, petitioner name is reflecting.
Huh?
Verify my lord and yes,
ಇವಾಗಲೇ ವೆರಿಫೈ ಮಾಡ್ಬಿಡಿ.
pass on much.
Huh? Pass. You just report to the thing, will
Please,
dispose it.
please, please.
Shashidhar can't believe he is wearing spectacles. Yes.
38. For the petitioner in this case, madam.
ಅದರಲ್ಲಿ ತಿಳ್ಕೊ ನೀವು ಅಂದ್ರೆ ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ ಇಲ್ಲಾಂದ್ರೆ ನಾಳೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಮಾಡಿದಾರೆ ಅಂತ ಹೇಳಿ ಅಲ್ಲೇ ಮುಗೀತಷ್ಟೇ. ಎಸ್
Petitioner in this case, madam. 38.
ಎಸ್
My lord, there was an inquiry that was ordered based on a complaint that was given by some private parties, my lord. Based on the inquiry, my lord, they have said that it is a Iduvadi land, my lord. Only thing is, during the inquiry, my lord, the regional commission respondent number 2 has directed not to create any third party interest to the sub-registrar. He has written a letter saying that no third party interest is to be created, my lord. Now the inquiry is completed, my lord. I gave a representation. Please direct the sub-registrar or withdraw this letter, my lord.
Now this annexure L.
Annexure L, my lord.
Is the
Annexure L is the, my lord, the letter direction that was given by the no, my lord, Annexure L is the inquiry report, my lord. During the pendency of this inquiry report, my lord, inquiry report is done and they say that the land belongs to me, my lord. Like during the pendency, my lord, the previous page.
That inquiry report is at annexure M.
Annexure L and M, my lord.
L and M.
L and M. Two authorities has conducted and both the authorities says, my lord, page 100. Both the authorities says that it is a private land, belongs to me, there is no encroachment. Page 100, relevant portion, my lord.
Page 100?
100, para 4, my lord.
Yes.
My lord, my only concern is this, my lord. My lord, when the inquiry was pending, there was a letter that was addressed by the respondent number 2. My lordship will get it at Annexure K, page 91. Regional Commissioner. This was during the pendency of the inquiry. Last 2 lines, my lord, he says, this has been addressed to sub-registrar. Last 2 lines, my lord. ಹಕ್ಕು ಬಿಡುಗಡೆ ಇತರ ಯಾವುದೇ ರೀತಿಯ ನೋಂದಾಣಿಕೆ ವಹಿವಾಟುಗಳನ್ನು ಈ ಪ್ರಾಧಿಕಾರ ಮುಂದಿನ ಆದೇಶವರೆಗೂ ತಡೆ ಹಿಡಿಯಲು ಸೂಚಿಸಿದೆ. My lord, now the inquiry has been concluded. I gave a representation saying that let this letter be withdrawn.
Admittedly, even as per the report, it is recorded that there is some, although it is Iduvadi land, there is kharab in that land, A kharab as well as B kharab. Now the petitioners have, the allegation is that there have been B kharab, although B kharab is located, that has been converted in wholly as been conducted illegally. The inquiry is still pending until the order of the regional commissioner. What I would suggest, may I make a submission, my lord, that in so far as the identification of B kharab is concerned, until that is done, the state, we are saying you do not create third party rights because it will create multiplicity of proceedings.
No,
This is a matter in which we have to file our objections, my lord.
No, now you take that inquiry, now you are saying some proceeding, some paperwork is still correct. Huh?
In view of that, the inquiry is not complete. There is no report on it. These are just reports submitted to the regional commissioner.
No, so correct. So you conclude this expeditiously, whatever you are taking, you take steps and then you.
Be done, my lord, upon notice to the sellers as well as the purchasers to be present at the time of the survey. Identify these kharab lands as well. Only upon this process will a report be finalized by the regional commissioner.
No, then you take your stand in writing so there is clarity.
Or there may be a direction for them to participate in the additional.
Well, it is already participated, but however, I will participate again, my lord. There is a presence where they say, my lord, in the report that I was present in the place. My lord, if my land has a B kharab inside, my lord, that doesn't mean that it will belong to the government. Only thing is, my lord, B kharab, my lord, under land revenue rules, my lord, I am not entitled for a compensation if it is acquired. Only that, my lord. Other than that, my lord, if B kharab is there inside my land, that will not affect anybody, my lord.
Let them take the stand so there's clarity. AG is directed to take stand in writing by the next.
One submission, my lord. My lord, I have given annexure N, the representation. Let them consider the representation, my lord, and call upon me to produce whatever record I require, my lord. Because, my lord, this problem is, my lord, the respondent number, petition number 2, why is suffering from a cancer, my lord. At any cost, they want to dispose this land, my lord. At least they want to mortgage this land, my lord. Let my representation annexure N be considered, my lord.
My lord, they will consider it, my lord, but it will be in continuation of this period. We also issue notices to the petition under 39, where the sellers as well as the purchaser.
No, so we'll keep it pending. Mere it will not solve your issue. It will go and land again in the same. Let them at least come out clearly.
Yes, madam.
AGA submits that they would complete instructions and take their stand by the next day. Full stop. In the interregnum, counsel for petitioner submits that if the petitioner's presence are required for any purpose, they would be present and cooperate in the proceedings initiated, if any, relating to the present dispute. Relist the matter in the week commencing from. Yes.
39,
Satish, DJ.
That is request to change the restoration of the name. But in the year 1977, the partition, register partition was entered into between the family of the.
Just wait.
Alternate remedy, my lord, under 136(2). Tahsildar has already passed his order.
But 136(2) different footing.
Kindly see, my lord, page 36 is the endorsement given.
But I have challenged page number 37. That is the endorsement has been issued by the Tahsildar saying that the revenue entry stands in the name of this one, which is the not found the original records and mutation register. Is the 1977 when the partition deed was entered into. My father name was coming to the form number 9 and 12 itself, and the encumbrance is also reflected. Is not a government land, but without there being any notice, is a due process of law. The stands in the name of the government without there being any notice. But such a similar endorsement has been called in question by the coordinate bench of this court.
No, just one. Now your name was earlier there.
Earlier, please. Earlier it is found.
Where is that?
But kindly see page number, annexure B, page number 24. Typed copy, 25. The father name was Padmanabhaya. The annexure A is the sale deed, as a partition deed. And page number 27 is an encumbrance. It is also reflected. Vivaga Patra, 10/8/1977. That has been acquired the property.
No, but you take your stand in writing.
Please.
Unless you say it's a grant.
It's not a grant.
It's not a grant.
Please, it is
then
not.
You take a stand.
The
AG state to take the stand in writing in light of the contention of the petitioner that the land in question was private land.
Please.
And accordingly, the question of entering the name of government as regards such land does not arise.
Please.
Yes.
40.
Release the matter in the week commencing from.
40. Kalyan.
Paper petitioner.
Release the matter in the same stage in the week commencing from.
5th of January.
Yes.
Application for transfer of khata based on the registered sale deed has been
Yes,
rejected by the Tahsildar on the ground it is a granted land, PTCL. It is out of the jurisdiction of the Tahsildar to issue such an endorsement, covered by judgment. Last time I given this judgment.
Yes. Judgment where which?
Please.
Paragraph.
Paragraphs,
my lord, 5, 6 and 7.
There is sufficient substance in the submission of the learned counsel for the petitioner. Tahsildar could now decline to enter the name of the petitioner on the strength of registered sale deed.
Now you are challenging the endorsement at
Endorsement issued by the Tashildar.
Annexure
Annexure G, page 38. Sale deed has not been questioned. No application of resumption has been
Petitioner.
filed.
has called in question the correctness of the endorsement. At annexure G, whereby the request of the petitioner for transfer of Khata in terms of the sale deed dated 30th January 1988 has been rejected, making reference to the checklist and observing that the land comes within the purview of the PTCL Act. Full stop. Counsel for the petitioner submits that the registration of Khata is sought pursuant to registered sale deed dated 30th January 1988, and in terms of section 128 of the Karnataka Land Revenue Act, authority must effect revenue entries regarding acquisition of title and have no jurisdiction to enter into validity of the sale deed. Full stop. Relying, full stop. Yes. Peruse the endorsement at annexure G.
Annexure G, page 38.
It is noticed that the only ground for rejection of the request for transfer of Khata is that the land comes within the provisions of the PTCL Act. Peruse the observations made by the coordinate bench in WP 5721 of 2021. Full stop. Observation at para 5 and
5 and 6.
5, 6, 7.
5, 6 and 7 reads as follows. Next. Must be noticed that in the request for transfer of Khata relating to acquisition of title must be done strictly in terms of provision of 128, section 128 of the Karnataka Land Revenue Act. In such proceedings, the authorities cannot enter into the validity of the sale deed. The observations made above are in an identical factual matrix. Next. Accordingly,
Lord, liberty is granted to the
yes.
to
Accordingly,
initiate proceedings.
accordingly, the endorsement annexure G is set aside. Request of the petitioner for effecting Khata to be considered and appropriate orders passed within a period of 3 months. Needless to state, if indeed the respondents were to find any violation of provisions of PTCL Act, they are at liberty to take appropriate action as is permissible in law. Yes.
My lord, I appear for petitioner in this case, my lord.
Yes.
My lord, I sought for a writ of mandamus, my lord, to consider the representation, that is, my lord, in pursuit, my lord, a compromise decree was entered into between myself and others. And in the compromise decree, my lord, I was declared as the owner of land bearing survey number 67. Pursuant to which, my lord, I made an application for change of RTC. And my lord, the report says that out of the 4 acres, my lord, 2 acre 33 guntas have been acquired for Kempegowda layout. But as such, no notification. We are not aware of the this thing, my lord. But my lord, for mutating the rest of the things also, they are requesting, my lord. The revenue department is also not getting the document, and I have tried to myself get the Kempegowda layout acquisition notification
Yes.
under
Just
RTI,
one.
but it's not provided.
Just one. Yes.
My lord, survey number 67 is, my lord, the total extent of 68 acre 2 guntas, my lord. Out of that, the BDA acquired, my lord, 2 acre 33 guntas. Now petitioner claims that he is a granted 4 acres. We can only, my lord, provide information that which portion of the area is be acquired.
That you take a stand in writing, then we can pass other orders. So if according to you, which is notified,
Yes.
that you place it on record.
Yes.
Learned counsel K. Krishna submits, he would take a stand in writing by the next day. Relist the matter in the week commencing from
3rd of February.
Yes.
Allah, Milord, I am in a deep trouble, Milord. First week of January, Milord. The reason is, Milord, any first week of January, Milord.
12th of January.
Much obliged. Much obliged.
Yes.
Saraswati M 43.
South Tahsildar, my lord, is unresponsive in most matters. Which may summon her in some date. Ask her to be present and explain. Most matters I'm taking time in is the South Tahsildar itself. Somewhere, my lord, your lordship may have to summon her.
Yes. The what you are seeking for?
For demarcating the property as per our sale deed, my lord.
Petitioner sought for demarcation of land in possession. Petitioner is also sought for the conclusion of 4D and Durst proceedings, including furnishing of Lebanese sketch. AGA is unable to take stand within what time the proceedings would be concluded. If instructions are not complete by the next date, AGA, the Tahsildar Bangalore South to be present through VC on
12th of January.
VC, but
some SOP.
No, they don't value it.
To be present on
12th of January.
The AGA to file a memo with name of the concerned official, while making it clear if instructions are not complete by the next date, necessary costs would be levied. It's also made clear that in the event the instructions are complete, presence may be dispensed with. Relist the matter on
12th. 45. Rupesh B.
Let Saraswati's client not be prejudiced by this order. Yes.
OD and Durst Milad, fixing Addubastu, dispute of 221 survey number, 4 acres of land Milad.
Yes.
Online application is filed with annexure B Milad. Page number 11.
Yes, yes. Yes, ma'am.
And 45. 44 kar dina.
Today afternoon I have a bench. Yes.
Milad, may they say Milad a suit is pending. Milad, a suit is pending in respect of other survey number. That is the objection. Therefore, I said Milad, they in the suit they themselves specifically aware that I have encroached their property. Therefore, Milad, I have filed this Milad application to fix Addubast in respect of my property. They have also filed for Lebanese sketch Milad that he withdrawn Milad, conveniently withdrawn. To come over that Milad my property intact ಇದೆ ಅಂತ ತೋರ್ಸಕ್ಕೆ ಇದು ಸೂಟ್ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ. But suit ಅಲ್ಲಿ there is no prayer.
No, the suit does not relate to this survey.
No, not in respect of this survey number.
Then you place that copy of the
Milad annexure E Milad page number 15. Milad kindly come Milad. ಅವರೇ ಅಬ್ಜೆಕ್ಷನ್ ಕೊಟ್ಟಿರೋದು. ಯಾರು ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ ಅವರೇನೆ. ನನಗೆ ನೋಟಿಸ್ ಕೊಡಿ ಅಂತ ಅವ್ರು ಬರ್ದಿದ್ದಾರೆ ಇದರಲ್ಲಿ. ನೋಟಿಸ್ ಕೊಟ್ಟು ಮಾಡ್ಲಿ ಅಂತ ನಾವು ಹೇಳ್ತಾ ಇದ್ದೀವಿ.
We'll dispose it of tomorrow. You just produce the plain copy, we'll record it and dispose. Relist tomorrow in the preliminary hearing list.
46, Chandrachud.
Application for conversion of the land. Tahsildar, instead of submitting a report to the deputy commissioner, he rejected the application on the ground it is a granted land. Kindly see annexure E page 30. He himself has rejected the application. You should have submitted a report to the deputy commissioner to consider the application. With this report, he cannot reject the application. Annexure C E page 30. It is without jurisdiction.
Now the order under 95 is to be done by the deputy commissioner.
ಹೌದು.
So this must be construed to be a report and it be placed before the DC. Let DC take an appropriate decision.
ಅಲ್ಲ, ಅರ್ಜಿಯನ್ನು ವಜಾಕರಿಸಿದೆ ಅಂತ ಹೇಳಿ ಅವರೇ ಬರೀತಾರೆ. ಅದು ಇಟ್ ಇಸ್ ವಿತೌಟ್ ಜೂರಿಸ್ಟಿಕ್ಷನ್. ಇವ್ರು ಹೆಂಗ್ ಬರೀತಾರೆ?
My instructions are that because an application was made, since this is PTCL land, what the endorsement should be read as that you have to seek permission from the DC. That they do not have the power to do.
Correct, that you
Application filed to DC.
that you clarify, they will do it.
Let them file an application before the deputy commissioner.
Application has been filed before the deputy commissioner for conversion of the land.
Endorsement is issued because the title are that in this PTCL land.
Kindly see the next annexure, annexure E. Similar land, adjacent land has been granted conversion.
No, correct.
It's also granted land.
So you say what is the procedure, we'll ask him to adhere to that.
No, application was filed before the deputy commissioner.
Yes.
That the deputy commissioner will have to answer, but I have not got instruction from the deputy.
You find out what is the procedure. Accordingly, he will take steps. Learned counsel for the petitioner would point out that annexure E is not sustainable as it amounts to a rejection of application. And such rejection is without authority of law. EGA to verify and submit what is the correct procedure relating to conversion proceedings that requires to be followed by the petitioner.
ನಾನು ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿರೋದೇ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ಗೆ, ಅವರು ರಿಪೋರ್ಟ್ ಕಾನ್ಫರ್ಮ್ ಮಾಡಿದ್ದಾರೆ. ಇವರು ರಿಪೋರ್ಟ್ ಸಬ್ಮಿಟ್ ಮಾಡೋದ್ ಬಿಟ್ಬಿಟ್ಟು ಇವರೇ ವಜಾ ಮಾಡ್ಬಿಟ್ರೆ.
Relist the matter on in same stage. 12th. Yes.
47 Rajshekar.
Notice it and page 18 is under challenge, my lords. On the last date of hearing, my lords directed. Without issuing, my lords, the notice of survey, my lords, this particular notice came to be issued. That is my stand, my lords, in this petition. Interim protection is there, my lords.
The interim protection earlier grant is extended till the next date. Relist the matter in the week commencing from meeting.
Great.
One submission.
One submission, my
My lord. My lord, the matter which is reserved, my lord, that pertain to 319 application, my lord. This honorable court, we are filing some
So
notice.
serve the other side and
We have served the copy. We have taken action.
give it.
My CL number 44. It has been adjourned in the morning. They have taken time responding. There was a stay that was granted by this honorable court. It has to be extended.
Temporarily, order. Earlier grant is extended to the next.
Password, they kindly repeat the call tomorrow.
It is here.
Serial number 56 may be short point is involved, may be taken up on day after tomorrow, my lord. 56.
I leave it to the court officer. I don't know how many matters are there. If it can fit, he will take it up. You make a request.
Please.
Serial number 67 wrongly connected some other matters.
That I think we have dealt
ಗಿರಿ. ಮತ್ತೇನು ಇಲ್ಲ ಸರ್, ಯಾವುದು ಇಲ್ಲ. ಯಾವ ಡೇಟ್ ಹಾಕೋದು? ಟ್ವೆಂಟಿ-ಸಿಕ್ಸ್ ಅದು 25 ಮಾಡ್ತಾರೆ.
ಈ ಬುಕ್ ಎಲ್ಲ ಇನ್ನೊಂದು ಮೇಡಮ್ ನೋಟ್ಸ್ ಇದೆಯಲ್ಲ, ಅದು
ಅದ್ರಲ್ಲಿ ಏನೇನೋ ಬರ್ಕೊಂಡು
ಅದು ಇರ್ಲಿ, ಇದು ಬೇಡ. ಅದರಲ್ಲೂ ಏನೋ ಬರ್ದಿರ್ತಾರೆ, ಸುಮ್ಮನೆ ಸೆಪರೇಟ್ ಆಗಿ ಇಲ್ಲಿದೆ
ಬಿಡಿ.
ಅದ್ರಲ್ಲೂ ಏನೇನೋ ಬರ್ಕೊಂಡಿದ್ದೆ ಕೆಳಗಡೆ ಇದೆ.
ಒಂದು ನಿಮಿಷ.
ಕೊಡು ಸರ್. ಕೊಡಪ್ಪ ಸರ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಈಗ 3 ಗಂಟೆ
ಅಲ್ಲಪ್ಪ ನೋಡಿ ಯಾವ ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ.
ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಬೆಂಚ್ ಸಿಂಗಲ್ ಬೆಂಚ್ ಇಲ್ಲ ಸರ್ ಮುಗಿತಾ
ಯಾವ್ದು?
ಸರ್ ಇದು ಮ್ಯಾಟರು 17 ಲೀಸ್ಟ್ ಆಗಿದೆ ಚೆಕ್ ಮಾಡ್ಬೋದು ಸರ್.
ನಾನು ಹೆಂಗ್ ನೋಡ್ಲಪ್ಪ ಇವಾಗ ಯಾವ್ದು ಬ್ಯಾಗ್ ನಡೀತಾರೆ.
ಸರ್ ಬೋರ್ಡ್ ಅಲ್ಲಿ ಕೇಳಿದ್ರೆ ಅವ್ರು ಇಲ್ಲಿ ಕೇಳಕ್ಕೆ ಅಂದ್ರು, ರಿಪೀಟ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರು.
ಏನಪ್ಪ
ಜಡ್ಜು 17ಗೆ ಮ್ಯಾಟರ್ ಲೀಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ, ಬಟ್ ಅಲ್ಲಿ ಬೋರ್ಡ್ ಅಲ್ಲಿ ಕೇಳುವಾಗ ಅವ್ರ ಸಿಸ್ಟಮ್ ಅಲ್ಲಿ ತೋರಿಸ್ತಿಲ್ಲ 17 ಅಂತ. ಸೊ ಅದಕ್ಕೆ ಇಲ್ಲಿ ಕೇಳಕ್ಕೆ ಅಂದ್ರು.
ಯಾವತ್ತಿತ್ತು?
15 ಇತ್ತು ನಿನ್ನೆ.
ರಿಪೀಟ್ ಮಾಡಿರ್ತೀನೋ?
ಮಾಡಿರ್ತೀರಾ?
ಅವ್ನು ನೋಡ್ಸೋದು ಅದೇನು ಕೊಟ್ಟಿದ್ರೆ ನಮಗೆ ವ್ಯತ್ಯಾಸ ಆಗ್ಬೋದು
ಸರ್ ಅದು ರಿಪೀಟ್ ಮಾಡಿರ್ತೀರಿ ಸರ್?
ಮಾಡಿರ್ತೀವಿ, ಬೋರ್ ಬಂದ್ ಸರ್ ಕೇಳಿ ಸರ್. ಏನೋ ಕೆಲಸ ಇವರು ಇಲ್ಲಿ ತಮಾಷೆ ಏನು
ಹಾಕಿದೆ.
Sir. Sorry, on the last occasion I had given haphazard synopsis and I explained the reason. Proper synopsis I am giving now.
Clarify points. There are two parts of it. One would be a factual analysis.
Yes, ma'am.
But before that, if the legal framework and concepts are clarified,
yes,
then we can go into the factual.
Very well, ma'am. First, I will go on facts, ma'am. Facts are only.
No, I'm saying on the
concepts, ma'am. I will submit. No, my lord. One of the content, one of the.
And then you can, while you're submitting, you can also refer to what are the differences as you are pointing out.
Yes, I will point out, my lords. First, I will take my lords to the division bench judgment and say where are the differences.
Yes.
And then, my lords, I would take my lords to the law. My lords, the division bench judgment. Division bench judgment, my lords. I think up to page 75 of the judgment, it is only narration of the facts. Para 30 at page 75.
375, correct. Volume 1, is it?
That is in the paper book given to me, it is filed as a separate volume. DB judgment, because volume 1, only order of the learned single judge would be there.
This division bench.
Because this is the writ petition paper book. All of us are referring to High Court writ appeal only.
This is a reference to the
Division bench order.
Division bench order, my lords, because
Later,
now.
not earlier division bench, later division bench.
Later division bench. The division bench from which the reference has arisen to the occasion to the full bench.
That is not placed. That copy is not placed.
Three copies of the division bench judgment.
All the judgments.
My lords, I have to go.
Registry would have done it. Registry would have done it. Along with the order sheet, it will be there. Yeah.
That's there in the file. The order separately.
Anu madam ಅವ್ರದ್ದು Rajesh Rai ಸಾಹೇಬ್ರದ್ದು judgment ಇದೆ.
So one separate order is there like this.
ನೋಡಿ ರೆಫರೆನ್ಸ್ ಆರ್ಡರ್ ಒಟ್ಟಿಗೆ ಇರುತ್ತೆ.
One separate order is there. No. In a folder like this order is there.
ಇದು original. I think he said
Order is there. Only the document.
ಇಲ್ಲ ರೀ ಮಾಡಲ್ಲ ಲ್ಯಾಪ್ಟಾಪ್ ಇಟ್ಕೊಂಡು
ಕೇರಳ ಹೈಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡ್ಬೇಕು 3 ಕಾಪಿ ಮಂಜುಳ ಕಾಪಿ ಸಾಫ್ಟ್ ಕಾಪಿ ಇರುತ್ತೆ ಅದನ್ನ ಸಾಫ್ಟ್ ಕಾಪಿ ಇರುತ್ತೆ
Like this it will be. That is such from the fact. All of us have now. Doesn't have. It's there.
It's not there.
Separate.
So anybody extra copy can give me. We'll make a
Division bench judgment.
Division bench.
Division bench
Because two
judgment,
sets registry has not made another. It's all right. I think I have made, but you have extra copy. You can share otherwise.
ಕೊಡ್ರಿ ಹಾಗೆ ಕೊಡಿ ಸಾಫ್ಟ್ ಕಾಪಿ ಸಾಹೇಬ್ರ ಹತ್ರನೇ ಇದೆ.
Mark something.
No, that's okay.
Don't mistake.
No, that will help us.
Oh. That's there.
Yes.
Manometers. Page 75, para 30. Consideration starts. This I am referring to the view rendered by opinion of Honorable Justice Anu Shivaraman, which commences at page 46.
Yes.
Up to para 29, it is all the submissions of the parties and facts. Para 30. Upon hearing the learned senior counsels appearing for the parties, the short point that arises for our consideration is whether the impugned order dated 19/7/2023 passed by the learned single judge in writ petition number 4046 of 2020 calls for any interference by this court in these intra-court appeals. Having considered the contentions advanced, we notice that at the relevant time, the method of recruitment to the post of district judges in the state of Karnataka was as follows: 25% by way of direct recruitment, 65% by way of promotion from the cadre of senior civil judges, and 10% by way of promotion through competitive examination. This, my lord, the reference is to 2011 recruitment rules, which came into force on 1/1/2011. There is no serious dispute with regard to the question that a challenge against the seniority list can be raised by the Director of Courts in case the promoted district judges are accommodated in excess of the quota set apart by the rules. Now it is also not in dispute that the promoted district judges are entitled to seniority only from the date on which there are substantial vacancies available within their quota and not the dates on which ad hoc appointments had been granted as ad hoc fast track court judges. In All India Judges Association and others, Union of India, 2002, 4, SCC 247. This is referred to as normally All India Judges 3. This is the third judgment in this series. The apex court had clearly held that quota in recruitment is to be applied against the fixed cadre strength and not against arising vacancies in many states. The apex court in paragraph 29 had already held that as follows. The experience has shown that there has been a constant discontentment amongst the members of the higher judicial service in regard to their seniority in service. For over 3 decades, a large number of cases have been instituted in order to decide the relative seniority from the officers recruited from the 2 different sources, namely promotees and direct recruits. As a result of the decision today, there will be in a way be 3 ways of recruitment to the higher judicial service. The quota for promotion, which we have prescribed as 50% by following the principle merit cum seniority, 25% strictly on merit by limited departmental examination, and 25% by direct recruitment. Well, I'll pause here and say this quota of 50%, 25%, 25% was in force in the state of Karnataka from 22nd September 2005 up to 31st December 2010. From 1/1/2011, it changed. Direct recruitment remained 25%. Promotion became 65%. And in-service candidate through limited departmental competitive examination, it became 10%. That is the change. That is the only change that has come thereafter. Experience has also shown that the least amount of litigation in the country where quota system in recruitment exists, insofar as seniority is concerned, is where a roster system is followed. For example, there is, as per the rules of the central government, a 40-point roster which has been prescribed, which deals with the quotas for scheduled castes and scheduled tribes. Hardly, if ever, there has been a litigation amongst the members of the service after their recruitment as per the quotas. The seniority is fixed by the roster points, and irrespective of the fact as to when a person is recruited, where roster system is followed, there is no question of any dispute arising. The 40-point roster has been considered and approved by this court in RK Sabharwal. One of the methods of avoiding any litigation and bringing about certainty in this regard is specifying quotas in relation to posts and not in relation to the vacancies. This, my lord, insofar as our state is concerned, right from the year 1962, when the first recruitment rule came, it has always been linked to the cadre strength. Total number of posts in the cadre is the phrase used in all these recruitment rules. I will take my lords through. Therefore, this aspect of this quota related to the number of posts in the cadre, that has been in existence in our state from the beginning. The senior, hardly ever, if there has been among the members, the 40-point roster has been considered and approved by this court in RK Sabharwal. One of the methods of bringing about this is by specifying the quotas in relation to the posts and not in relation to the vacancies. This is the basic principle on which 40-point roster works. We direct the courts to high courts to suitably amend and promulgate seniority rules on the basis of the roster principle as approved in the RK Sabharwal as early as possible. Here, my lords, the fact remains, in our state, this has not been done. And a division bench of our High Court has held in C.V. Chitra's case that it was only a view of the Supreme Court requiring us to amend the rule. For example, my lord, 2-3 suggestions were made in that All India 3. One is the moment a person passes LLB, he should be eligible to compete for civil judge's post. No experience is required. Whereas in the Karnataka rules, it continued to be 3 years like that. Some experience was always stipulated. And more importantly, enrollment as an advocate was also stipulated. Because a person cannot, in the Supreme Court judgment, if we see, enrollment as an advocate is not necessary to apply for the post of civil judge. All India Judges 3. But the recruitment rule made in the state of Karnataka says he should have been enrolled as an advocate, number one. Number two, he should have practiced for so many years. That condition was challenged before this honorable court. C.V. Chitra, I was on the losing side. I appeared for the petitioners. I argued that, look, your recruitment rule is contrary to Supreme Court judgment. Division bench of this court took a view that, no doubt, Supreme Court suggested or recommended amendment of the recruitment rules in this particular manner. But High Court and state government have discretion as to what should be the recruitment rule within their sphere. They exercising the discretion in our domain, we have thought it fit to incorporate a condition of eligibility that enrollment as an advocate is mandatory. That you cannot find fault with. Same argument would apply here because though the Supreme Court said you adopt a rule of seniority to fit in with 40-point roster operation as suggested in R.K. Sabharwal. R.K. Sabharwal arose in relation to reservation and operation of what is the adequacy of number of posts. But in our state, except I think the promotion of promotion to the cadre of office superintendents in the state government, where they have prescribed a ratio, certain number of first division assistants, certain number of stenographers, certain number of clerk cum typists, or some ratio is there, 5:4:1 or something like that. There rota would apply, rotation would apply. In all other cases, in all other recruitment in our state, there is only a quota and there is no principle of rota adopted. Of course, both systems have their own plus points, and therefore, this High Court felt that there is no need for us to adopt the rota. I am clarifying here itself because tomorrow that we should better here clarify it. We hope that as a result thereof, there would be no further dispute in the fixation of seniority. It is obvious that this system applies only prospectively. This is most important.
All the judgments.
Prospectively, except where under the relevant rules, seniority is to be determined on the basis of quota and rotational system. The existing relative seniority of the members of the higher judiciary has to be protected, but the roster has to be evolved for the future. Appropriate rules and methods will be adopted by the High Courts and approved by the state wherever necessary by 31st of March 2003.
Yes.
Para 29 of All India Judges Association case has been extracted and quoted by the learned single judge in paragraph 15 of the order under appeal. However, thereafter, the learned single judge has relied on decisions of B.B. Badami, Gonal Bhimappa. It is clear that the discussion in B.B. Badami and Gonal Bhimappa was in a situation where the recruitment rules in question, that is the Mysore Government Servants Probation Rules and the Mysore Recruitment of Gazetted Probation Rules, specifically provided for applying the ratio against vacancies and not to the strength of the cadre. This is the ground on which the learned judge distinguishes and holds that B.B. Badami and Gonal Bhimappa are not applicable because they dealt with quota based on vacancies, Here, quota is based on total number of posts in the cadre. It was in the said circumstance, apex court held that quota has to be worked out against the vacancies arising during a block period, and that working out the seniority without consideration of the quota as applied against vacancies arising during a block period is erroneous. The finding of the learned single judge in writ petition number 4046 at paragraphs 33 and 34 is as under. Applying the aforementioned ratio to the facts of the records, judicial officers promoted on ad hoc basis as additional district judge session judges, their seniority has to be considered only on which date they are substantially appointed as against the vacant post, and not from their initial date of appointment as ad hoc district judges. On a careful examination of the impugned final seniority list, nothing is stated by the respondent number 3 regarding their ranking as against the substantial post. I am of the view that the impugned final seniority list is required to be set aside in terms of the observation made above. Nextly, having regard to the learned counsel appearing for the parties, there are 139 posts of district judges created during the years 2003 and 2016, and their cadre strength is increased. However, in terms of the judgment of the Honorable Supreme Court, promotion could be given to an extent of 65%. However, the impugned final seniority list consisting of more than 65%, and further promotion is made in excess of 65% as against the substantial vacant posts. Therefore, the respondent has failed to classify the block period in the seniority list. Hence, I am not convinced with the arguments advanced by the learned senior counsel appearing for the respondent number 3 that the petitioners have not challenged the appointment of respondents 13 to 18. Having taken note of the observations made above, I have arrived at the conclusion that reckoning of the seniority of the promotees from an anterior date of entry. Date of entry cannot, if it is counted from date of entry, it cannot be treated as anterior date. If it is counted from the date of creation of the vacancy, then it becomes anterior date seniority. Would amounts to violation of Articles 14 and 16 of the Constitution and contrary to rota quota rule, and the same is in excess of their quota. The latter additions which are relied on in the judgment itself would make it clear that in the case of appointment of judges, upper court had directed uniformity to be maintained, and that the quota in question was liable to be applied as against the cadre strength and not against the vacancies. The rule specifically provided for filling up of 65% of total posts by promotion. It further provided that 10% of the posts shall be filled up by promotion from the cadre of senior civil judges on the basis of merit through LDCE, held in accordance with the guidelines issued by the High Court. The amended rule also provided that if any of the post is not filled under this category, the same shall be filled up by promotion under item number 1. The substitution was effective from 1/1/2011. These aspects are clear from reading of the Karnataka Judicial Service Recruitment Rules 2004 as amended by Karnataka Judicial Service Recruitment Amendment Rules 2011. The promoted district judges can count their seniority only from the date when they are substantially appointed against vacancies available there in their quota. Therefore, the question of applying the ratio as against the vacancies which arose during a block period would be irrelevant and would not arise at all in the instead case. In the nature of challenge raised by the direct courts, the only question which requires to be answered is whether private respondents were promoted in excess of their quota. If not, the writ petitioners who were appointed by direct recruitment on 1/1/2016 would not have any right to claim a revision of the seniority on the ground that the promotions are in excess of the quota. It is an admitted fact that the direct recruits can at best claim seniority only from the date of their appointment. The question therefore was, what was the cadre strength in the post of district judges as on 1/1/2016? The first question which requires an answer is, what is the meaning of the expression cadre and what constitutes cadre strength? In service law, cadre means a designated group of officers grouped together. The Karnataka Civil Service Rules defines cadre as follows. Rule 8(7). Cadre means the strength of service or part of a service sanctioned as a separate unit. The apex court in the case of Baleshwar Das held that paragraphs 9 and 24 as under. So the order of appointment to the service is decisive of seniority, and the service horoscope of each assistant engineer has to be cast with reference to his appointment order. The next question, which is When is an engineer appointed to the service? When under the rules he becomes a member of the service. For until he gains entry into the service, he cannot claim to be appointed to it. To hover around with prospects of entry is not the same as actual entry. Therefore, we have to examine when an engineer becomes a member of service under the rules. Clause B of the rules 3 defines member of service to mean a government servant appointed in a substantive capacity under the provisions of these rules to a post in the cadre of the service. What then is the cadre of the service? What do we mean by appointment in a substantive capacity to a post in the cadre? Can there be a temporary post included in the cadre? Here, Rule 4 becomes relevant. Rule 4 prescribes the sanction strength of the cadre. It provides that the government may, subject to the provisions of Rule 40, increase the cadre by creating permanent or temporary posts from time to time as may be found necessary. So a cadre post can be permanent or temporary, and if an engineer were appointed substantively to a temporary or permanent post, he becomes a member of the service. That is, my lords, to which post he is appointed is irrelevant. Nature of the post to which a person is appointed is irrelevant. What is relevant is whether he has been appointed substantively. This is one of the points where there appears to be some divergence. Therefore, I am pointing it out. So a cadre post can be permanent or temporary, and if an engineer were appointed substantially temporary or permanent, he becomes a member. The touchstone then is the substantive capacity of the appointment. Here we get into service jargon with slippery semantics and flavored officialese. We are free to confess that the rules striking divergent notes like ill-tuned symbols have vexed us a while. The touchstone of valid interpretation being the Constitution and harmonization of rules with fundamental rights being the proper path, we have tried to sensitize the provisions to do equal justice under the law, refusing to petrify Rule 23 or the other relevant rules we have referred to. Rule 4 of 1936 rules clearly contemplates a cadre as covering permanent or temporary posts. So a cadre takes in temporary posts. Once we cease to be allergic to temporary posts as a component of a cadre, we reach the next step that a cadre is, as it were, a layer in the service. Rule 4 itself, while dealing with and the strength of the cadre, speaks of a holder of a post in a cadre as a member of the service may be the holder of a temporary or a permanent post. In this case, Supreme Court was interpreting a pre-constitutional rule of 1936. Then several things have been said, how these cobwebs are to be cleared and all that. Finally, this is the conclusion reached. That is, it can consist of temporary or permanent post. To which post you are appointed is not relevant. The question is whether your order of appointment shows that it is a substantive appointment. And I can say without fear of contradiction, whenever a person is promoted as ad hoc judge, it clearly indicates in the order of promotion itself that your promotion is ad hoc. Then when a vacancy arises which is assignable to promote a quota, that is made regular by issuing the regular promotion order. In fact, the orders of appointment that is produced in this batch of petitions, they themselves clearly say, first order of promotion says, the following ad hoc judges and senior civil judges are promoted as ad hoc district judges and senior civil judges are promoted as district judges. There is an order of substantive appointment. The apex court, this is regarding the post-independence provision members. The apex court in the case of Union of India versus Pushparani and others has held at paragraphs 23 to 26 as follows. In the service jurisprudence which has developed in our country, no fixed meaning has been ascribed to the term cadre. In different service rules framed under proviso to Article 309 of the Constitution, as also rules framed in exercise of the powers of delegated legislation, the word cadre has been given different meaning. In A.K. Subramanian, a 3-judge bench of this court, while interpreting the provisions contained in Central Engineering Service Class 1 recruitment rules, observed in paragraph 20, the word grade has various shades of meaning in the service jurisprudence. It is sometimes used to denote a pay scale and sometimes a cadre. Here it is obviously used in the sense of cadre. A cadre may consist of only of permanent posts or sometimes, as is quite common these days, also of temporary posts. In fact, my lord, the entire confusion has arisen in this case because in VV Badami, which is the Bible for interpreting our state rules, state service rules, there the contention of the promotees that cadre consists of temporary posts also was rejected on the ground that the recruitment rule that was considered in VV Badami clearly stated cadre strength of permanent posts only. It did not include temporary posts. There also A.K. Subramanian is considered, and then it is distinguished, saying that here the cadre consists only of permanent posts. Therefore, we reject the argument. Then, my lords, in Chakradhar Paswan, in service jurisprudence, the term cadre has a definite legal connotation. It is not synonymous with service. It is open to the government to constitute as many cadres in any particular service as it may choose, according to the administrative convenience and expediency, and it cannot be said that the establishment of the directorate constituted the formation of a joint cadre of the director and deputy directors, because the posts are not interchangeable and the incumbents do not perform the same duties, carry the same responsibilities, or draw the same pay. This Chakradhar Paswan, it arose out like this. There were 3 posts of joint directors, but the deputy directors. One deputy director Ayurveda, another deputy director homeopathy, and another deputy director allopathy. The state wanted to apply reservation to that cadre, saying that it is not a single post cadre, there are 3 posts. The cadre of deputy director consists of 3 posts. Therefore, reservation is applicable because it will not result in 100% reservation. That was the view of the state. When that reached the Supreme Court said, what is a cadre? Deputy Director Unani cannot be transferred as Deputy Director Allopathy, even if the pay scales are same. That is how, my lords, they said, what is a cadre? They clarified. They may be in the same scale of pay, but that does not amount to a cadre consisting of 3 posts. That is how this. In state of Maharashtra versus Purushottam, it was held that cadre means unit of strength of a service or a part of it as determined by the employer. The appellant High Court had taken a specific stand that the cadre strength was 314. The notifications and order issued by the government on the basis of which such a contention was raised have now been placed before this court by respondent number 3. It is clear that vacancies which are permanent in nature or which have continued from year to year on the basis of extensions duly granted by the state government and which form a part of the cadre have to be taken into account while working out the ratios set apart for promotion. A division bench of the High Court of Kerala in its judgment dated 29/6/2017 in writ appeal number 1224 of 2017 dealing with an identical situation. My lords may have a look at that judgment, my lords. Because my learned friend interjected the other day and said that leave has been granted. Yes, leave has been granted by the Supreme Court against this judgment. It is not stayed, it is not reversed. Granting leave, once it has entered the gate of the Supreme Court, it doesn't mean that it will come out reversed or it will, whatever it is. No, my lords.
It's very difficult to enter that gate.
No, my lords. In fact, it is very interesting. Seniority has always been a vexed question, but ultimately, my lords, it is very interesting, and how a comma or a semicolon can change the meaning. That science is there in the seniority science only, my lords. That is my seniority and reservation. Both are very what I would say. It can perplex even the seasoned service law practitioner. And to borrow the words of Mr. P.P. Rao, he used to say, service law is a lawless law because there is no law made by the legislature. Entire law is made by the judges themselves. Therefore, my lords, you used to always remember, say, it is a lawless law. But it is not lawless, my lords. It may be. In this, my lords, the question was, this was again a judgment pertaining to seniority in the cadre of district judges in the Kerala state. Then it's para 10 of this report, if my lords would kindly see. Para 10 and 11 are extracted here only. The second ground taken was that temporary posts cannot be included in the permanent cadre. The learned single judge upheld this said contention. Respectfully, we think that it is a wrong proposition of law. A cadre is a designated group of officers who are grouped together. Cadre means strength of a service or a part of service sanctioned as an independent unit. It may have posts of different grades. It may even include temporary posts, work charged posts, supernumerary posts, shadow posts created in different grades to constitute cadre. That is the prerogative of the state. In this connection, we would refer to judgments of the Supreme Court in the case of Baleshwar Das versus State of UP and Union of India versus Pushparani and several other cases wherein it has been clearly held that it is open to the government to include temporary posts in the cadre to be defined by them. The learned single judge was clearly wrong in holding the temporary posts could not be included in the cadre. Lastly, the learned single judge was of the view that the power of declaring the cadre strength was that of the state and the state could not have delegated it to the High Court, in the sense left it to the High Court to quantify the same. The learned single judge was of the opinion that not only the post but the numerical strength have to be declared by the state. We are unable to accept the same. It is for the state in consultation with the High Court to declare the cadre and its strength. Its strength is to be calculated on the basis of the posts which are brought in the cadre. Once the posts are indicated, then it is only a ministerial work that is to be done by the High Court. This answers, my lord, the petitioner's contention that cadre strength notification has not been issued. And I was even canvassing the other day that post is created, court is established. Establishment of a court is not in dispute. Creation of post is not in dispute. Then only notification is not issued. The division bench, learned judge heading the bench, relied on these two. I would also point out something more which supports the contention, that is the Karnataka Civil Courts Act is there. And then the cadre and recruitment rules made by various bodies. The para 12, my lords, first 5 lines may be relevant.
No, you are contending that notification not being issued,
yes, ma'am,
is a formality that can be ignored because otherwise it's complete in all terms.
It is like that is my submission. And one more thing is, my lords, under the Karnataka Civil Courts Act 1964, creation of district courts, creation of district judges, how many additional district judges, all these are there. And also it also includes creation of the posts of senior civil judges and civil judges also. That act requires a notification to be issued whenever a post of senior civil judge or civil judge is created, but not when it creates a district judge's post. That I'll point out from the act itself. Therefore, my submission on that aspect would be, one is,
we'll have to eventually, there's one way of looking at it.
Yes, ma'am.
The formalistic view would be, what is the definition of cadre under the applicable rules?
Yes, ma'am.
That would be a formalistic reference point.
That is, ma'am. One is, what is the definition of the cadre? Here, cadre does not exclude temporary posts. One principle of law is, my lords, when a general definition is given and there is no exclusion of any particular post, if the post itself is not there, that is different. Here, admittedly, temporary posts are there. Admittedly, deputation posts are there. Admittedly, leave reserve will have to be there because no human being can work 365 days. Therefore, my lords, existence of these reserves, creation of posts is not this. Only thing is, there is no cadre strength notification.
In any case or in a particular case, it is not given?
In some particular cases, it is not there, number one.
Many or in number?
No, my lords, what the dissenting judge points out there is, I would not, I cannot say dissent judge, it may be objected to with the other side. Two views are there. Learned judge heading the bench, that opinion I am reading. What the other learned judge constituting the bench says is that there is no recruitment notification, number one. Number two, a very, what I should say, my lords, I have to use the mildest form of word because a strange this one is, suppose I have 6 deputation reserve posts. For example, my lords, Lokayukta recruitment rule. Lokayukta cadres, it has made its own recruitment rule. In that, 1 post of registrar, 7 or 8 posts of additional registrars. They are scaleless posts. And the method of recruitment is by deputation of a district judge. At a given point of time, there may not be 8 people on deputation. The learned judge takes a view that no doubt there are 8 posts, but 8 persons were not there on deputation on that day. Therefore, the cadre strength will not add up to that. But cadre, there is a deputation reserve. That deputation reserve should be equal to the deputation posts or encadred posts included in those recruitment rules. Suppose today Lokayukta says that now workload is less, I can manage with 6 only. I send back 2 persons. The posts will not cease to exist. Or suppose, let us take a case like this. Normally, I anticipate only 4 persons have been asked by the Lokayukta, therefore I will promote only 4 people today. Tomorrow, Lokayukta says, send me the 5 and 6 and 7 also. Can this court create a district judge overnight? It cannot be. Because this court is entitled to fill up the posts equal to the cadre strength, not more than the cadre strength. Some may not be in use. Let us take a simple case, Manoj. Suppose it is decided to establish an additional district court in, say, I would mention a place where there is no court, and my own place, say Shidlaghatta. When a post is created there, when a additional district court post is created, even if you post a person there to Shidlaghatta on the same day, immediately work cannot start, because establishment of any new unit has certain preparatory work. If the logic of the learned second judge who has rendered the second opinion is taken into account, until the Chief Justice of this court goes and cuts the ribbon there, I cannot promote anybody as district judge. Is that a law? Are we working in the abstract? Or are we having any respect for the ground realities and any respect for workability of a route? Theory may be anything, my lords. Like what we study in law colleges. We studied for 3 years. Present generation is lucky to study for 5 years. But the moment I come to this court, I have to forget what all I learned in the college. Because this is practice of law. There it is theory of law. The difference between theory, practice, ground reality, pragmatism, it is beyond Wren and Martin. My respectful submission is the second opinion is Wren and Martin opinion without respect for realities of working of a rule. Rule may be there, working is different. Glorious example is practice and law and practice of banking. Law is different, practice is different. Now, continuing this, for example, this is on paragraph 12. If the state stated that posts A, B, and C will form the cadre, what does that mean? If A, B, and C are three distinct posts, the cadre strength would be 3. It is only the High Court which is announcing the figure 3, which is otherwise contained in the definition itself. There the matter, this one, rest of the things about the numericals of that particular case, it has gone. Therefore, when the High Court says 340, and when it places on record the notifications creating those 314 posts, unless a particular post is abolished, 314 would stand. The learned senior counsel appearing for the respondents has placed on record, respondents here is the petitioners now, a compendium of all the respondents, that is the respondent in the writ petition, High Court, has placed on record a compendium of all the service rules with regard to recruitment of district judges in Karnataka from 1962 onwards. It is submitted that in the rules, the application of the other rules which govern the government servants in the state of Karnataka are specifically mentioned. Rule 7 of the Mysore District Judges Recruitment Rules reads as follows. Application of other rules. Except in respect of matters for which provision is made in these rules, the Mysore Civil Services Rules, the Mysore Government Servants Conduct Rules, the Mysore Government Servant Probation Rules, Mysore Government Servants Seniority Rules, Mysore Government Servants Medical Attendance Rules, the Mysore Civil Services Classification Control Rules for the time being in force, and all other rules and orders regulating the conditions of service of the officers of the state in civil services made from time to time under the proviso to Article 309 of the Constitution shall be applicable to the district judges appointed by direct recruitment under these rules. Similarly, the Karnataka Judicial Service Recruitment Rules 1983 provides that subject to Articles 233, 234 and 2 of the Constitution, provisions of rules so and so of the Karnataka General Civil Services General Recruitment Rules shall, insofar as they are not inconsistent with these rules, mutatis mutandis, apply to the recruitment of district judges, civil judges and munsifs. The Karnataka Judicial Service Recruitment Rules 2004, notified on 9/9/2005, also provided at Rule 11 as follows. Subject to Articles 233, 234 and 235 of the Constitution, provisions of the Rules 5, 6, 2, 6, 3, 8, 9 and 10 to 13 of the Karnataka Civil Services General Recruitment shall, insofar as they are not inconsistent with the rules, mutatis mutandis apply to the recruitment of district judges, civil judges senior division and civil judges junior division under these rules. All rules regulating the conditions of service of the members of the state made from time to time under any law for the proviso to Article 309 subject to Articles 233, 234 and 235 be applicable to the civil judges senior division, civil judges junior division, district judges. The amendment notified on 11/7/2011, here my lords may note, be effective from 1/1/2011. The amended quota has provided 65% in Rule 4 of the Karnataka Judicial Services Recruitment Rule 2004. Amendment in the entries relating to category of district judges, serial number 1, for the figures of words 50% of the total post, 65% of the total post shall be deemed to have been substituted with effect from 1/1/2011. Rest of the extraction is not relevant. Straight away we can go to para 46. It is therefore clear that the rules relating to reservation and appointments are made applicable to recruitments from the Karnataka Judicial Services as well. However, since these specific rules which are made applicable are specified in the judicial service themselves, the reliance on the rules which are specifically not applicable, the circulars and the government orders rendered on the basis of those rules
which provided for applying the quota against the rising vacancies are not applicable to the appointment of post of district judges. It is clear that such appointment is primarily governed by Articles 223, 233, 234, and 235 of the Constitution of India, and the judicial service recruitment which are in force at the relevant time. It is pertinent to note here that some of the recruitment rules governing fixation of seniority provide for fixation of cadre strength by the governor or the government specifically. However, this also is not the case in the instant rules, since there is no such provision that the cadre strength has to be fixed by the government. Therefore, the decision of the apex court in the case of High Court of Judicature Rajasthan versus Veena Verma reported in would also not be applicable to the facts of this case, since the Rajasthan rule specifically provided power in the government from time to time in consultation with the High Court to vary the cadre strength in judicial posts. In the absence of such a provision in the rules that are under consideration in the incident case, it was open to the High Court to fix the cadre strength on the basis of the notifications issued by the government. That is, creation of post is done by the governor in consultation with the High Court, and they issue the notification. The finding recorded by the learned judge is that once that is done, it is for the High Court to declare or determine the cadre strength. Further, it is also clear that recruitment rules do not specify the fixed numerical cadre strength for the post of district judges. Therefore, the cadre strength would include all those sanctioned posts in the cadre of district judges and all the posts which are to be are manned by officers in the cadre of district judges. Wherever that post is, if the rule says it has to be occupied by a district judge, then it is included in the cadre strength is the finding. The contention that there has to be a specific notification by the state government declaring the strength of the cadre of district judges cannot be accepted, since the High Court on the administrative side has calculated the number of posts available in the cadre of district judges, taking note of the notifications issued by the government, and has enumerated and stated that the cadre strength is 314 at the relevant time. The rule in question specifically provides for applying the ratio to the total post, which denotes the cadre strength. Further, the rules also provide that if the posts available through limited filling up by assessment of merit through LDCE are not filled up, the same shall be filled by promotion. A perusal of Annexure N dated 16/3/2022 would show that there is a Annexure N is the final seniority list that was questioned. Would show that the list starts at serial number 38 and takes into account all persons who have entered service since 7/3/83 and who have been promoted as district judges with effect from 26/5/2003. The appellants contend that the seniority of the officers at serial numbers 38 and 39 is fixed by referring it from the date of appointment of fast-track judges, since there were vacancies available in the quota for promotion as applied in the substantive post on the date they were appointed as fast-track judges. Further, the seniority of officers at serial number 40 to 105 is fixed on different dates, and it is stated in the list that their seniority is reckoned from the date they were appointed to the substantial vacancies under the quota mentioned in the 1983 rules, and not from the date of the notification appointing them as fast-track judges. It is true that seniority list shows only the dates from which their seniority has been reckoned, and not the specific posts or vacancies against which they have been adjusted. However, with regard to the officers serial number 40 to 105, they were appointed and their promotions were adjusted till 1/1/2008, and the writ petitioners who had entered service only on 1/2/2016 can have no complaint with regard to the same. This is on the principle, my lords, direct recruit will get seniority only from the date of his entry. And the date of adjustment of the promotees against the substantial vacancies is much anterior to. That is 8 years anterior to the date of entry of the direct recruits. The same is true of those officers who have been appointed before the dates on which private respondents in the writ petition have been appointed. The contention that some of the promotees were promoted and posted as fast-track judges only because there were no vacancies in the regular court cadre to accommodate them also cannot be accepted. Respondent number 3 has specifically stated that they were appointed and posted to the fast-track courts because the fast-track courts had to be set up and their services were required. The only point on which a challenge can be raised by the directly recruited district judges with regard to the promotees exceeding their quota. In case there are no such promotions in excess of the quota applied as against the cadre strength, the direct recruits would have no claim as against the promotee district judges. In the instant case, a perusal of Annexure N, final seniority would show that the seniority of the promotee district judges was fixed by reckoning their seniority from the date when they were appointed to substantive vacancies and not from the date of their appointment as fast-track judges. It is pertinent to note that specific dates on which the private respondents in the writ petition have been appointed are stated in Annexure N seniority list. It is worth mentioning that apart from stating that the promotees are in excess of the quota fixed against the cadre strength, the writ petitioners do not have a consistent case as to how many of these promotee officers are in excess of the quota as applied to cadre strength. Further, the contention appears to be that several of the posts which are included by the High Court in the cadre strength are not posts which are permanent in nature, and that therefore those posts should not have been included in the cadre strength. The details of the posts which have been included in the cadre strength having been made available, there is a further contention raised that cadre strength should be declared separately and systematically. Specifically, it is not possible to accept these contentions. Once it is accepted that the posts of district judges have been created or that posts have been created which are as a matter of fact being manned by district judges, then the contention that specific notification of cadre strength have not been effected cannot stand in the way of promotions being made to the quota as applied against the cadre strength. It is only if the petitioners can specifically point out that the promoted district judges are occupying posts which are meant to be filled up by direct recruitment, they could have succeeded in the writ petition filed by them. Further, these rules as well as the orders of the Apex Court has clearly provided that where necessary, candidates are not available for filling up by LDCE, the said vacancies have also to be filled up by promotion. The objections raised by the writ petitioners in the representation filed by them to Annexure X was specifically that officers from serial number 288 to 329 and 355 to 372 are promoted in excess of the available vacancies and 65% quota earmarked for promotees and are required to be given seniority from the date on which the vacancy arises with the 65% promotional quota as prescribed with the rules. It is a specific case of the respondent number 3 that the date of assigning seniority to promotee district judges is not reckoned on the basis of ad hoc appointments given to them in fast-track courts, but with regard to the date of occurrence of vacancies within their quota. Further, the party respondents whose seniority was specifically under challenge in the writ petition had not been put on notice by the then single judge, nor were their contentions considered before the seniority list was set aside. Having considered the contentions advanced on all sides and having given anxious consideration to the earlier judgments of this court and the authorities relied on, it is clear that the finding of the then single judge at paragraph 33 and 34 of the order under appeal requires interference. In the absence of substantiation of the contentions raised by the writ petitions, the writ petition could not have been allowed. Writ appeal is allowed, the order of single judge, and the writ petition stands dismissed. Then now the contrary view. Contrary view, para 58. Para 59 onwards. Since her ladyship has already in detail dealt with the facts of the case, it is not necessary to reiterate the same to avoid repetition of facts. Nonetheless, I am in agreement with the view taken by that in respect to the question that a challenge can be against the seniority list can be raised by the direct recruits, and also in respect to the question that promoted district judges are entitled to seniority only from a date on which there are substantial vacancies available within their quota and not the dates on which ad hoc appointments have been granted as ad hoc track. Thus, the divergent opinion is only with regard to cadre strength and the consequential promotion in the post of district judges as on 1/2/2016, as also the final seniority list dated 16/3/2022. These are the 2 points of difference. The undisputed facts forthcoming from the material record are that on 14/9/2012, the High Court published the final seniority list in the cadre of district judges. In the said seniority list, 82 senior civil judges were promoted on ad hoc basis as district judges to man the fast-track courts
wider notifications dated and later on substantially appointed as district judges on 1/6/2029/7 were shown above the direct routes appointed on 25/2/2008. The direct routes challenging the said final seniority list dated 14/9/2002, 12 and so and so. The said judgment were allowed by learned single judge, holding that the direct courts of 2008 should be placed above the fast track court judges by considering the date on which they were appointed as district judges on substantive basis on 1/6/2009 and 29/7. The High Court preferred writ appeal before the coordinate bench of this court, apart from other appeals preferred by the promotees who had earlier worked as fast track court judges. On 3/4/2014, the coordinate bench of this court allowed the said appeal by holding that the seniority of such fast track court judges shall be reckoned from the date of their actual promotion if vacancies exist within the quota earmarked for promotees under the recruitment rules as on the date that day, and if not, from such a date on which the vacancy arises within such quota. It is further held that the seniority of direct recruits would be reckoned from the date of their appointment. In compliance with the directions issued by the coordinate bench, a provisional seniority list was published in the cadre on 24/7. It is pertinent to assume that date neither the rich petitioners nor respondents were born in the cadre of district judges. Respondent 13 to 49 were promoted as from cadre C on 1/4/2015. On 8/6/2015, here was one omission which perhaps has led to the confusion in the minds of the honorable judge is that respondents 13 to 49 were promoted as district judges from the cadre of senior civil judges. That is not fully correct. They were promoted from the cadre of ad hoc district judges and senior civil judges. If that had been noticed, then what should have been clear that from the date of their ad hoc promotion, they have not been considered. They have been considered only from the date of their regular promotion. On 8/6/2015, 5 district judges were appointed by way of direct recruitment pursuant to the recruitment notification issued during the year 2012. Subsequently, respondents 50 to 82 were promoted as district judges from the cadre of senior civil judges on 21/8. Later, the petitioner along with 4 others were appointed as district judges on 1/2/2016 pursuant to the selection process held under notification date so and so. Further, respondents 4 to 12 subsequently deleted during the pendency of the writ petition were promoted as district judges from the cadre of senior civil judges on 30th May 2016. Based on the aforesaid provisional list dated 24/7/2014, the High Court published a finals in which the names of subsequently appointed district judges were also included. However, the writ petitions were placed below respondents 13 to 82 as well as respondents 4 to 12. Aggrieved by the same, after making representations, writ petition number so and so came to be filed by the petitioners challenging the final seniority list. Now, here, in the previous paragraph, the judge holds respondents 4 to 12 were deleted. Again, he comes back to the deleted non-party respondents 4 to 12. It is not a case where principles governing the seniority are challenged. The specific prayer in the writ petition is show us above these respondents. They want to push down these respondents. Therefore, every one of them is a party. They were made parties. Then 4 to 12 were deleted. Again, he goes back to 4 to 12. Agreed by the same, after making representations, writ petitions number 4046 came to be filed by the petitioners challenging the final seniority. During the pendency of the writ petition, by considering the representations made by the petitioners and several other issues, both direct recruits and promotees, the then Honorable Chief Justice constituted a committee consisting of 3 honorable judges. The said committee extended the opportunity of personal hearing to all aggrieved persons. Actually, there is no malefides attached, attributed. It is not the case that the High Court wanted to help particular promotee or group of promotees because they were dear to them. No such allegation is there. Natural justice, it is a finding of fact recorded that during the pendency, by considering the representations, the then Honorable Chief Justice constituted a committee consisting of honorable judges. The said committee extended opportunity of personal hearing to all aggrieved persons, including the petitioners. In fact, they have placed on record a representation they made to the committee even during the personal hearing. The full court of this court, while accepting the said report of the committee, resolved to withdraw the final seniority list and directed publication of fresh seniority list. Pursuant thereof, the High Court published a provisional say on 30th September 2021, calling objections from all concerned. After considering the objections filed by the petitioners and other aggrieved judicial officers, final seniority list came to be published. In the final seniority list, the petitioners appointed on 1/2/2016 and assigned rankings 373 to 80 and were placed above the respondents 4 to 12, promoted on 30th May 2016 and assigned rankings at serial numbers 381 to 390, but below the respondents 13 to 49, who are deemed to have been who are promoted or deemed to be promoted on deemed is wrong, because the order of promotion itself is issued that they are promoted with immediate effect, and that is dated, I think, the 31 that that is dated 30th March 2015. It is not that subsequently, after long years, their order was issued saying that you have been deemed to promoted from your date of birth. No, it is not like that. Promoted with on 1/4 and assigned rankings 50 to 82. Hence, the prayer in the pending was amended, seeking prayer to quash the final seniority list. Then, my lords, the learned single judge has proceeded to quash the final seniority list on the ground that the senior civil judges promoted on ad hoc basis as fast during the year were entitled to count their seniority only from the date on which they were appointed as district judges, that is on 1/6/2009 and 29/7/2009. It is further held by the learned judge that promotions were given in excess of 65% of promotional quota under the recruitment rule as against the substantive post of district judges in respect of increase in cadre strength. Here, I'll pause for a minute and say, vacancies arise even if there is no increase in cadre strength because of the retirement or elevation of somebody as a judge of this court, or voluntary retirement, resignation. All these are called as wastages. In one single word used, they are not waste. They normally retire. If somebody is dismissed, then I can appreciate that word wastage.
Only prospective.
But the service jurisprudence uses the word wastage, clubbing all these together. Therefore, it is not only the additions, but exits. I would use a more respectful word. Exits also create a vacancy. And when the quota is linked to the total number of posts, replacement theory will apply. If a direct recruit retires, that post should be filled up by a direct recruitment only. If a promotee retires, that post should be filled up by promotion only. Therefore, in addition to the retirements, vacancies in promotional quota, or for that matter in direct recruitment quota, also arise because of the exits, planned or unplanned, glorious or inglorious. The reason for exit is irrelevant, but every exit causes a vacancy in that stream of appointment. This appears to have been lost sight of in this particular case. And our High Court has said, even long anterior to this, R.K. Subbarwal came in the year 1995, to be precise, 10th February or 13th February 1995. In 1981 itself, Division Bench of our High Court has said, where the quota is linked to number of posts in the cadre, replacement theory would apply. That is the position. That increase in cadre strength, that is a misnomer. It is not only because of increase in cadre strength, it is because of the exits also. That has been, on these two grounds, the writ petition filed by the writ petitioners was allowed by quashing the final seniority list of direct district judges with a direction to the High Court to redo the seniority list. In terms of the Karnataka Judicial Service recruitment rules, the posts of district judges are to be filled in the quota of 2/3 by promotion from the cadre of senior civil judges and 1/3 through direct recruitment. This is a misnomer, misreading of the 1983 rules. 1983 rules, I pointed out the other day that it does not provide any definite quota. And there are two judgments, one of the Supreme Court going from Tamil Nadu, and another a judgment of our High Court, though of a learned single judge. After noticing the language of the 1983 rules, it said that there is no quota at all for the direct recruits under 1983 rules. Thereafter, as per the Karnataka Judicial Service Recruitment Rules 2004, the said quota should revise to 50% by promotion from the cadre of senior judges, 25% through limited and 5 years qualifying, 25%, etc. Subsequently, in terms of the directions issued by the Supreme Court in this, the said quota should revise. This is there is a jumbling. Even 2000 rules were made pursuant to the judgment of the Supreme Court in Alienation judge's case. The said quota should revise, etc. It is well settled that when appointments are made to any post from more than one source, it is permissible to fix the ratio of the recruitment for the different sources, and if rules are framed in this regard, they must be followed and implemented strictly. The quota prescribed under the relevant rules for different method size is sacrosanct and cannot be breached. The preliminary objection raised by the Senior Counsel appearing for the High Court and promote is that in the absence of promotion orders of respondents for 13 to 82 being challenged, the petitioner cannot claim seniority over them is without any substance. The further contention that the petitioners do not have locus standi to challenge the promotions given to respondents 13 to 18 as both were appointed in different modes of recruitment prescribed under the recruitment rules to the post of district judges is also untenable. The coordinate bench has reiterated position of that when promotion is made outside the quota, that part taken, because I agree that proposition that if I am pushed down in the seniority list because of other source getting excess promotions, I am entitled to challenge their seniority, and it is not necessary to challenge. In fact, in Godal Bhima Park, Supreme Court has gone to the extent of saying that this is only a seniority dispute and the promotion is not under challenge. And on that basis, it decided its seniority question. Para 16(9), this is where from the difference accentuates. In Sri S.S. Naganand, learned Senior Counsel appearing for the High Court has also contended that Karnataka government seniority rules, which is applicable to government servants, do not apply to the district judges in view of Article 233 and 234. It is to be noted that 233 of the Constitution provides that appointments of persons to be at the posting and promotion of district judges in any state shall be made by the governor of the state in consultation with the High Court, exercising jurisdiction in relation to such state. Further, Article 234 of the Constitution of India relates to appointment of persons other than district judges to the judicial service. But Rule 3.2 of the Karnataka Judicial Services, as well as Rule 11.2 of the Karnataka Rule, provide that all ruling, etc., that I have read out, it is the same as found in the other judgment. Subject to Articles 2, there is nothing mentioned in 233 to the India with regard to method of determining the seniority of district judges. If nothing is mentioned, length of service is the golden rule. That is this is the phrase used by the Supreme Court in one judgment. That is, in the absence of rules, golden rule is length of service. One addition that is made is where there is a quota rule, it should be within the quota. These are the only two principles. Thus, in the absence of rules framed by the High Court governing seniority of district judges, in furtherance of 233, the right with its rule-making power, corresponding rules applicable to the members of the state civil services would apply. There cannot be any dispute with this because the recruitment rule itself says seniority rules 1957 would apply. Of course, they have used the phrase mutatis mutandis. Mutatis mutandis is with appropriate changes. Change is where it is rules say something about applicable only to the vacancy based quota, it cannot be applied as it is to the post based quota. Further, coordinated bench in writ appeal number has already held that the Karnataka government servant is applicable in the state of Karnataka and has considered the provisions contained in the said rules. Therefore, it cannot be said that the Karnataka government service seniority rules are not applicable for determining seniority in the state of in view of absence of any specific rules promulgated by the High Court in this regard. The question of rankings assigned to the fast track judges is concerned. The learned senior counsel for the High Court contend the same has already been determined by writ appeal number 4, and the petitioners cannot be permitted to re-agitate this issue. The learned senior single judge has mainly relied on Dinesh Kumar Gupta versus State of Rajasthan and others, and Yamini Singh versus High Court of Andhra Pradesh in support of his finding in this regard. Here I pause for a moment and say, both these judgments, C. Yamini pertain to Andhra Pradesh and Dinesh Kumar Gupta, both of them pertain to fast track judges senior and not the persons who are regularly promoted as district judges. The Honorable Supreme Court, in the case of Dinesh Kumar Gupta, whether the judicial officers promoted on ad hoc basis as additional district and session judges to man the fast track courts in the state and who are substantially appointed the district judge are entitled to seniority from their initial ad hoc promotion. Here, my lords, in this case, wherever ad hoc appointments had been made to man the fast track courts, they have been assigned seniority only from the date when substantive vacancy arose in the cadre of district judges. Now, let us analyze this finding. Suppose, my lords, today Mr. A is sent, promoting him ad hoc to a fast track court. There has to be some continuity there. Today he is sent, after 3 months regular vacancy arises in the permanent or normal cadre of district judges. He will be entitled to count his seniority from that date on which the substantial vacancy arises in his cadre. You cannot say that, no, he is continuing still in fast track court. Therefore, you have not withdrawn him from the fast track court. Therefore, he will not get seniority until he comes back to the city civil court. That cannot be the law. The question is not where I am. The point is whether substantive vacancy has arisen in my mother cadre or parent cadre. Because I have to respect both the parents, not only the mother. Though mother is more respected because for obvious reasons. The moment vacancy arises in permanent cadre, wherever I am, my seniority counts. Whether the judicial office is promoted on ad hoc basis, the additional decision is to man the fast track courts in the states and who are substantially appointed to the cadre are entitled to seniority from the date of their ad hoc promotion. That question would not arise here because they have been given from the date of. As regards question 40.1a, the law on the point is well settled, and though the learned counsel advanced submission based on various decisions of this court and principles emanating therefrom, the following decisions in the context of ad hoc appointments as additional judges to man fast track courts in the country are sufficient to address the issue. Entire discussion 41.1 up to page 129. It is all on fast track judges. It is to be noted that review petitions and miscellaneous applications filed in the aforesaid case were also dismissed by the Honorable Supreme Court. Further, Supreme Court in the case of Yamini, this is again fast track court. The question which has been raised in the instant petition or the instance of the petition has been examined by this court in C. Yamini, wherein the 3-judge bench of this court have examined the nature of their
appointment of the district and sessions fast track on ad hoc basis under 2001 rules and later appointed by order on regular basis and becoming members under 2007 rules held that the petitioners are entitled to claim benefit of seniority from the date of their initial appointment as district judges, fast track and other consequential, at the same time limited benefit of service, etc. Since the service rendered, para 9, that is extra, fast track this is. It is thus noticed that para 74 onwards, application of that law by the learned judge. It is that noticed that the Honorable Supreme Court in the case of Dinesh Kumar has framed a specific issue at para 40.1a, and it is held that judicial officers promoted on ad hoc basis by additional district and session judges to man the fast track courts in the state and who are substantially appointed to are not entitled to count their seniority. It is that concluded that by the Supreme Court that the reckonable date has to be only the date when substantial appointment is made. The Honorable Supreme Court in the case of Yamini has categorically held that the service rendered by fast track judges cannot be considered as a regular judicial service. Next paragraph. Thus, the law is no longer restricting with regard to this issue. Fast track judges can be assigned seniority only from the date on which they are substantially appointed as district judges and not from any anterior date from the date of their ad hoc promotion as fast track judges or otherwise. The service rendered as fast cannot be considered as a judicial service for the purpose of Article 2172A of the Constitution of India. That has no application at all in my case because none of us were appointed. It is not the case that any of the appellant's service has been counted as a district judge from the date of their ad hoc appointment. There is in the writ petition even there is nothing to say that I was appointed on as ad hoc judge on such and such a day. I was regularly promoted and said there is no such date. However, it is true the petitioners can be permitted to raise such a ground in view of the earlier decision as conducted. I have no hesitation to say Article 141 law laid down will prevail. The contention of the petitioner that when final seniority of district judges, the High Court was bound to follow the law laid down with the honours prevailing as on that day, and that an earlier division bench decision cannot be relied upon to the extent is contrary to the ratio laid down. I agree with this if there is any divergence between the earlier division bench and the subsequent Supreme Court judgment. Absolutely, there is no difference between the two. In fact, even our earlier division bench has said in conclusion, that is ILR 2014, I'll point out after reading this judgment, there also the direction is count their service from the date vacancy arises in the parent category. This paragraph misapplying an inapplicable judgment and saying that subsequent Supreme Court judgment would prevail without appreciating the facts of the case is, I humbly submit, my lords, is indefensible. It is well settled law. Then about law of precedents is discussed in para 79. Then, my lords, last sentence, last two sentences at page 133. The determination with regard to fast track court judges pursuant to the decision rendered in coordinate bench has never become final. The final seniority list published by the High Court was withdrawn based on the report of the committee, and thereafter the final seniority list was published. It cannot therefore be said that the issue relating to assignment of seniority is settled or has become final. As discussed above, all fast track court judges have retired from service long back, and they would not be affected in any manner if their rankings in the seniority list are revised in consonance with the law declared by the Honorable Supreme. They would always be entitled to count their service for the purpose of protection of them. It is the duty of this court, which is also to give effect to law in any manner, was published. Thus, in the peculiar file, I am of the opinion that traffic should be assigned seniority as per the law declared by the Honorable is not done. None of them are parties here. None of them. My seniority is questioned, and reason taken is my predecessor seniority has been wrongly determined without making my predecessor a party. This is not natural justice. Notice there are two types of challenges in a seniority list. One is questioning the seniority list simpliciter without claiming any relief against any particular person. In such case, making affected parties in a representative capacity would suffice. But when you are claiming seniority against A, against B, against C, against D, A, B, C and D, all of them become necessary parties. That is totally ignored. And they say persons who are not before this court, they have retired. Therefore, nothing is going to be affected. Their pensions will be protected. Therefore, I am upsetting their seniority and you suffer the consequences. This is not law, is my responsibility. The learned single judge has rightly relied upon decisions of the Honorable to held that senior civil judges appointed as are only entitled to count their seniority from the date they are substantially appointed. As the said conclusion, learned single judge cannot be said to be bad in law. In view of the aforesaid declaration, 82 seniors who were promoted as ad hoc basis as district judges to man the fast track courts, via a notification dated 15/2/2003, 19/3/2003, 15/11/2003, and 20th March 2004, and substantially appointed as district judges on 1/6/2009 and 29/7/2009, cannot be given seniority prior to the date of their substantial appointment. Neither those seniority lists were challenged, and finding of the learned judge who headed the bench is that they were all adjusted before 1/7/2008. How that finding is wrong, it is not discussed here. Yes, every judge has a right to dissent. Reason should be based on records of the case. And where are the seniority lists? As could be seen from the final seniority list, the fast track judges to 103 cannot be assigned seniority from 26/5/2003 to 1/1/2009, and their seniority will have to be reckoned from the date of their substantive appointment on 1/6/2009, 29/7. In such an event, there will be a cascading effect, and the subsequent promotees within the 65% promotional quota will be further pushed down. On this ground alone, the seniority list is required to be redrawn. It is only when the seniority list is redrawn, one can exactly ascertain if any respondent number 13 to 82 would also be pushed down in the rankings assigned to the seniority list as a consequence. So whether I will be pushed down or not, the learned judge is not clear. One principle of judicial review is, it is for the challenger to make out the case, pointing out 1, 2, 3, 4. These persons could not have been granted seniority list. Therefore, they will go down. Consequently, 5, 6, 7, 8 also will go down. Learned judge says 1/6/2009, 29/7/2009, that is bad. And he is not sure as to what will be the effect of that finding. He says, only when it is redrawn, I will know. But nonetheless, he quashes the seniority list of 2022. Kindly see this. What would I say? On the inadequate data, it is the petitioner who has to be non-suited, because he who comes to the court must prove his case. Here is a case where learned judge holds, I would not know the consequences, but still I will set aside this seniority list. What for? To have one more exercise? The High Court has filed objections before the learned single judge and stated that the final seniority is prepared according to date of entry into service and date of promotion as district judges. The seniority list is silent. Date of promotion of district judges, not as ad hoc judges. There is a lot of difference. If the say of the High Court is, I have given them seniority from the date of their appointment, promotion as ad hoc district judges, fine. Single judge would have a case to, or the High Court will have a case to frown upon. What is it? I have gone by the date of appointment as district judges. What is wrong in that? The seniority list is silent with regard to maintaining the quota of 65% for 20%, 10% by selection. The High Court has also not produced any statement showing the allocation of posts as per the quota for the one, and since annexure P to the producer earlier round of litigation won only up to that date. It is thus clear that the basis for determining seniority of persons recruited under these different is their date of appointment as district judges. What is wrong in that? It is not ad hoc judges. The other contention of Mr. Naganand, the senior counsel for the High Court, is that though there is no promotion made in excess of 65% quota, as on the petitioner, learned single judge has given an enormous finding in para 34. The High Court has furnished the factual details with catering and vacancies available under the 55 promotional quota as on the date the petitioners were appointed.
After everything is done, finally we will look into the details furnished by the High Court, but we would also want the High Court to draw up a chart.
Yes, that
2003.
Very well.
What was the position? What are the changes? 2011. What happened?
Well,
Because there is a difference with respect to the
numbers.
Now, even if you say 314, there's a difference on both sides as to what is the correct number because of the conflict in their understanding of what is cadre.
There is a easier way to get those figures, Manoj. At the undisputed point of time when these promotions were made, or when this direct recruitment was made, after the High Court decides that these people are suitable for fit to be promoted, or these many persons are required to be appointed by direct recruitment. The normal procedure followed is, because of my experience in the last round, I can submit. A letter is written to the government pointing out this is the cadre strength, these are the number who are in the occupying, these are the vacancies, therefore these many people can be promoted, and out of those many who can be vacancies that are available for promotion, the committee 1 or committee 2, whatever it is, AC1 or AC2, they have found the following as fit for promotion, and learned Chief Justice, Honorable Chief Justice has agreed with that. Therefore, we request the government to request the governor to issue the order of appointment. Thereafter, the governor issues the order of promotion or order of direct. Those letters also will give a fair idea of how it was arrived at. Because I am that record should be there, because earlier in the 2014 round before the learned single judge, I appealed for the High Court. Then I had seen those records. Of course, 10 years have passed by and I do not know whether
I have one.
You are entitled to tell that I am entitled to counter. ಅದರಲ್ಲಿ ಮಧ್ಯದಲ್ಲಿ ಹಾಕಿ ನಿಂತಿಲ್ಲ. Battle lines have been drawn.
Lord, I have one submission. The private respondents have not filed their objection, nor contested before the learned single judge. Kindly appreciate this, Lord.
Because
One
much
fact-
water has flowed since then. We
Take
filed
it on.
appeals before the
On
division
question
bench.
of law, my lord, learned but always argue.
Let us see.
On question of facts, my lord, High Court has to, my lord. High Court has to provide.
Are
He
yours-
cannot argue because
Let us see.
they are not contested the petition. In fact,
Too late in the day for that submission, my lords. Our appeals have not been
no, my
held.
lord,
We
objection is not
maintainable.
filed. That is why I am making my submission, my lord.
No, now we are in a process of understanding.
Yes.
So when it comes to whether he is permitted or not, we'll decide later. Now we are only having an open ear to all arguments. So let us get a picture of it. But when it comes to final adjudication,
I do
we will
agree.
take note of the
I
limitations.
do agree. Lord.
If
I
a-
do agree. But if the reply is filed, facts and figures are given to the, before anything the judge. Right? I can understand. It.
I am not.
They have
rely-
not.
I am not
They
relying
are,
on.
they are arguing in vacuum here.
Let us see.
Sorry, I have not referred to any document which has not been filed either by the petitioners themselves.
Now, just he said, my lord, 1/7/2019 and 26/7/2009, the fast track was substantially promoted. That facts and figure are there before the learned single judge and before the bench also. Those facts are not placed before the learned single judge.
No, in so far as the factual aspect, we will visit it later.
But
Now we are only
2003, fast track judges are promoted ad hoc. In 2009, not substantive vacancy, they are promoted. Can they give not earlier to that date?
I said, one of the learned judges has given a finding, they were adjusted before 1/7/2018. Secondly, none of them have been made a party. Thirdly, in deciding the validity of the seniority granted to persons who are non-parties, parties have been made to suffer. This is not natural justice. These are my submissions. I have gone by your own facts pleaded, even on cadre strength consisting of deputation posts. On the last occasion, I pointed out notification of 2001 produced by the petitioners, and even on the cadre strength, I am going by either what they have produced or what the petitioner, High Court has produced. I have not produced a single piece of paper which you people have not produced. And even if I have not filed written statement, I am entitled to cross-examine. Ultimately, if it comes to CPC. And CPC is not allergic to writ proceedings. Because writ proceedings rules themselves say that.
I agree. Question of law is there, he can address. On question of facts, my lord.
Question of law based on facts pleaded.
now in so far as that we'll see at the end, but now we are open to.
My lords,
we are open.
if persons who are not parties in the writ petition and who are subsequent recruits, of course, my lords have said that their implement will be decided later. If they can be heard, now they want to cook their broth in my fire. They have not filed writ petition.
Anyhow, Ms. Rajgopal, we have not prohibited you, so you can continue.
Therefore, my lords, because what happens, these are derailment.
I'm not objecting because
My lord, these are derailment exercises.
On facts, my
I am
lord,
at the fag end of my career and I refuse to be derailed. That much I can confidently say. It is that page 137, first paragraph there, last 4 lines. It is that clear basis for the seniority of the 3 difference is their date of appointment as district judges. There is no finding as to who are the persons who have been given seniority from the date of their ad hoc district judges. The other contention of Sri S.S. Naganand, Learned Senior Counsel for the High Court, is that though there is no promotion made in excess of 65% quota on the date of the Learned Single Judge has given a erroneous finding, para 34. The High Court has furnished the actual factual details of the cadre strength as on the date of petitioners were appointed. It is specifically stated in paragraph 9 of the circular joinder that as on 21, the sanctioned strength of cadre was 304
and 200 posts were earmarked under 65% promotional quota. It is further stated that the working strength of officers was 193 and 11 vacancies still existed under 65% promotional quota. When the learners appearing for the petition disputed this factual position with respect to increase in cadre strength, the registrar of the High Court is called upon to furnish the details along with relevant notifications by which there was increase in cadre strength of district judges. The High Court has filed a memo dated 8/9 by providing the details in regard to how the petitioners have filed objections to said memo, contending that 32 posts mentioned by the High Court cannot be considered as part of the cadre strength of the district judge. The specific difference point of it is 32 posts. High Court's cases, this is factually incorrect. What we have given is correct. I also subscribe to that view. But without conceding that 32 is correct, my respectful submission would be, even if that 32 is correct, my promotion would still be within the quota. What has happened is, I'll point out at this stage, the in-service candidates, they will get quota of 10% or 25% or whatever it is, only in respect of additions to the cadre strength after 9/9/2005. If that is the case, they will get either 14 posts or 19 posts, as against which 43 persons have been appointed. 43 persons have been appointed under in-service quota. They could not have been appointed. I will refer to the figures they have given and I will point out that. This may kindly be borne in mind. 32 is the difference according to them. 32, if that is the difference, 65%, 50% of it or 65%, it comes to 16. If 16 promotional posts will go or 18 promotional posts will go, even if that is the case, that is the case made out before the learned single judge, without disputing those figures, I would still be within the quota because excess recruitment has been made not under the promotional channel, but under the in-service quota LDCE channel. And no LDCE district judge has been made a party in this. No challenge to ranking assigned to LDCE judges. This is fairly covered by question framed and answered in the Honorable High Court of Punjab and Haryana versus State of Punjab. Therefore, my respectful submission would be, take that 32 as correct, purely for the sake of argument. Even then, examine the question whether seniority list could have been set aside. After reading this judgment, I'll directly take my lords to the concerned judgment. 32 is the figure, ultimately disputed figure. The notification dated, carry 87 notes. The notification dated 15/2/2002 relates to a court created for the purpose of conducting a trial of a case relating to Dandupalya, Krishna gang. Another notification in 15/2 relates to court created for the purpose of conducting trial of a case relating to fake stamp paper scam. As per both these notification, condition number 1 stipulated that post was created only for a period of 1 year and prior approval was mandatory for continuation of the said court.
Let me pause here, my lords, for a moment. It is not the case that the trial of Dandapalya ended in 1 year. It is not the case that fake stamp paper case ended in 1 year. It went on, at least for several years. Can we wish away the existence of those courts? Because there is a judgment of the Supreme Court which says that as long as it is only the readjustment of the post created, there is no requirement of any further sanction. And as I already pointed out, Civil Codes Act does not require any notification extending the tenure. Condition number 5 also said no new recruitment could be done for the said court. Further, notification at 2712 relates to court created for conducting trial of case involving late Kumari Jayalalitha. These 3 courts were temporarily created only for the purpose of conducting trial in specific and upon conclusion the court would stand abolished. Here notice what is meant by a temporary vacancy, which will have to be excluded. That also has been dealt with by the Supreme Court, where it said, unless it is of a very short duration, it cannot be treated as a temporary vacancy. Now, my lords, there is a provision even in the KCSRs. There are cases where the doctors are sent for higher studies in service. Sometimes the course lasts for 5 years, anywhere between 3 to 5 years. The provision in law is that during that period when he is on higher service, higher education, this one, he retains a lien. But still, if the absence is likely to take more than 3 years, a regular promotion can be made in his place. Only thing is, the test is whether it is purely temporary or of an adventitious nature or accidental. Now, Jayalalitha Special Court was established. Then who is that stamp paper? Property tagondu abhyasa ella mari abhyasa ella. How can I know about Telugu? I have not. You can see my record. Ask my learned friend, he will get all the registration details. Okay. Telugu case. It was not over in 6 months or less than 1 year. Then, my lords, the special courts are created for a specific purpose. 1 year is the outer. If it is less than 1 year, you can treat it as a transient vacancy. Now, suppose a person is sent to try Telugu for 5 years. Can the judiciary function? It is only temporary, therefore I will not promote anybody as district judge. Can the remaining courts function? There is nothing called as ad hoc functioning of a district judge, except in case of fast track courts, which are of a special nature. And these are all part of regular judicial service in a special court. Even otherwise, the trial in all these 3 cases have been conducted several years. There is no notification for continuing such courts thereafter. Thus, these 3 courts cannot be considered as increase in cadre strength of district judges. The office order dated 23 to Administrative Additional Registrar Admin, Supreme Court of India, would indicate that
One NS Kulkarni, additional disciplinary clause, is deputed as member judicial of the E committee. A sanctioned post in E committee cannot be considered as part of the district greater strength of district judges. These matters, to use the mildest word, outrageous. Supreme Court E committee one post is created of district judge from our state. Because Supreme Court was created as a part of its cadre strength, even though it is required to be filled up by deputation, it cannot be treated as a part of the cadre strength of the district. Where does the learned judge get this idea in service jurisprudence? It is like telling
Yes. Yes.
then the state government has not notified the said post to be part of cadre strength of district judges. The said post is in another establishment. All deputation posts will be in other establishment only. Unless you say no district judge can be deputed anywhere else. The said post is it cannot become comprehended as to how this post is included as part of the cadre strength of district judges. This post also cannot be considered to be part. Next, it is claimed that as per the notification date 3110, there was increase in cadre strength of 1. The note appended on page 4 of the memo would show that the post was considered a part of cadre as on 1/8, as a judicial officer was posted in the said post for first time. However, reading of the notification reveals that it relates to amendment of the High Court of Karnataka rules, whereby the nomenclature additional registrars is substituted. This notification does not relate to creation of a post in the cadre of strength of judges. A post created in the High Court, because there is no notification, it is no post. My lords are aware, at one point of time, registrar administration, or those days I don't remember whether it was registrar administration. A non-district judge was being appointed. It changed. Subsequently, number of registrars increased. All of them are filled only by the district judges. No, you have not issued any notification, therefore I can. There is a saying, sorry, I have to use Kannada because that is the only language I am affluent with. Angayaliro Kannadiಗೆ Kannadi ಯಾಕೆ ಅಂತ. A sore in the palm, you don't need a mirror to look at it. You are seeing those registrars every day. But you say that they are non-existent, they are not existent, they are non-existent because government has not issued a notification. It is like chasing the shadow, ignoring the substance. This again brings me back to the theory of common sense, whether it is enemy of court sense. That reading of the notification reveals that it relates to amendment to the High Court of Karnataka Service Conditions of Service and Recruitment Rules 1973, whereby nomenclature of additional registrar is substituted by registrar judicial, registrar admin. This notification does not relate to creation of post or increase in the cadre of district judges. Even though those notifications say to be filled up by a district registrar, district judge, even then it doesn't increase the cadre strength. In the High Court, creation of any additional post, insofar as it requires financial outlay, it is sanctioned by the government. But says, no, it should be in a particular format. Forum takes
precedence over substance. What we are told in jurisprudence is, it is the substance which matters and not the form. What is decided here is, it is the form that matters and not the substance. Even otherwise, as per the method of recruitment prescribed under the recruitment rules for said posts, they can be filled by promotion from the post of deputy registrar or filled by posting a person who has been a district judge. Even though it says it shall be filled by district judge, it is not, because an alternate method also is provided. Though the post is validly created on the establishment of the High Court, the said post need not be mandatorily filled up by serving district judge. There is also no notification issued by the state government with concurrence of finance department for making this post as part of the cadre strength of district judges. That this post also cannot be considered to have been made part of the cadre of district judges. The net judge agrees in all other cases financial clearance is there by this one. The notification relates to 6 posts of chairman of permanent Lok Adalat. One is section 22B of the Local Legal Services Act provides for the establishment of permanent Lok Adalats. 22B provides that post of chairman can be filled by a person who is or has been a district judge or has held an office higher than the rank. Merely because a district judge can be deputed to the third post, these 6 posts cannot be considered in the cadre strength of district judge. This is how the differences are arrived at. Merely because now, my lords, in every one of these cases, my lords may kindly take, look at the cadre rules. I'll just point out here in these cadre rules, my lords may kindly have a look at page 165. Good. 165, 161 and 165.
Look at the manual.
I go to the irutte, the immediate tag, whether same edition is there or ಅದರಲ್ಲಿ cadre rules ಇಲ್ಲ. I know, my lords, that in small book it may not be there, therefore I passed on. I'll have a xerox of it done. cadre strength ಇದೆ ಗೊತ್ತಿಲ್ಲ. ಕೊಡಿ, ಇದರಲ್ಲಿ cadre strength ಇದೆಯಾ ಅಂತ ನೋಡ್ಬಿಟ್ಟು ಕೊಡ್ತೀನಿ. ಎಲ್ಲಿದೆ ರೀ? Yes, that 76 first schedule is there. Assistant. ಅದು 161 is the cadre strength, my lords. 165 is the method of filling up. Police wing ಇದೆ. Technical wing ಇದೆ. Enquiry, first schedule, administration enquiry wing, registrar 1, additional registrar 6. Method of deputation, method of 79 is the cadre strength, my lords. 77 is 76 is cadre strength. 70, yes, 79 by deputation of an office. And it is said that it cannot be taken into account. There is a deputation reserve we have to hold. equivalent to the deputation posts created in the establishments to whom we are to depute. To say that these do not form cadre strength, it is some words better are not uttered. Silence is golden. And these are all pregnant gaps. Then words about the permanent Lok Adalat. Then para 91. The notification relates to each post of additional registrars of this court at Dharwar and Kalburgi. Notification dated so and so relating to 3 posts of registrar recruitment infrastructure statistics review. There is 2 posts. The method of recruitment in respect of this is not exclusively from the cadre of district judges. Doesn't dispute the deputation of district judges is a method of recruitment. The said post can be filled by promotion of the cadre of or by posting a person who has been a district judge. Though the posts are validly created on the establishment of the High Court, the said posts need not be mandatorily filled up by a serving district judge. This is like mandating the impossible. One of the methods of recruitment is by deputation. High Court wants to take a deputy registrar on district judge on deputation. But for that purpose, it cannot promote a person as district judge because it is not part of the district judge's cadre. It is all impossible interpretations, incapable of comprehension, and more importantly, incapable of implementation. Today, High Court wants 4 posts to be filled by deputation. High Court recruitment rule made by Chief Justice after consultation with the Governor provides for deputation as a method of recruitment. But learned judge says, no, cadre strength notification has not been issued in the cadre of district judges. So this court is powerless to take them on deputation. This is the then, my lords, it comes to about deputation to DRT. Letter dated issued by the then Registrar General of the High Court is the relieving letter of one C.R. Benakanahalli, District Judge, upon having been appointed as presiding officer. The said post of presiding officer is a selection post at pan-India level, with tenure of appointment at district are never deputed to the said post. Even district judges are considered for appointment. Merely because a judicial officer has resigned from the post of and is joining as a president, the said post cannot be considered to be a part of the cadre strength. There is also no gazette notification issued by the state government. Ultimately, everything turns on absence of notification issued by the state government or deputation not being the sole method of recruitment. I am yet to come across any judicial precedent supporting this reason. Therefore, learned judge also very wisely does not refer to any precedent. Yes, of course, we are entitled to choose, lay our own path, but that path should be in accordance with law. By notification, the Karnataka Secretary has come into force. This is the additional secretary to the state government, law department. The amendment is the post of Secretary to Government Department of Parliament. The method of recruitment promotion from the cadre of additional draftsman and the ex officio additional secretary to government. And only when no eligible officer in this cadre is available, then by deputation of an extra officer of Karnataka. Thus, the rule itself expressly provides that it is a promotional post in the said government department and not meant by only district judges. The said post is in the state government department. This is not, there is a super judgment to the Supreme Court that where a deputation post is there in the state government or elsewhere, High Court has power to depute that district judge and also withdraw him. Of course, the only condition is where a deputation is for a definite period, it has to wait till the conclusion of the definite period, except where both the lending department and the borrowing department agree that it can be cut short. Then what's the administrative tribunal? Here again, the reason is the rules provide for filling up the post by promotion like a deputy registrars, and a judicial officer is temporarily deputed in exigencies of administration. This proceeds on a basis that temporary post cannot be part of the cadre strength. The notification in deputation arbitration center. As far as the said post of director is to be filled up by deputation of the, however, it is further in the government is also authorized filling up the said post of director by appointing. Thus, even the retired judge can be appointed and said post. Then one is about the Lokayukta again, para 96. I pointed out to the Lokayukta this one, para 97. Thus, as detailed above and as rightly condemned in senior counsel, that the said above 22 posts, 32 cannot be created. These are the 32 posts. Even identification of 32 posts is not difficult. The finding rendered by the learned judge is that 32 posts are to be excluded from the cadre strength. Each of those notifications, learned judge analyzes and comes to conclude they are not part of the cadre strength because state government has not issued notification, number one, or there is alternate method of recruitment also. And he comes to conclude that since there is an alternate, you cannot treat him as a district judge cadre. This reasoning, my lords, is the basis for upholding the order of the learned single judge by the second member of the learned judge who has rendered the second opinion. Then, my lords, para 99. The literal meaning of sanctioned post is an official, approved and funded position with an organization, official staffing structure created with formal authorization by a competent authority. The approval includes a financial sanction and specifies a job title, salary and duties for the post. Now, 7 persons are deputed to Lokayukta. Are they not funded by the state? Even if it is not funded by the state, if something is wholly owned or controlled by the state government, a deputation is made. Salary has to be, during the period of deputation, has to be borne by the borrowing authority. Where is the question of state funding come in that? Suppose there is now, for example, this is a medical procurement society or something they have. It is a wholly owned government, state government. Every alternate day they will be issuing a tender. And there are so much of commercial transactions in that. It may request. In these recruitment rules, yes, there may be a deputed. Where is the question of state funding necessary in that? This is wholly contrary to the provisions of foreign service that is contained in the KCSRs. And admitted position is KCSR supply. Then it goes to the definition of temporary period, temporary post, and says that if it is for a limited period, it is a temporary post. Para 101. Admittedly, in the instant case, there are no notifications published in the official gazette
to include the post in the cadre of district judges. Without such an order, it cannot be said that the strength of the service has been increased or the post has been created. Divorce the cadre of service shall be considered as ex-cadre post. Merely because it is temporarily deputed to such post on deputation, the same does not imply that they become posts of district judges. Deputation is always temporary. A deputation is retained his lien in the parent cadre. They can always be filled up by resorting to other methods of provided in recruitment rules governed under more or less in the Honorable Supreme Court in High Court of Rajasthan versus Veena Verma. This is pertaining to FTC. Circumstances are not identical. Another learned judge has held that Veena Verma does not apply. Then about Badami Gonal Bhimappa, then 103. The High Court has claimed that there were 134 sanctioned, 314 sanctioned posts in the cadre of district as on the date of the petitioners and others were appointed on 1/2/2016, and thus there would be 204 posts under 65% promotional quota. It is their further stand in the survey gender that 193 judicial officers promoted under 65% promotional quota were working on that day.
Last sentence, the extract in Veena Verma's case,
Yes, ma'am.
referring to ex-cadre posts.
Yes, ma'am. It is not ex-cadre post. It is called in service jurisprudence as encadred post. Every post outside the parent cadre is not ex-cadre. If in the recruitment rule it is shown as post to be filled by deputation, to that extent it becomes an encadred post. That is how High Court has considered it part of district judges' cadre. There is a difference between ex-cadre and encadred. Encadred means place of work will be geographically outside the district court, but it is a post required to be manned by a district judge. To that extent, it gets encadred into the cadre strength of the district judges. There is a world of difference between ex-cadre and encadred. I refer to submit this difference between encadred and ex-cadre has been totally ignored.
Yes.
Then Manoj, the High Court claimed Badami and Gonal Bhimappa refer. I can even point out that it is not applicable. They just held it is not. The High Court has claimed that there were 314 sanctions for the case as on the date of petitioners and others were appointed. There will be 204 posts under 65% promotional quota. And it is further their stand that is surface under 193 officers promoted who were working on that day. However, if the above 32 posts are excluded from 314 posts, the total cadre, then the cadre strength will be 282 posts. In such an event, there would be 183 posts, 180 posts under 65. Thus, even on the date of appointment of petitioners, 10 promoting officers would be in excess. Ultimately, finding is 10 promoting officers would be in excess. Now kindly take these figures which are taken from the memo filed by the High Court regarding the cadre strength. Appointment cancel. No, my lords. I would recall to my lords that in service LDCA quota was created under the 2004 rules for the first time, which came into force on 9/9/2005. On this, there is unanimity. So I agree. I am not tired. Why are you tired? Tired of hearing me? You my lords take this cadre strength notifications chart that is produced. Page 1, item 8. As on 1/8/2005, cadre strength was 172. No, my lords, next relevant date would be 1/8/2005, 9/9/2005. There was no increase or decrease in cadre strength. Then, my lords, the next relevant date would be item 23. That is 28/10/2010. On that day, cadre strength was 199. Therefore, my lords, the increase in cadre strength from 22/9/2025 to 31/12/2010 would be 27. At that point of time, in-service LDCE quota was 25%. That means 7 posts will go to LDC. Then, my lords, the next relevant date is 21/1/2016 or 1/10/2015 or even 1/8/2015, and even on the date that is according to him 21/1/2016 if it is taken. Now the High Court says it is 314. Learned has said deduct 32 from that. Now if 32 is deducted, it becomes 282. The increase between 1/1/2011 and 21/1/2016 would be 282 minus 199. It will be 53. %10 of this 53
10% of this 53 will be 5. Therefore, total number of posts that could be filled up by in-service direct recruitment would be 7 in the period 22/9/25 to 22/9/2005 to 31/10/12/2010, 7. In the subsequent period, it will be 5. Totally, it would be 12. Now, kindly come to Annexure N. In Annexure N, or Annexure N source is not given. Kindly come to Annexure A, which is the provisional list.
We'll continue. We'll have to wind up. We'll continue. We'll continue.
Very well.
Not this Saturday. I only where in the company. Because Saturday is not working. Friday we start. So we will inform them. He says it can be. Sorry. After we open. I'll do. Judgment to keep in this folder every time it's getting.
We'll have it at 9 in case anything we'll see.
We can see that. Yeah, I can come. That's what I said.
We'll continue on 9th.
9th of January. Only 2 sentences may I say, so that my lords can ruminate over it.
Yes.
So the quota available for LDC candidates was 12. This is based on the judgment of the Supreme Court in Honorable High Court of Punjab and Haryana versus State of Punjab. As against that, 43 persons are shown in the seniority list from that quota. Even if these 32 posts are removed, that is accounted for by excess promotions, excess appointment made under LDC quota, which is not challenged. And no LDC district judge is made a party. On this more I will.
So this, insofar as this factual application,
yes, ma'am.
Since there is some variance, we call upon both sides to file your charts. And then we'll, that makes it easier at the time.
I'll file a chart.
My lord has further examined in view of the notification issued by the state government in the year 2006, 2022. All those notifications are necessary to decide, my lord, what is the catastrophe.
So
I have produced it. I will give it to the.
So charts can be made by all sides, which would benefit us in trying to get an idea of.
Ask the lord, what is the government order? 15 plus 10. Lord, if the government order is there in 2006, all India agency.
I will prepare the charts under quota rule, taking both 314 as correct, taking exclusion of 32 also as correct. Even then, I will safely get the seniority assigned to me.
The arguments of Is Rajgopal remains inconclusive. This proposal hearing 2:30.
Lordships are keeping it on the 9th, my lords?
Ninth.
Grateful.
2:30.
My lord, sir. Court Hall 7, my lord, 66th matter.
Seventh January. Seventh or ninth?
Third set list of citations.
Manjunath Bharadwaj.
ಈಗ ಕೂತ್ಕೊತಾರ? 2 volumes.
ಎರಡು ಸೆಟ್ ಇದ್ದು ಇಲ್ಲಿ. ಉಜ್ಜು.
ನಾನು ರೆಡಿ ಮಾಡಕ್ಕಾಗಲ್ಲ ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಅದು ಅದೇ
ಸರ್ ಅದು ನಮ್ ಸರ್ ಕೋರ್ಟ್ ಆಫ್ ಸರ್
ಉಜ್ಜು. ಇದು ಎರಡು ಸೆಟ್ ಇದೆ.
ಒಂದ್ ಸೆಟ್ ಬೇಕಷ್ಟೇ.
ಅಷ್ಟೇ ತಗೋಬಿಡಿ. ಆಯ್ತಾ? ಆಮೇಲೆ ಇವತ್ತೊಂದು ಕೊಟ್ಟಿದೀವಲ್ಲ, ನಾ ತಗೊಂಡೋಗ್ಬಿಡ್ಲಾ? ಇಲ್ಲೇ ಇದೆ ನೋಡಿ.
ಯಾವ್ದು?
ಅನು ಮೇಡಮ್ ಮತ್ತೆ ರಾಜೇಶ್ ರೈ ಸಾಹೇಬ್ರದ್ದು ಒಂದ್ ಸೆಟ್ ನಾನು ಕೊಟ್ಟೆ, ತಗೊಂಡೋಗ್ಬಿಡ್ಲಾ ಬೇಕಾ?
ಮಾರ್ಕ್ ಮಾಡಿದಾರೆ ನೋಡಿ.
ಅವ್ರು ಓದ್ತಾ ಇದ್ರು.
ಮಾರ್ಕ್ ಮಾಡ್ಬಿಟ್ಟಿದಾರಾ ನೋಡಿ.
ಎಕ್ಸ್ಟ್ರಾ ಒಂದ್ ಸೆಟ್ ಇತ್ತು.
ನಾನು ಮಾರ್ಕ್ ಮಾಡಿದ್ದೇನೆ. ನಾನು ಮಾರ್ಕ್ ಮಾಡಿದ್ದೇನೆ ಕೋರ್ಟ್ ಆಫ್ ಸರ್. ನಾನು ಮಾರ್ಕ್ ಮಾಡಿದ್ದೇನೆ. ಅವರು ಮಾರ್ಕ್ ಮಾಡಿದ್ರು ಬೇಡ ನೋಡಿ, ನೋಡ್ಬಿಡಿ.
ಮಾಡಿರ್ತಾರೆ.
ನಾವು ಒಂದು
ಎಕ್ಸ್ಟ್ರಾ ಕೊಡ್ತೀನಿ ಬಿಡಿ ಬೇಕಾದ್ರೆ.
ನಾವು ತಗೊಳ್ತೇವೆ ಸರ್, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
Court officer.
ಸ್ಕ್ಯಾನ್ ಮಾಡ್ಬೇಕಲ್ಲ, ನಿಮ್ ಸ್ಕ್ಯಾನ್ ಮಾಡಿ ನಿಮ್ಗೆ ಕಳಿಸ್ಬೇಕಲ್ಲ. ರಾಜ್ಗೋಪಾಲ್ ಸಚಿನ್ ಆಫೀಸ್ ಹಾ.
ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಇಟ್ಟಿದ್ದೀರಾ ಇಲ್ಲಿ?
ಬೇಡ ಅಲ್ಲ ಅಷ್ಟು ಸರ್ pronouncement of orders, serial number 82, Meera, party in person,
petitioner
Abhinama Raman,
The review petition is allowed. Order passed in WP 3012 of 2023 is recalled and petition be placed before the regular bench for disposal in accordance with law. In light of the discussion is made above, review petition is at liberty to engage a different counsel in the writ proceedings, and if wakalat is filed, same to be taken on record. IA 1 of 2024 is also allowed.
much obliged.